Good morning. Committee on State Affairs will come to order. Will the clerk call the roll?
Senator Betancourt.
Present.
Senator Hall. Senator Hinojosa.
Present.
Senator Parker. Senator Perry. Senator Shortner.
Present.
Dean Zaffarini. Senator Paxton. Senator Hughes.
Here, quorum is present, and there have been some travel delays which will affect some of the senators arriving, but we're thankful to everyone who's here to participate, and whether you're going to be listening or testifying, or whether you haven't decided yet, that's okay too. You've got a little time for that. We're going to hear invited and public testimony, and so we'll first take up each of our charges. We'll go through the ones for today and hear the invited testimony on each. Then after that, we'll open a public testimony. As you know, if you go to the U.S. Congress and try to testify, unless you were invited, you're not welcome there. But many states do it that way. But in Texas, we like public testimony. We like to hear from the people we work for, whether we agree or disagree, or that's how we do it. And so that'll be toward the end of this hearing, and most of you have done that before. At this point, I will see if any member of the committee wishes to make any opening remarks. It's not required or expected, but we always want to give an opportunity.
Why are you looking at me? Am I the only one awake? I think no. I know Perry got up ahead of me. Mr. Chairman, thank you for having this hearing. Thank you, Lieutenant Governor, for issuing the charges to the committee. I think all of us are interested in what are really three main subsets of state affairs charges. And I think you've collected a good team of people to start the discussion off. So I will get out of the way and let you run the show, which is what I think you're going to do anyway.
Thank you, sir. Thank you, sir. Thank you, each one, for being here and being involved. And so, Lieutenant Governor has assigned this committee interim charges. Most here know how that works. During the time between the sessions, we do our work and do our groundwork and do our research and follow up on what happened the previous session, and also prepare for the next. And so we're going to take up 4 of them in turn today. Monitoring legislation passed this legislature, beginning with our proxy advisory law, and also maintaining the security of our elections, ensuring the efficiency of our elections, and protecting the unborn. And so on monitoring, we'll be looking at Senate Bill 2337, a bill passed last session, which many states have introduced versions of, and the feds have also taken some action on, which we'll be talking about. Lieutenant Governor asked us to monitor how the laws we passed this session are being implemented and to recommend what more may be needed to complete the work. So 2 laws are named in that monitoring charge. The one we'll take up today is Senate Bill 2337. Our monitoring charge on the Lottery Commission will be at a later hearing, of course, and we'll be plenty more time to gather that unfolding story, Senator Hall, as you lead on that. And so it's important. Proxy advisory firms, at the risk of insulting your intelligence, I'll just say something about what they are, because most of us weren't real familiar with them. But if you are an institutional investor, maybe you're a retirement fund, maybe you're the Teacher Retirement System of Texas, or maybe you're a private foundation, or maybe you're just an investor that owns a bunch of stocks. Many times these entities own hundreds or thousands of shares in hundreds or thousands of companies. And of course, those shares that are in Exxon, Walmart, IBM, fill in the blank, each one of those shares entitles you to a vote at the annual meeting of that company. The annual meeting, of course, is where the board is elected, where the company takes policy positions, decides direction they're going to go, and so those votes are really important. And again, if you're an institutional investor with hundreds or thousands of shares, it's hard for you to keep up with each vote and every topic that's going to be brought before the committee. And as a result, over the years, companies called proxy advisory firms have grown up to provide a service. So historically, a proxy advisory firm would research a company and look at all the votes that are going to be taken at the annual meeting, look at the candidates for the board, look at all those decisions, and then make recommendations to the people that own those shares. And historically, they looked at things like corporate hygiene. Is this company following the law? They'd go to the Securities Exchange Commission and look at all the circulars and all the publications and all the notices and all the violations, potentially, and see how the company was doing. And then they would recommend how the owners of that company, the shareholders, should vote. Sadly, in the last few years, those proxy advisory firms have taken a very partisan political edge. And so rather than just making recommendations based on good corporate hygiene? Is this company following the law? Is it managed well? Instead, they're inserting a political agenda. And so Texas has taken the lead on pushing back against that. If you are going to hire someone to advise you, you want to make sure they're telling you the truth and they're disclosing all the information, not cherry picking and not slanting it, and not telling you one thing and another client something else. So that's what Senate Bill 2337 was about. And so the bill has taken effect. There's been litigation. There's been litigation to block the law. It is still in effect except for enforcement by the Attorney General. And we anticipate the courts will eventually do the right thing on that litigation. But for now, there is still litigation going on. And so at the end of the day, this is about Texans' retirement savings that are invested in these companies and the direction they take. And there's a larger discussion about our Texas economy and about whether we're going to let folks go after the energy industry, which provides good-paying jobs, provides low-cost energy. In days like these, aren't we aware that the cost of energy affects everything else? And so much of this agenda is going after energy, going after good jobs, going after good, low cost of living. And we're not going to let that happen. We can't do that. As stewards, we cannot do that. And so Senate Bill 2337 requires honesty. If you're a proxy advisory firm and you're telling people how they should vote on with their shares, you have to tell us if your recommendation rests on something other than financial interest. If it's politics, you have to disclose that. If it's a social issue you care about, you have to disclose that if you're not giving them financial advice, purely financial advice. So two firms cover most of the proxy advisory market, ISS and Glass Lewis. ISS is for Institutional Shareholder Services. They have filed litigation to block this bill, and that's okay. That's what the courthouse is for. We expect to win that case, but we're moving forward in the meantime. And so we invited Institutional Shareholder Services and Glass Lewis to appear and answer for their practices. ISS declined, let us know they're not coming. They sent us a letter. And then we haven't heard back from Glass Lewis, so we have a place prepared for them. We hope they'll show up. We'll see. In addition to inviting ISS and Glass Lewis, we're also going to hear from witnesses who can speak to how these firms operate and what next steps Texas should make. So our panel on this charge includes Terry Shen from ISS, we don't think appearing, Nicole Garzon-Mitchell from Glass Lewis, Chris Babcock, and at this time we'll call Terry Shen, Nicole Garzon-Mitchell. Chair calls Chris Babcock from Foley and Lardner. Chris, go take a seat. Chair calls Brad Hubbard from Gibson Dunn in Dallas. Call James Copland, Manhattan Institute. Call Eric Bledsoe, American Resolve Institute. So we've heard from ISS. We had them a place just in case they change their mind. It looks like most of us are.
Mr. Chairman,
Dean, of course.
what are the time limits for today's hearing?
So for public testimony, of course, we'll be limited to 2 minutes. And for our invited testimony, I believe they're generally limiting their testimony to 5 minutes, of course, subject to questions from you and the other senators.
Thank you.
Thank you, Dean. All right, so I'll ask the clerk if Nicole Garzon-Mitchell from Glass Lewis or anyone from Glass Lewis has registered to testify.
No, sir.
We'll ask the Sergeant at Arms to go in the hall and call their name 3 times.
Mr. Chairman, I do have a comment at this point because I think the audience now understands that we've asked people to come and they have not willingly decided to attend. We've been down this road before. The chairman successfully ran a very important meeting at Marshall, Texas, where this was first debated, or at least in concept. And at the time, ISS as well as 3 other firms actually attended. And it is extraordinarily disappointing that people will not respond, specifically companies that have reason to be summoned to a meeting can only expect that they may be summoned on a permanent basis to come back and explain their absence, or should I say more forceful basis, not permanent. So, Mr. Chairman, I want to thank you for trying to get people to attend because they're at the heart of this matter. speaking as someone familiar with Texas energy policy, I'm appalled that ISS would attempt to use our own funds to vote against our own energy projects. And the fact that they're not willing to come and have that public policy discussion is beyond disappointing to me, Chairman. And you have been a stalwart at trying to get transparency into this process since those Marshall hearings. And I believe that if they do not wish to come at some point, you'll have to decide to compel them. That's up to your decision. I've signed those subpoenas before, and I believe the fact that the other company ghosted you with not even a response, at least ISS put a response in here, and they could have come and testified and basically waived off any questions based on their suit, but they could have testified to the public policy, which they're wrong on. We do not need institutional proxies telling our retirement system or any of our other funds in the state to not invest in Texas energy projects. That's really at the heart of the matter. And that's what taxpayers need to understand, the citizens of the state, and why they were asked to come. And the fact that they're not here speaks volumes to what their position is.
Well, thank you, Senator. At the Marshall hearing, of course, you had a good, helpful exchange with representatives from ISS, as I recall. And so the Sergeant at Arms reports there is no response from Glass Lewis. And so, and Senator, you're right. You know, we, in addition to affecting public policy in Texas and having control of a lot of Texas money, these firms are also hired by various state entities to perform this service. So they're a client as well. So as you know, as you mentioned, the committee does have subpoena power. This committee already authorized those subpoenas during the regular session, which are still in effect until January, and will be conferring with the committee on whether we should invoke subpoena power, and we'll see if we hear from those guys in the meantime. Until then, we're going to be talking about what they're doing, what they're not doing, whether they're following the law, and how we can move forward. And so with that,
Mr. Chairman?
oh, Dean, please, you're
Thank you.
recognized.
If they were here, even if under subpoena, and their attorney advised them not to answer a question, they simply wouldn't answer it, correct?
Senator, that's a tremendous point. So because of the litigation, if they were concerned, they didn't want to be here while the case was going on, this was even discussed with them. You can come, bring your lawyer, and question by question. If your lawyer says, I can't really answer that based on litigation, of course, that's fine. They had that option. That was discussed with ISS. I'm so glad you underscored that, because that's an option they have. It's not necessary to hide from public view. Days like today remind us of the old adage that we live around here, that sunshine is the best disinfectant. And so thank you for pointing that out. Thank you, Dean. At this time, I do have an order we'd like to take the witnesses in. So, Mr. Babcock, you're recognized. Introduce yourself. Give us your testimony. Welcome.
Today on this matter. Making sure the mic is good. Thank you. Thank you, sir. My name is Christopher Babcock, and I'd like to thank the chairman and the members of this committee for inviting me to testify today. Bill 2337, and why it was an important piece of legislation for Texas and for our overall capital markets more broadly. The members of this committee have received written testimony from Stephen M. Pantina of Proxy Analytics, LLC. His testimony highlights the significant role that proxy advisors, and in particular ISS and Glass Lewis, play in corporate decision-making. Said simply, in the United States, most shares of public companies are owned by professional asset managers, the institutional investors that the chairman mentioned in his opening remarks. These asset managers are third parties who invest the savings from ordinary Americans who are planning on retirement, saving for emergencies, otherwise seeking to build their financial future. And these asset managers are fiduciaries. That is, under law, they owe their clients duties of care and loyalty and have a recognized obligation to vote corporate shares on a reasonable basis aimed at one thing, their client's financial interest. You would assume then that when professional proxy advisors, such as ISS or Glass Lewis, sells voting advice to these fiduciaries, their advice would be based on the shareholder financial interest that is the asset manager's duty. And yet both proxy advisors have publicly disclaimed this as the basis for their voting recommendations. ISS has stated in an interview with CNBC that, quote, "The investment thesis is something we leave to the investors." Glass Lewis told the House Financial Services Committee that it does not generally conduct an economic analysis of shareholder proposals before it makes its recommendations. The proxy advisors say this despite acknowledging that if their advice were labeled as non-financial, then, as Glass Lewis said, its asset manager clients might, quote, "feel compelled to disengage from buying and acting on their voting recommendations that could cause a fiduciary to be, again, quote, perceived to be violating its fundamental duty and opening itself to litigation." Said plainly, we believe that, as stated by attorneys general in Texas and several other states, ISS and Glass Lewis have worked to advance agendas under the guise of impartial investment advice through distortion and non-disclosure of material facts. In particular, while portraying themselves as disinterested and neutral service providers to avoid regulation, ISS and Glass Lewis have gone to great lengths to avoid transparency concerning how they develop their recommendations. Both proxy advisors are suing in federal court to avoid the enforcement of SB 2337. And while they are entitled to their day in court, it's worth noting that the proxy advisors have worked hard to keep the discovery, which seeks information as to whether their voting recommendations are made solely in the shareholder financial interest, confidential, and required numerous filings to be made under seal or with significant redactions to avoid having the details of the proxy advisor's decision-making subject to public view. Moreover, ISS and Glass Lewis have recommended against all but a single corporate proposal to redomesticate to Texas. Not once in any of their published recommendations did they disclose that these firms urging shareholders to reject coming to Texas were themselves in active litigation against the state. These recommendations did more than omit material information. What ISS and Glass Lewis published provided shifting rationales that appear to show a motivated reasoning in their voting advice. Compare what ISS has said about 4 companies who have had proposals to redomesticate to Texas. In particular, what they've said about the company's decision to adopt or not adopt a derivative ownership threshold. As a reminder, Texas allows its corporation to set an ownership threshold that must be met for a shareholder to take control of a derivative claim. Texas Capital Bank proposed to adopt a threshold and disclosed to shareholders that such a threshold could protect the company against opportunistic and frivolous litigation. ISS, in evaluating that claim, stated that it determined it does not appear that the company is currently or historically unduly burdened by non-meritorious litigation. Archer Aviation proposed a similar threshold, and ISS responded by arguing that the threshold was concerning, in fact, because Archer had been involved in shareholder litigation. ArcBest Corporation proposed to redomesticate to Texas and to affirmatively not adopt a threshold without a shareholder vote. ISS determined that the opting out of the threshold was simply not relevant to its analysis. ExxonMobil did not adopt an ownership threshold, and yet ISS recommended against its redomestication because the company would be able to do so in the future. In each of these recommendations, all of which were made this year, the reasoning was different but always pointed to the same result. And the inconsistent and results-oriented reasoning shown by ISS and Glass Lewis does not only apply to litigation thresholds. We've seen numerous mistakes and errors in how they've described Texas law on the proposals for Texas redomestication. Companies redomesticating to Texas were criticized for having exclusive venue provisions, even though such provisions are common and almost universal among large public companies. Differences in legal structure were mischaracterized as reduced protections, despite being substantially comparable when the effect of the structures was analyzed. Cost savings of proposals were ignored, often on arguments based on market capitalization, even when the proxy advisors acknowledged that a company was seeking savings was pre-revenue. That is, a company that has yet to earn revenue, that is still relying on investor funding, and identified cost savings that would allow it to have less dilution, less capital, was discounted simply because of the company's market cap. Texas law was routinely misstated in both large and small ways, but always in a way that supported a recommendation against redomestication. If all the mistakes go to one side, that suggests they're not honest mistakes. Rather, ISS and Glass Lewis decided on their preferred result and then reasoned backwards to get there. I've focused on the redomestication proposals because that is a part of my practice. But ISS and Glass Lewis have a long history of recommendations that are inconsistent with shareholder financial value. I'll mention two of them from 2022 briefly. One proposal for Chevron to adopt a report that could lead to the divestiture of significant assets. Another shareholder proposal to Pfizer that it freely transfer its intellectual property to allow vaccine and other manufacture in third world countries without receiving compensation. Both of these proposals were identified as having a material cost, a material burden on the shareholder financial return of those companies, and yet ISS supported both of those proposals without justifying that through the lens of shareholder value. The issue here is not whether the proposals that they vote for or against are good or bad on policy grounds. That is important. The important is to understand that when professional asset managers purchase advice as to how they can vote their shares in accordance with their fiduciary duties, the fiduciary duties to serve their own clients' financial interests, the recommendations should contain that analysis or explain that they do not meet that standard. ISS and Glass Lewis are free to hold and to advocate for any policy views they like. That's appropriate to do, and we believe in robust debate and discussion. ISS and Glass Lewis are not fiduciaries. They don't have a duty to the independent investors who are ultimately affected by their advice. And yet, despite this, they sell their voting recommendations to fiduciaries, and the effect is significant. In a 2019 letter to the SEC, ExxonMobil analyzed the voting patterns of its own shareholders and found that there is a set of asset managers who consistently vote in line with ISS's recommendations, and often before the asset managers would have had a reasonable chance to read and consider the report. In Exxon's analysis, every year in which ISS recommended against a company's vote on say on pay, support fell by roughly 15% on the first business day after the recommendation, leaving a material question as to whether the recommendations were independently reviewed or immediately followed. Now, many asset managers have their own stewardship teams and are able to carefully consider how they view and vote their corporate shares. But the data shows that some portion of the market does opt to simply file ISS and Glass Lewis. When the following becomes mechanical, for whatever reason, including the compressed nature of proxy season, with thousands of companies putting together shares for vote in a 2-month window, or resource constraints on smaller asset managers who may want to reduce fees they charge their clients rather than pay for stewardship teams, a proxy advisor's recommendation becomes and can become a fiduciary's vote. ISS and Glass Lewis market their research to these fiduciaries. If they continue to do so, transparency and accountability with respect to their recommendations are essential. SB 2337 took the correct position. A proxy advisor who is influencing the voting decisions made with respect to the savings of ordinary Texans and others should be asked to prove that their recommendations are consistent with the fiduciary standards of asset managers or make it clear to the market that their recommendations are not. I want to thank the committee for the time.
Thank you for your testimony. We'll have questions for each of the witnesses, I'm sure, but we'll wait till we hear from each testimony. So thank you. Thanks for being here. Thanks for what you're doing on this. Mr. Hubbard, you're recognized. Welcome. Introduce yourself and give us your testimony.
Thank you, Chairman Hughes and members of the committee. My name is Brad Hubbard, and I'm a partner at Gibson Dunn in Dallas, where I practice appellate and constitutional law and advise public companies and their boards on Texas corporate law, corporate governance, fiduciary duties, and redomestication. SB 2337 fills an important regulatory gap, and in doing so, helps ensure that shareholders receive full and fair disclosure. As a general matter, everyone who speaks to shareholders about how to vote their shares during proxy season is subject to a comprehensive federal regulatory regime, which requires disclosure and creates accountability. That includes management, that includes the board, and that includes other shareholders themselves when they submit proposals or solicit proxies. The one group that isn't covered is one of the most influential, the proxy advisory firms. These firms advise shareholders how to vote during proxy season, but their advice is virtually unregulated. They're outside of the federal proxy solicitation regulations. They lack clear fiduciary duties to shareholders, and they face no accountability for inaccurate recommendations or undisclosed conflicts of interest. Through SB 2337, Texas has again demonstrated its leadership in the corporate law space, stepping in to fill the regulatory void by requiring proxy advisors to provide full and fair disclosure, just like every other proxy season participant. SB 2337 doesn't tell proxy advisors what to recommend or what to consider in making their recommendations. It requires disclosure and parity. When speaking to shareholders, you must give them complete and accurate information. And these concerns about full and fair disclosure aren't just hypothetical. With my remaining time, I'd like to first discuss two significant undisclosed conflicts of interest that affect proxy advisors, one that's structural and pervasive, and one that's specific to the state of Texas. And second, I'd like to highlight a few troubling developments that I have observed during the 2026 proxy season. First, ISS and Glass Lewis don't just provide advice to investors about how to vote their shares. They also provide consulting services to companies. This practice, charging public companies hundreds of thousands of dollars for guidance on securing favorable voting recommendations, while simultaneously providing investors with independent advice on how to vote on those same companies' proposals, creates a significant structural conflict of interest. And if that industry structure sounds familiar, offering investors a supposedly neutral assessment of a company while simultaneously receiving significant consulting fees from that same company, it's because it is. 25 years ago, that was the accounting industry. Firms audited the very same companies they consulted for. And that practice ended only after the collapse of Enron and WorldCom, which caused massive wealth destruction and harm to shareholders. ISS and Glass Lewis also face a significant Texas-specific conflict. As the committee is well aware, both firms have sued the state to block enforcement of SB 2337. But they didn't once mention their ongoing litigation against Texas during the 2026 proxy season. And that's despite providing recommendations on more than a dozen proposals to re-domicile in Texas, which requires the advisors to analyze and evaluate Texas law and the Texas legal environment. And I'd like to close with three troubling observations from this proxy season. First, with one exception, the proxy advisors have uniformly recommended against every proposal to re-domicile in Texas. And they did so despite not only meaningful explanations from the companies about the thorough analyses their boards undertook in concluding that governance under Texas law was in the shareholders' best interests, but also significant shareholder engagement in support of the move. Second, although the advisors spilled significant ink on the Business Organization Code's ownership thresholds for derivative lawsuits and shareholder proposals, whether a company adopted those provisions and in what form or format they did or did not appears to have had no influence on the advisor's ultimate recommendations. For example, eXp World Holdings adopted both 3% thresholds. Texas Capital Bank shares proposed adopting a 1% threshold for derivative actions. ExxonMobil declined to adopt either threshold, and ArcBest not only opted out, but also included the opt-out in their charter. That's 4 significantly different approaches and 1 uniform result, voting against the recommendation. The impact of the advisor's systemic recommendations against redomestication has been stark. Faced with the near certainty of proxy advisor opposition, with its attendant financial and reputational costs, many companies are beginning to reconsider their plans to redomicile in Texas. And they're doing so despite well-informed board determinations that there's a strong economic and governance case for choosing Texas. And third, the proxy advisor's analysis of Texas corporate law during the 2026 proxy season has ranged from inaccurate and misleading to simply wrong. And I'd like to point out 2 issues that have been pervasive in particular. One pertains to books and records requests. ISS says that the Business Organization Code imposes a 5% threshold for books and records access. They complain that would be impossible for a shareholder of ExxonMobil and would require them to have something like $31 billion invested. But that's flat wrong. The plain statutory text makes clear that it's disjunctive. It's a 5% ownership interest, or that you've held the shares for a 6-month period. And even in addition to that, the Section C also makes clear that courts can compel production for any shareholder that proposes a proper purpose. And then second, when discussing and opposing shareholder proposals and derivative actions, even when discussing those for companies that have affirmatively opted out, indicating they're not going to adopt those, ISS inaccurately describes the threshold for derivative suits as being 3%, full stop. But that's not what the statute says. The statute says the company at its election can choose up to a 3% threshold. You could make it a 2 shares threshold, a 3 share threshold, or a 3% threshold. There's no acknowledgement or recommendation of the nuance in the law. And even more worrisome, in my view, is that after these verifiable inaccuracies were brought to the attention of the proxy advisors, they did nothing. No acknowledgement of the error, no corrective disclosure, and they didn't even fix the problem going forward when discussing other companies' proposals. In sum, the proxy advisor's uniform systemic opposition to Texas underscores the need for legislation like SB 2337. Shareholders deserve full and fair information from those trying to influence their votes. Federal law ensures that that's what they get from management, from the board, and from their fellow shareholders. SB 2337 closes a critical regulatory gap. It requires full and fair disclosure from the proxy advisors to Texas shareholders, Texas companies, and the Texas economy deserve nothing less. I welcome any questions the committee may have.
Thank you for your testimony. We're probably going to have questions after we hear from everyone. Thank you for being here. Welcome. Good to see you. Introduce yourself. Give us your testimony.
Thank you. Thank you, Chairman Hughes and members of the committee. Thanks for the opportunity to testify today. My name is James R. Copeland, and since 2003, I have been affiliated with the Manhattan Institute for Policy Research, a nonprofit public policy think tank in New York City, where I've long been a senior fellow and the director of the Institute's legal policy research. I also serve on the Investor Advisory Committee for the Securities and Exchange Commission. I do want to emphasize, of course, that my comments today are solely my own. They shouldn't be attributed to my employer or certainly not to the committee. I've also prepared reports and affidavits and litigation involving parallel issues, including SB 2337, and my comments are solely my own, shouldn't be attributed to any litigant or others in such litigation. I've been studying proxy advisory firms and their influence on shareholder voting at America's largest publicly traded corporations for more than 15 years. I published my first significant empirical study on these issues in 2012, which I wrote about in the Wall Street Journal that year. I think that op-ed and the study can be made available to the members of the committee. In 2018, I co-authored a study with Stanford's David Larker and Brian Tayan that laid out empirical evidence on proxy advisory firms and proposed various reforms. I've submitted multiple comment letters to the SEC and other agencies on this, which can be made available. I've testified before both houses of Congress on these questions, most recently last September before House Financial Services. All those can be made available as well. And I've sponsored and edited and published studies from outside scholars, including on the relationship between environmental and social shareholder activism and share value, and on robo-voting of proxy advisory firm recommendations. It was written by Paul Rose, now the dean of the law school at Case Western Reserve. So the sum of all this research is that two proxy advisory firms control virtually all of the proxy advisory market. Each is foreign owned. One is owned by the German stock market. One's owned by a Canadian private equity firm and its principal owner. Each of these firms has struggled with accuracy, as you've heard about from the other witnesses. Each has struggled with conflicts of interest, as you've also been hearing about. Each suffers from a significant lack of transparency about how it reaches its recommendations. And each has focused on overreaching environmental and social concerns that typically have an attenuated or an inverse relationship with share value. They have been particularly aggressive in supporting environmental proposals hostile to the interests of many large Texas employers. And you've just heard a significant recounting of how they have viewed redomiciling proposals for Texas in the most recent proxy season. So in addition to SB 2337 and other Texas lawmaking and lawmaking in various states, there have been recent federal efforts to regulate the proxy advisory industry. I want to sketch those out briefly for the committee. In July 2020, the SEC adopted amendments to the federal proxy rules that explicitly treated proxy voting advice from advisory firms as a solicitation under the Securities Exchange Act. And under this rule, proxy advisory firms could qualify for an exemption from the usual proxy solicitation information and filing requirements only if they adopted and publicly disclosed written policies and procedures designed to ensure timely sharing of voting advice with the company subject to the advice before clients received it, and ensured that clients had a way to access any written response the company made before the shareholder meeting. However, in summer of 2024, the U.S. District Court for the District of Columbia held that the SEC had acted contrary to law and in excess of statutory authority in the 2020 rulemaking. And so in essence, and it had already been backtracked after a change in administration, but in essence, the 2020 rule has been essentially vacated, leaving proxy advisory firms mostly unregulated under federal securities law. Now, last December, and Mr. Bledsoe can talk about this because he was involved in it, the White House issued an executive order urging a new effort at overseeing proxy advisors. The exact parameters of what will emerge from the SEC action in response to that White House executive order are not yet known. And in keeping with the aforementioned judicial rulings, there may be limitations in how much oversight the agency is statutorily authorized to assume. So in general, I want to emphasize there is room for Texas and other states to regulate in this area. Congress has not preempted states from overseeing proxy advisory firms. Corporate law and securities regulation remain an area of joint federal and state regulatory oversight, with states still broadly overseeing corporate law and federal law focused on disclosure. The Supreme Court has strongly stated that it will not presume federal preemption of state corporate law in particular without clear congressional directive. I emphasize also that the SEC has recently shifted toward broadly demurring in its oversight of shareholder proposals, traditionally governed through the agency's regulation of proxy statement materials under its Rule 14a8. This shift will place the onus more back on state law where it belongs and may substantially affect the role proxy advisory firms have traditionally played in influencing corporate behavior. With these shifts, state corporate law becomes even more paramount. Finally, while Delaware has long dominated state corporate franchises, its position is not inevitable, and interstate competition for corporate charters, even if mostly theoretical, and it's been mostly theoretical to this point, is a central underpinning of what my law professor Roberto Romano called the genius of American corporate law. Texas's efforts to enter this space, now with some success, are a very welcome development, particularly Texas's efforts to cabin aggressive, socially oriented shareholder activism affected through shareholder proposals, the ownership requirements previously discussed, and shake down derivative lawsuits that principally enrich plaintiffs' lawyers, which we've also just heard about. So I welcome any questions, and I look forward to working further with the committee members and staffers in this important work. Thank you.
Ms. Copeland, thank you. Ms. Bledsoe, welcome. Introduce yourself. Give us your testimony.
Chairman Hughes, members of the committee, thank you for the opportunity to testify today. My name is Eric Bledsoe. I'm a visiting fellow at the American Resolve Institute. American Resolve Institute is a nonprofit organization dedicated to promoting freedom, opportunity, and innovation grounded in the nation's founding values. Prior to joining the American Resolve Institute, I served as Special Assistant to the President for Domestic Policy at the White House from January of 25 to March of this year. For my tenure at the Domestic Policy Council, I could say that President Trump and his administration are committed to ensuring every American has the opportunity to pursue prosperity and financial freedom. That is why during his campaign even, the president promised to eradicate the politicization of the financial sector, which has weaponized Americans' investments and savings for ideological purposes, often without their knowledge or consent. That is why in the first year of his second term, President Trump signed Executive Order 14366, protecting American investors from foreign-owned and politically motivated proxy advisors. In the executive order, the president directed the chairman of both the Securities and Exchange Commission and the Federal Trade Commission to take action consistent with their agency's authorities to ensure proxy advisors advance investor returns rather than ideologies like diversity, equity, and inclusion or environmental, social, and governance agendas. Two foreign-owned firms, Institutional Shareholder Services, or ISS, and Glass Lewis control over 90% of the proxy advisor market. Many index funds vote in lockstep with their recommendations, so this advice becomes de facto control in corporate elections. Given this duopoly, proxy advisors have unmatched influence in corporate governance matters like shareholder proposals, board composition, and executive compensation, which impacts returns for investors, many of whom are just saving for retirement. They effectively decide how trillions of dollars in shares are voted. ISS and Glass Lewis have used that power to issue one-size-fits-all recommendations based off of political litmus tests rather than company-specific financial analysis. Those recommendations are then used by the fiduciaries who must vote in the financial interests of teachers, firefighters, and retirees. Take the example of board composition. From 2022 through early 2025, ISS generally recommended voting against the nominating committee chairman at large companies with, quote, no apparent racially or ethnically diverse members, and against the chair where there were no women. This is cookie-cutter governance, a fixed identity threshold applied across thousands of companies, regardless of performance, industry, strategy, or director qualifications. The proper fiduciary question is whether a director can help create long-term shareholder value. A rule key to skin color or sex is the opposite of company-specific financial analysis. Then the political weather changed. On February 11, 2025, ISS indefinitely suspended consideration of board, racial, ethnic, and gender diversity in its director recommendations, expressly citing President Trump's executive orders on DEI. A genuine financial judgment does not evaporate because an election turned out differently. Glass Lewis proves the same point, but from the other direction. Its 2026 guidelines still generally recommend against the nominating committee chair of a Russell 3000 board that is below 30% gender diverse, and against the chair of a Russell 1000 board with fewer than one director from an underrepresented community. The two firms now can treat the same company differently on the same political issue. That is judgment by policy rather than by financial analysis. And on the energy front, Phillips 66 shows the same machinery in operation. For the 2021 proxy season, ISS rewrote its benchmark policy to treat, quote, demonstrably poor risk oversight of environmental and social issues, including climate change, as grounds to recommend voting against a company's directors. A generic political standard it applied across companies, not the product of any company-specific financial analysis. Backed by that kind of pressure, an investor campaign coordinated through the activist network Climate Action 100 pushed Phillips 66, an American oil refiner, to pledge a 15% cut in the emissions of its products, its so-called Scope 3 emissions by 2030. In plain terms, the company committed to a plan to limit the use of the very product it sells. There is no company-specific financial case for that. It is a political objective routed through fiduciaries who are supposed to be voting for financial returns. The same season, the same machinery let a 4-month-old fund holding just 0.02% of ExxonMobil shares win 3 board seats. With SB 2337, Texas is protecting its investors by requiring proxy advisors to disclose a financial analysis providing an economic rationale for their recommendations. SB 2337 imposes transparency requirements and holds proxy advisors accountable to their responsibility to recommend votes that have a positive impact on returns for its investors. Reforms like these support at the state level reforms President Trump is advancing at the federal level, ensuring every American invested in their future can expect that their investments prioritize shareholder value. Texas could expand the law by requiring that the proxy advice that the Texas retirement system and other state fiduciaries receive is based on publicly disclosed financial analyses that are free from conflicts of interest, as has been mentioned a few times. Phil Anderson, president of America's Economy First, recently wrote that the proxy advisory industry is a problem created almost entirely by institutional laziness and regulatory drift. And now, 20 years on, 2 firms that nobody elected and nobody can easily fire have a quiet veto over a substantial portion of American corporate governance. Every American has the right to financial security and independence to access the American dream. Texas has the opportunity to promote transparency and bring accountability to how the shares and the funds it manages in its public retirement systems are voted. The state has a fiduciary responsibility to its beneficiaries. Teachers and firefighters have more than earned the right, after decades of public service, to retire with dignity and financial security. Measures like those in SB 2337 ensure beneficiaries remain on a pathway to prosperity. Thank you for your time this morning, and be happy to answer any questions you might have.
And thanks for your testimony. Senators, we'll open up the panel for questions. I have some, but I'll wait to see if any members have anything first. Dean, you're recognized.
Thank you, Mr. Chairman. First, is there any evidence that indicates that considering any environmental, social, or governance factors is inherently inconsistent with an investor's fiduciary duty?
There is. So Cliff Asness.
Pull the mic a little closer, Mr. Babcock, so we
Thank
can
you.
Go
Yes,
ahead.
sir.
Thank you.
There is. So Cliff Asness, the head of AQR, a institutional investor fund, looked at ESG investing in a letter he published, I want to say 2019 or so, late teens. And he made the point, if you have a strategy to maximize financial value and you have the same goal, one strategy is constrained, one is not constrained, inherently the unconstrained strategy will do better. That is, if the constraints are added outside of your core goal, there is inherently a trade-off. And so if your strategy is focused on environmental, social, or governance goals, rather than purely pursuing what is the right financial interest, there is an implicit drag that shows up in the modeling.
Thank you. Anyone else?
Yeah, and Cliff is a friend, and I think he's absolutely right on this as a matter of theory. I mean, he studied his theory under Fama and Fringe and these folks. He's made a lot of money on it. We also did commission an empirical study on this question. The word inherently does a lot of work there. In other words, could there be an environmental or social factor that could add value as an investment strategy in theory? If the market is somehow not properly pricing it in, sure, in theory. But in general, Cliff's rule is almost a truism in terms of financial theory. Empirically, we commissioned a study by Tracy Weidke, who's an economist, professor at the University of Tennessee, to look at public pension fund activism and share value, because I'd been tracking, shareholder proposals in the environmental and social space for some years, and we're like, well, but the real answer here is there a share value impact? And so she, developing on a methodology she developed in her doctoral dissertation, started looking at this and looking at when public pension funds, and these are most often done by more blue state public pension funds, but are engaging in social activism through shareholder proposal sponsorship in their portfolio. What that impact is on share value, because you've got regular controls. They don't do that with all their investments. And what she found was an inverse correlation between share value and this sort of social and environmental shareholder activism. Now, that doesn't mean that there's always an inverse relationship in every case, but on average you find that. So I think it's an important public policy impact. There have been other studies as well, and I think while there's never unanimity among studies, I think the bulk of the research here would suggest that there's probably an inverse share value relationship. At a minimum, as I said, it's an attenuated relationship and a theoretical one. That in the aggregate doesn't really wash, as Cliff said.
Thank you. Should the state be involved in deciding what categories of information investors should consider, or should this be left to the market participants and investors?
So I think the important thing in the requirement for transparency with the proxy advisors, it's not whether or not the state supports the policies they want to vote for. This is not an issue that the state is opposed to ESG or supports ESG or other social initiatives. Rather, it cuts to the heart of the way the proxy advisory firms influence, not through persuading people investing their own money, but by persuading fiduciaries who are investing other people's money. And when someone is investing other people's money and has a duty to invest that for a financial return, their advice should either be consistent, we would suggest, with that shareholder financial return, or if it's not going to be consistent with that return, they should acknowledge that so that the third-party asset managers, who again have a legal duty to maximize return, can take the advice into consideration appropriately. This isn't a problem of advocacy. It's a concern that ISS and Glass Lewis essentially seek to push non-financial agendas through the mechanism of shareholder voting.
Thank you.
I think, from my perspective, the state should be broadly value neutral on these questions normatively. In the ordinary case, the select case is when you're talking about your own pension plans and your own investment strategy, and then it's really important for the state to adopt I think, consistent with share value norm. When it comes to the regulatory overlay, this is complicated by the fact you've got the federal and the state here, right? And normally disclosure rules are federal, but we have a vacuum, at least at the moment, when it comes to proxy advisory firms on this, and so and there's no preemption. So I think having various forms of disclosure or analytical requirements on the part of fiduciaries, or they're not really fiduciaries, but part of market actors, giving proxy voting advice that have massive impacts on the market. This 2012 study I looked at showed 15 to 20% market impact, and econometrically from ISS, when you add in Glass Lewis, it's probably about a quarter of the vote. Now that's probably shifted a little bit over time since then, but there's clearly still substantial robo-voting going on by smaller institutional investors, not the big fund families which vote on their own. When you've got something that's that significant, I think the sort of disclosure rules we're talking about and analytical rules are useful. And they're the sorts of things the SEC regularly requires of companies, of issuers, as well as institutions. So, how that state and federal fits together is a fairly complicated question. But in the absence of any federal role at the moment, I mean, I would applaud Texas for thinking carefully about this.
Thank you. Is there a risk that these policies could place Texas at a competitive disadvantage and that firms would rather go to states that don't have such requirements?
There's always a risk, but I think the obvious evidence cuts in the opposite direction right now. I mean, you've got multiple companies trying to re-domicile in Texas, so I don't think that's going to happen overnight because Delaware has such a dominant position here, has for 100 years, has a well-developed body of law. My colleague Robert Miller wrote a piece on this a couple weeks ago saying, I don't think Delaware is going to lose it all right away, but in terms of where you're going to incorporate, most big companies are still in Delaware, but the momentum is toward Texas, not away from it. So it's probably creating a competitive advantage in terms of corporate franchises for Texas, not the inverse.
And I agree with Mr. Copeland, is what we have seen in the proxy advisor's uniform recommendation against is that is chilling the willingness of companies whose boards have put in the effort and the diligence and the exercise of their fiduciary obligations to compare Delaware law and the Delaware regime to Texas law and the Texas regime and make the decision that would be in the best interest of the company and the shareholders, and yet they're hesitating to make that move now because of, not because of SB 2337, but because of the proxy advisor's unwillingness to explain exactly what it is that you need to do to get a for vote to redomesticate. I walked through a couple of the examples. Lots of different companies have done lots of sort of different moving pieces with the SB 29 stuff and the shareholder proposal stuff, and the sort of uniform result has been against. And so that's what's concerning from my view.
And I'll say one other point here. The concern is not that shareholders broadly agree and support these proposals and that ISS and Glass Lewis reflect the interest of shareholders investing their own money. What we hear time and time again when talking to companies who are concerned about the role of the proxy advisors, it's not because they think the proxy advisors are persuasive. When they talk to large asset managers, large institutions, and management is usually able to articulate and often persuade, not always, but when there's a dialogue and a way for discussion between a company and its shareholders, we find much more support for redomestication or other proposals. The problem is there are smaller asset managers who don't have their own stewardship teams. And so when ISS or Glass Lewis make a recommendation, and that recommendation is based on mistakes, it has errors, it's not transparent, it has omissions. Companies have no one they can call at some of these smaller asset managers to say, hey, your advice doesn't actually articulate this or doesn't cover this appropriately. And so again, the concern is not that ISS and Glass Lewis are persuasive, it's that they have a niche that allows them to substitute in some ways their judgment for that of the fiduciaries, and they do so while at the same time disclaiming any responsibility for the accuracy or content of their recommendations.
Thank you. When we considered this bill last year, critics said, and I quote, that the disclosure requirement would be onerous and burdensome for smaller advisory firms, and that the civil liability put on the proxy advisory firms would be chilling. Has that been the result of this legislation that you know of?
The legislation currently has not led to suits against the proxy advisors. The Attorney General is currently enjoined from enforcing it against the advisors, and so we have not seen the market effect of the law in full force.
Thank you so much. And finally, my fifth and final question is, our charge includes making recommendations for legislation needed to improve, enhance, or complete implementation of this legislation. Does any of you have any recommendations to that effect?
Yeah, well, I mean, I think it would behoove the committee to think about, legislation that could potentially moot the litigation, right? But I think, overall, it's a solid piece of legislation. I do think if the SEC comes down, and FTC's got a piece of this as well, as Mr. Bledsoe talked about, but the SEC is going to be the principal actor here. If they come down with rules vis-a-vis proxy advisors, I think that then it becomes imperative for the committee to think about that and what the interaction is between the federal and state regime. I mean, there still could be a place for state law here. There's not going to be complete preemption of the field, I don't think. But who knows? It kind of depends on that. I mean, if the feds preempt the Texas law completely, there still would be pieces of it that would be in effect, which are in effect, right? I mean, a threshold on derivative lawsuits, a threshold on shareholder proposals, because my instinct is the SEC will continue to push this towards the state level, and hopefully will do so formally. I've called on them to do so. So it kind of depends on what the SEC does, and it kind of depends what happens on the litigation front. But there may be ways to create safe harbors around what you're alluding to here. I mean, you don't want to create barriers to entry in this industry. I think it's very difficult to have new entrants in the industry. When we looked at it, ISS used to be owned by publicly traded American companies, so we could look at the books, and it's like, oh, they get 120 million in revenues, 2/3 of which is only on the proxy advisory business. 1/3 is the corporate side business, which is a conflict of sorts. That's not going to attract a bunch of big VC money, right? I mean, I think they get overpaid for a lot, and they get overpaid for because of their influence, not because of the economics of their business. At root, we have a problem with voting, which is a problem with voting every elected official is aware of, in that it doesn't make a lot of sense for a small asset manager to invest heavily in its voting, because that's not a competitive advantage relative to other asset managers. And so they try to discharge this at a low cost. And when you discharge it at low costs, and these are fairly easily captured sorts of businesses, that's why we have the world we've got. Texas isn't going to fix that on its own, but I do think Texas is very smart to be thinking about how this relates to Texas's pension funds, to Texas businesses, and Texas's efforts to have companies re-domicile here. So,
Thank you so much. Thank you, Mr. Chairman.
And thank you, Dean. Senator Bencourt, do you have questions, Senator Bencourt?
Yes.
You're recognized.
Thank you, Mr. Chairman. James, to your point, I want to make sure that that the whole subject of the Marshall hearings was to set a pattern of recognizing the obvious with Chairman Hughes's leadership, that we weren't going to accept ESG solutions on Texas retirement funds and having people come out and say, don't have our retirees' money being spent on high return Texas energy projects. Now, if I remember correctly, we had one of the firms actually dropped the ES before even the hearing, because they figured out that they could market a G solution in half the states pretty rapidly. But I just want to make that clear, at least from my one view, and I know the chairman also went through this in detail, that we're simply not going to allow proxy advisors to vote against use our own shares to vote against our own energy projects. It's really what was occurring. Okay, still is, obviously, because that's my second question. Gentlemen, all of you, how many companies have been basically by either ISS or Glass Lewis, how many times have they been advised not to move to Texas? Specific examples, if you have them. I think Brad or Christopher had them.
Yeah, I mean, so if we want to walk through this proxy season, ISS came out against the proposals to redomesticate to Texas from Forward Industries, which was from New York, Texas Capital Bank Shares, which was from Delaware, Arc Best Corporation from Delaware, EXP World Holdings from Delaware, T-Tech Holdings from Delaware, Exxon Mobil from New Jersey, Voyager Technologies from Delaware, Dreamfinders Homes from Delaware, First Cash Holdings from Delaware, AER Sale from Delaware, and Weatherford from Ireland.
I believe it's also come out against Dell and Archer,
right.
which are still pending votes.
Okay, so I'm counting 10, gentlemen, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Between, if I add Dow or Archer to the list, was Weatherford, is that the oil field supplier, or was that a different?
Correct. They're currently in Ireland. The vote did not pass. They received 62% of the shareholder votes, but they needed a 75% bar to make that.
So that's 9 votes. That's 9 votes that have already occurred. They've advised against, and 2 more.
That's right.
Right. Now, by chance, has anybody added up the total amount of CapEx on these guys, on these 11 firms?
It's over 800 billion. Exxon covers all. It
helps.
Yeah, it's over 800 billion.
Right. Okay. So nearly, Mr. Chairman, $1 trillion of total effective wealth, well, to translate for the lay people that are listening. They've advised not to come to Texas, and for what I believe is purely political activism. There's not a focus on what I would call the governance side of this or the shareholder side of this, but this environmental social activism. Now, you all have talked about how that can be baked into the market, baked into the decisions. These are things that are all part of our market forces that you have to go through this. But I just wanted to put a fine point on how much wealth is being prevented from coming here. Now, any estimate number of jobs at this point? It's obviously in the tens of thousands, but
I think it's hard to put a hard number on jobs.
because you're transferring a corporate.
Because
right.
you're transferring a corporate entity that tends to create jobs over time, that tends to create deeper roots to the state. But it's hard to isolate that from all the other factors. But I agree with you that it is significant.
So this isn't an esoteric discussion of what should be good public policy and the fact that you could have a more liberal view of environmental, social, or more conservative view. This is an absolute roadblock being put up by foreign-owned proxies to tell nearly $1 trillion of companies not to relocate to Texas. So, gentlemen, do agree with that summary? Eric, I've got a question for you since you brought this up. Obviously, there's a federal discussion about rules that relate to foreign-owned proxy advisors. Could you be more, should I say more descriptive to the audience of what's being discussed? Because it would appear that both ISS and Glass Lewis fall under that discussion.
Yes, Senator. To be clear, no longer speak for the administration, just here in my capacity at American Resolve Institute. What I can say is there are a number of provisions in the executive order, pretty clear. One thing that I would point out is for federal regulation to go back and examine the classification of proxy advisors. As James and a few others have said, really is a kind of gray area that proxy advisors operate in. And so one of the things to look at is regulation on how do we classify them? What are they? They're not fiduciaries. They are certainly actors in the corporate governance and financial space. So one thing would be to look at would they be classified as investment advisors, right? Which would actually put them subject to more disclosure and more requirements under federal law and regulation.
They're certainly acting as investment fiduciaries. Okay. They give out advice and they don't have to maintain any type of transparency, whether it's true or false. They take no responsibility for their recommendations because they're not held accountable by any licensing standards that I understand, at least at this point. And look, you could have a debate about this because I think all of y'all recognize there's a mix of market forces here. But the Phillips example is pretty demonstrative as to what happens when you have a fight led by proxy advisors that people take the recommendation and rubber stamp and vote that way because they may not even understand what that recommendation is because it's not transparently disclosed that they have a bias. See, they clearly have a bias. Okay. Now, politics is full of bias, except that when you're running for office, that is on display with whatever communication you make to the voters en masse. And but here they don't have to even say they're biased. They don't even have to say what their opinion is based upon, and their opinion doesn't have to be right. It is wrong. Okay. And so many times, the debate I had, Mr. Chairman, with the ISS Representative Marshall, they were fundamentally wrong to advise the Texas Employee Retirement Fund not to invest in high return Texas energy projects, period. It's not up for debate. It's in the state's interest to get a good return on that money. And look, just the companies you've named, I used to work for Dow. Okay, in a galaxy long ago. I've got relatives at Weatherford. ExxonMobil's campus is huge up between mine and Senator Liggins. These are real operations that have real employment, that generate real wealth, and these proxy advisors, I believe, because of this of their political persuasion, of environmental, social, especially from the fact that they're coming from obviously what is a non-shareholder based view. They have already stopped $800 billion worth of companies from coming to Texas. Mr. Chairman, I mean, that's an enormous amount of money. It's a huge disservice to the state of Texas. It's a huge disservice to their shareholders because it's not even being debated in open transparency. I don't know, gentlemen, you got any comments? Am I missing it?
Three quick follow-ups on the federal regulatory point, right? One is there's nothing present, right? It is aspirational, right? It's a great executive order that acknowledges all of the problems, all of the regulatory gaps, right? Texas has done a really important job in filling that gap, but there is nothing working there now. In large part, that's because the SEC tried during the first Trump administration, right, to regulate them, say that their proxy advice counted as solicitation under Rule 14A9, and the Court of Appeals for the D.C. Circuit said no dice, so that's off the table. And then we're also seeing the push to the states, as we talked about with 14A8 and shareholder proposals. So I think it's still, even if the federal government is able to make some movement in this space to ensure that that regulatory gap is closed, it is important the work that Texas is doing, being on the forefront, filling this regulatory gap and ensuring that shareholders can receive full and fair information.
I think I want to highlight one of the points that Mr. Hubbard made earlier because I think it's so key to this. Everyone else who is speaking to shareholders in this context is subject to some sort of regulation, a fiduciary duty, a rule that prohibits errors and omissions, that prohibits materially misleading.
Some type of oversight.
Management is. If an activist investor thinks, I don't like how management's running this company, I want to go get shareholder support, that investor is regulated in what they can say. They have to be honest and transparent and let the markets play out. ISS and Glass Lewis have avoided deliberately that transparency and accountability, and that's why bills like 2337 are so important to try to bring some accountability to these actors.
Well, when you testify in other panels, just tell them that we're lucky to have a chairman that can write a bill like that and pass it. Okay, and that is, quite frankly, one of the major differences that why Texas is leading on the subject. Mr. Chairman?
Senator Benjamin, thank you. That the Marshall hearing you mentioned, of course, what gave rise to that hearing, one of the primary sparks for this committee and this legislature was when we learned, as you said, that ISS had recommended a Texas pension fund to vote for a recommendation that says we oppose future oil and gas development. That's just a hard one, and hearing them try to explain it was pretty fun. But that's what got us on this. That's what made us
Pretty
realize
sure
there's
I
a
was
real
sitting
problem.
next to Senator Perry when we learned that in the Finance Committee,
Yes, sir.
I believe.
Yes, sir. Yes, sir. I have a few follow-ups. This has really been helpful, and I thank the committee and the witnesses for your patience. A couple of mechanical questions I have. Mr. Babcock, we talk a lot about the votes at the annual meeting, and that's sort of the way I frame the issue at the beginning, talking about electing people to the board or unelecting people to the board or shareholder resolutions. But tell us a little bit about what goes on before the meeting, because we know that many times, at least I've been told, and we had testimony that many times, long before that meeting takes place, because ISS and Glass Lewis are calling these companies or telling them what they think, what they want, can that often affect what's even brought up at the annual meeting? Tell us about what's going on before the meeting takes place and what a big effect they can have there completely in the shadows.
Absolutely. So to give an example, the board has, at an annual meeting of shareholders, only certain items come up. The election of directors, it's very similar to a representative democracy, where the shareholders elect their directors who will then serve and generally operate the company. Certain major decisions and certain requirements of federal law are also voted on. So there's a say on pay and advisory vote on compensation that's required by the SEC. If a board wants to pursue a major transaction, a merger, an acquisition, a sale, or coming to Texas, something that is a fundamental business transaction is how the TBOC refers to it. Other state laws use different language, but the same idea. Those are proposed by management and considered by the shareholders at the annual meeting. All of this is public. Management's proxy solicitation is filed with the SEC. There are often campaigns to reach out to shareholders to explain their view, to take feedback, to make sure that the shareholders are aligned and comfortable with the vision. And management bears a reputational penalty and a cost if they make proposals that are voted down. They want to be seen as, they of course want to lead, but they also want to make sure that their guidance, their suggestions are those that are broadly supported by their shareholder base. Oftentimes, when a company is considering a significant transaction, one of the things it will do is it will sit down with its internal investor relation professionals, it will hire outside advisors, and it will ask, what support do we have for this? Do we believe not only that this is the right thing for shareholders, which is our lodestar duty, that's the first duty, but they're also going to ask, even if we believe it's the right thing, will we get the requisite support that we need? And so when ISS and Glass Lewis are known to vote against Texas constantly, for an example, just because, again, we've seen that this year, and that's the data that we've been looking at most carefully, they're going to ask, can I win a shareholder vote without ISS, without Glass Lewis? And that's probably going to have a drag of 10 to 15 to 25% of the votes. And if they believe that they can't, if they believe that they cannot win the vote without ISS and Glass Lewis support, and ISS and Glass Lewis have taken an inconsistent and changing but constant opposition, they are likely not to bring that to a shareholder vote because management is going to see the cost of a failed proposal as significant and not likely to go forward if they don't expect they have the votes. This is difficult to quantify because this happens in private conversations for months ahead of time and doesn't often percolate up. We can see some examples. For example, a company that looked to come to Texas prior to the effectiveness of SB 29, prior to the effectiveness of SB 2337, was Mercado Libre. They had a proposal to the shareholders. ISS and Glass Lewis recommended against it. That resulted in the proposal being withdrawn without ultimately going to a vote. And that was fairly far along. There are many proposals that simply don't happen, and we don't see the data because of the chilling effect of these two advisors.
That makes sense. We've also heard testimony about company policies broadly, where a CEO or a company owner or a company management is told by ISS, for example, meeting's coming up, we control this many shares of your retail shares. We think you should consider taking your company in this direction. That's what. Tell us about that. We know that happens. We've heard testimony from company management about that happening, not just about a redomestication or even maybe not even a vote before the shareholders, but a direction the company's taking, a policy, a social political issue that ISS cares about but doesn't do anything to add value to the shareholders.
That is correct. And so ISS and Glass Lewis interface with companies. And ISS and Glass Lewis, not only in their public policies, but also in conversations with companies, will discuss what their policy is looking like with a goal for influence. Because ultimately, what ISS and Glass Lewis sell is their ability to influence companies. They're not selling. They might disagree with this characterization, so I want to be clear this is my view. But they are not necessarily selling voting advice. They are selling an influence over the process that is difficult to identify and quantify because most companies who have these conversations do not want to come and testify about those. And so I can't talk to any particular conversations that I have heard of or been aware of.
Of course not.
But I can confirm that such conversations happen. And ISS and Glass Lewis often seek to influence companies to adopt policy views that ISS and Glass Lewis ultimately believe to be supported, not based on financial analysis, but based on their own policy view. And again, I think it's worth emphasizing the great work of 2337 was that it acknowledged that ISS and Glass Lewis can campaign, can have views, can articulate them. What is problematic is when they launder policy advice as financial analysis and financial advice fit for fiduciaries to vote on.
Well said, Mr. Babcock. That those conversations have been likened, those private conversations have been likened to Chicago in the 1920s when Al Capone's guys come by your store and say, hey, you got a nice store here. I'd hate for it to burn down. I can help you with that. I'm not the first one to make that observation, but thank you for that. Mr. Herbert, let me follow up on that. You talked about conflicts and, Professor, do you have something else on that? I want to ask you something else, but we don't want to miss it. That's okay. Okay, well, you won't forget. Mr. Herbert, you talked about those conflicts, and it relates to the conversation Mr. Babcock and I were having about these communications. So tell me if I got this right and clean this up. But my understanding is I know that I'm a public company, and ISS is going to be making a recommendation about how my shareholders should vote on my recommendation. I can hire ISS to help me get a better recommendation. Did I get that right?
That's correct.
Tell us about that.
I mean,
Get the microphone closer.
You have that exactly correct, Mr. Chairman. Their consulting services provide guidance on securing favorable voting recommendations, how to improve their governance such that ISS will then give the proposals from the company a for vote. And they don't disclose in any of their, they turn around and then say, we advise yes, for or against, and they don't disclose that, well, our consulting arm also worked on this particular issue at the company, provided consulting services to this company. They acknowledge broadly that they provide these services, but tend not to disclose in their reports whether they provided services to an individual company. And they say, well, we have a firewall between the two sides of the house.
That makes me feel better. Go ahead.
And right, and that was I was an accountant before I went to law school, and that was the sort of same approach that what was then the Big Five took. They provided the same consulting services and assurance audit services to the same companies and had firewalls between the teams, and we know where that led.
I want to ask you about one more thing. You talked about, there's been a lot of testimony about the recommendations and what they're based on. You shared some objective falsehoods or errors. You were talking about their characterization of Senate Bill 29, and if I wrote this down correctly, you said that they said that the new Texas law requires a 5% threshold to get books and records access. Was that was in a recommendation published by one of these proxy advisors?
That was correct. They described that as being one of the reasons why ExxonMobil should not re-domesticate, because it would be harder. It would hurt the shareholders' ability to access books. It did not acknowledge that there was the 6-month holding period. Did not acknowledge subsection C, which allows a court to compel production for any shareholder who shows a proper purpose. Right, in New Jersey, they always had to go to court, and they didn't disclose or mention that of the books and records that are available under the TBOC are broader than those that are available under New Jersey law. So it was all kinds of, it was very surprising.
Well, and thank you that, and lest I repeat that and confuse people, I want to make it, you've made it so clear. There is no 5% threshold for seeking books and records access under Texas law. Never has been, never will be. At least I'm not going to vote for it anyway. Not in the bill. Not in the bill. You're so right.
It wasn't in the bill either.
That's right. It was not. It was not, Mr. Chairman. Thank you for that. Then you also shared with us that with regard to some of these factual errors in these reports, when these were brought to the attention of the proxy advisors, they immediately corrected and let folks know they got that wrong.
No, and again, that is, I mean, that is, you talk about, you think about what is the impact of the proxy advisors not being subject to regulation and not facing any consequences for failing to disclose conflicts or any accountability for being wrong, right? If that were to be right, because everybody else participating, right? The board owes fiduciary duty to the shareholders. They have done the research to say, look, this re-domestication makes sense. We've thought hard. We've compared both of the laws. Their statements, management statements about re-domestication, all subject to federal securities regulation. If they got something wrong like that was pointed out to them, you would expect a corrective disclosure, and you would expect one promptly. And what you did not see is, not only did you not see a corrective disclosure, you didn't see an acknowledgement of error, and in even going forward, right, when opining on other re-domestications, they continue to make the same error. And again, I think that is part of the, right, with SB 2337 enjoined and no other sort of regulatory structure filling that gap at the present moment, that's what you get.
If I may say, just briefly add on to that.
Pull the mic over. Go ahead. Thanks.
I think what's also important to remember is when they make these statements that are incorrect, if management made comparable errors, management would be subject to fiduciary duty litigation. It could prevent the validity of a corporate transaction because shareholders were not fully informed. It can be subject to litigation under 14A9 of the federal securities laws of the Exchange Act because management had materially misleading statements or omissions within their proxy solicitation. When management responds, which is seldom because often management may not want to respond even if they know it's wrong, they feel they've got the vote or for other reasons. But when management responds to correct these errors, that statement subjects management to liability when they try to correct the errors and omissions of ISS and Glass Lewis. Meanwhile, there is no lawsuit against ISS or Glass Lewis for comparable errors.
I did not realize that. Senator Perry, you're recognized.
I'm sorry, Mr. Chairman, and I'm probably going to ask a question I should know. I wasn't at the marshal. I don't think I was on your hearing. I think at the time I got added after that. Probably a good thing. So here's the question of the day, and I'll try to frame it so you don't have to give me a how the car's made speech. Does the board ultimately have to take their recommendation? Basically, what you said a while ago is no.
No.
There is extortion, possibly, by practice. If they don't take their recommendation, then they could be publicly ridiculed for not taking a recommendation, I assume.
The board does not have to take the recommendation, and shareholders don't have to take the recommendation.
Okay. So I'm trying to get to just who do these guys get paid from?
So I'm trying not to tell you how the car is made, so give me a second as I try to get to the right.
Somebody writes them a check. Is it a contract with the board and these folks, or is it all these individual shareholders they cobble together?
So, and I think that's the issue, is that they are not advising individual shareholders.
Okay,
Their
there you go.
clients tend to be asset managers who in turn are fiduciaries of the individual shareholders. So an asset manager, I'm saying asset manager, but think of someone wants to start a mutual fund. Someone has an idea and they realize I can make a profit on the market picking stocks. I can charge a fee and I can let people get hopefully rich, hopefully grow their wealth by following my advice. I know how to spot a trend in the market and I can invest on that. So someone sets up a fund and they take investors and they have fiduciaries to the investor, and their skill set is identifying what companies they think are going to generate an appropriate risk-adjusted return.
Right.
Well, for 2 months out of the year, almost the vast majority of public companies have an annual meeting. All of these annual meetings have director elections. Many of them have say-on-pay votes. All of them have auditor ratifications. And then there are also a handful of fundamental transactions being voted on. So you've got someone who has a really good investment thesis, but they may not have studied the dynamics of what makes a good board or not.
Sure.
They may not have studied this, and they want to keep the fees they charge their investors low. They have, under law, a duty to vote their shares. And so what has happened is ISS and Glass Lewis have said, we will prepare third-party advice that you should feel comfortable relying on in voting these shares. That structurally is not a concern. The concern is when the third-party advice does not publicly but privately disclaims that it's going to the standard to which the asset manager is going to be judged.
I appreciate exactly the fiduciary responsibility. And actually, as a corporate board member, your sole responsibility is shareholder return, like it or not. I mean, someone that's in the business of doing things that we know are not good public policy from a health perspective are still required to look to their bottom line investor return. That's their fiduciary responsibility. You've said it 100 times. I agree. My point is these hedge fund guys are the middle guy, but they've accumulated enough shares to be influential in decisions. And what I'm hearing from you is this guy over here is peddling influence with those guys.
What we find is some of the larger asset managers tend to have their own internal stewardship teams. So JP Morgan, I believe publicly this year, said they're no longer hiring the proxy advisors. They have an internal team. Other large asset managers.
Which you would expect that. And if I'm an attorney, a smart attorney, I would probably sue the crap out of them if they took advice from a hedge fund, from one of these groups that presents a return impact, because you didn't do your own due diligence. But here's a question I have. Set that aside. I get it. Do these proxy people ever get involved as a silent campaigner? Do they advocate for board positions through other influence? Are they influencing the board, not the hedge funds, but the board? And I guess hedge funds have managers that are elected too by how they run. But
they influence the board in two ways. One, they have policy guidelines on who they're going to, because the board is up for election, usually every year in most companies. The board is up for election. ISS and Glass Lewis will often have vote no campaigns against directors if they're opposed to them. For example, Southwest Airlines, a longtime Texas corporation, after SB 29 adopted a derivative.
So they're the dark money, if you will, of the investment world.
I think that's a fair metaphor.
Okay. All right. That's where I think, in my humble opinion, you can hire people to do your research. You can have them have some influence on your decision because their research is better than your research. But when they start impacting the governance of the board of the company indirectly through campaign or black money, dark money, or, for lack of a better term, but kind of setting up a cabal, right? That internally they can disrupt the final say over what hedge fund we use. That's the board. Over how we're elected and who we're elected. They get in there and start messing in that area. But you can say with confidence the vote no campaigns against this guy as a director for this board of trustees is real.
It is real, and companies take them very seriously because, again, ISS and Glass Lewis, again, generally studies vary, but are strongly correlated with 10 to 25% of the vote, depending on company and how it's built.
Summary real quick is ultimately the board of directors, the trustees for the corporation, Exxons, those are the guys that control. But what we've allowed is unaccountable control mechanisms to interject into the process.
That's correct. I would probably say influence rather than control, just to
Well,
be, but
no,
I think you can frame it either way.
I think it's control. I mean, influence and control, two different things. You ultimately have to either have the proverbial cojones to run your company or not. Fair enough?
That is fair, sir.
Okay, so buck stops where those sit.
I mean, the control or influence, whichever you want to say, is sort of indirect but very real, right? If Glass Lewis says, if you don't have the right percentage of gender diversity or racial diversity that we think is right on your board, we're going to vote no on your directors, then even though the fiduciary duties rest with those directors, they can influence that campaign. And if they can influence a quarter of that vote, that's a very strong lean.
Well, I appreciate the pressure it applies, but it goes back to what is the number one goal for a corporate board of trustee is to maximize shareholder return. And again, I don't say that's always a good thing. People are making lots of money on bad things. I can list a whole lot of corporations that their whole livelihood is making a lot of money for their shareholder returns on bad things. But set that one aside. They control all of this. And in any, 25% vote conversation, that would tell me that maybe you as a board are not in the right direction. If there's that much that's being weighted against you out there, then maybe you got the wrong policy and it should be a consideration. But I understand the ESG movement very well on a very practical level outside of the public market. Local banks in small communities were being held to those standards, and it was drying up capital. So I get the conversation about bad public policy being coerced and the impact it has on the average working day mom and pop stores when their banks say, I'm sorry, we'd love to loan you that money, but really we're out of balance on this issue and we're being judged by federals that are going to threaten to take our FDIC insurance away for our investments if we don't do this, and you don't fit the mold for that. We've got to loan this over to here. So I get that coercion that took place through federal overreach, but I'm just saying at some point we as a legislature can do a lot of good things, but at the end of the day, it comes down to a decision by a board to say, you know what, that's not applicable to my shareholder returns, and you can threaten to mess with me. If that's a public policy that the shareholders want, then I'll hear from them. But you got to take that risk, because what we're doing is circular. We're in this track. Well, it's not me, it's them, and if they say they can't, we're not going to solve it. We can find a way to enforce. I think that's what's next, right? But the board, the truth about it is these groups usually provide cover for really hard conversations that they really don't want to have. So I don't know.
Just one counterpoint to that, Senator, is that we saw 12 boards making the hard decision and putting to a vote the move to Texas, right, in the exercise of their fiduciary obligation, knowing they were going to face that opposition. We've got 12 boards that did that, and of those, 11 of them all got the against vote still. And I think that is the part that is hard, right? So even if you have, the muscle and you go, and look, it was great to see that of those, 10 of them passed, but it was very unfortunate to see the ones that the shareholders, right, because there were some set of the shareholders that voted with the proxy advisors instead of with the board's advice. The company ultimately did not get to redomesticate to Texas.
Yeah, I'd say just because it's not popular doesn't mean it's not right.
Completely agree.
And ultimately, I believe in Texas that the truth shall prevail and that your returns are maxed in Texas. When it comes to this issue, ultimately, that proxy vote changes character and goes away because they don't like the value of the corporation or whatever that be, that weird, obscure, emotional feel that's tied up in all this junk. It will go away and they will come and they will bring their money. But it's just something that you got to be, it's kind of like if you never go out there on that limb, you're never going to get it fixed. And for the ones that are, thank goodness they are. For the ones that don't, they're going to get left behind because we are going to be, unless we screw it up, we are on the track to continue to be the economic engine that everybody migrates to. So shareholder return will interject back into this conversation at some level as this other stuff goes away.
That's right. I think the one thing I might say, sir, in respect, I think I agree with everything you've said, that ultimately the board is a fiduciary. It's their responsibility to do this. What Texas can do is make sure that these conversations, which are public conversations, right? They're conversations between boards, their shareholders, they're being done in full view of the market. Texas can work to ensure those conversations are transparent. And if ISS or Glass Lewis are providing recommendations, they're showing their work so that those can be properly evaluated and treated in the market. And so you don't have to go and dig into a bunch of research as to who this is and what's actually driving it. We can simply require, which is what 2337 did, that when advice is given to people who are managing other people's money, that advice needs to be transparent with the rationale explained so that those persons who are managing other people's money can ask, am I being a good fiduciary by following this? Or is this driven by something that isn't appropriate for me to be looked at?
I do agree with everything that the chairman's done and where the state of Texas is. I just want to highlight the fact that the buck stops somewhere. And those folks have to be willing to go there, and they'll have the support of Texas Legislature when they get in those fights. And we should step up. But we can't be the policeman for social conscience at an investor level with a hedge fund between us and them, because they control too many other assets that people in Texas depend on.
That's right. That's right. Professor, I want to ask you a couple more things. And thank you for this testimony, and thank you, Senator Perry, for filling out the waterfront on what's happening here. When did you said you've been studying proxy advisors for a while. I don't recall when you said that first started.
I started following the shareholder proposal market around 2010, and my first study I did on proxy advisors specifically, and it was on ISS because that's the data set I had, was 2012, so sometime.
All right. I'm curious because at the beginning I characterized the role of proxy advisors, what they've done historically, and it was a generalization. I think I reminded my dad said something one time about how no generalization is reliable, including this one. But what I want to ask you, is it fair to say that at one time proxy advisors were more of a corporate hygiene, good governance Senate, then this drift or lurch took place where it began to take on a political agenda? If that's a fair characterization, tell us if you think that is and when, if so.
Yeah, I think that's right. Our database went back to about 2006. And you saw around the time we started studying this, we started studying it for a reason, around 2008 to 2010, you saw more leaning in from the proxy advisors in the direction of sort of the E&S components of ESG. I mean, ESG was launched right in front of that time. It was launched through the UN. It was launched through the finance industry and banks and things like that. And so you saw a gradual shift in behavior. Not to the level it became, within the last 5, 6, 7 years. Around 2017, that's when you saw some of the big fund families, the passive investor families, the State Street and BlackRock in particular, started to lean in on some of these questions, and they've backtracked now some, and ISS has backtracked some, and after the election results, as Mr. Bledsoe said. So it is it's gone a little bit back and forth, but they were under some pressure, right? I mean, I've done comment letters to ISS as well because they'll take outside comment letters. They don't listen to me, but as part of their policy guideline making process. The social investing funds are very active in this, even though they have small market share in terms of their ownership. And then some of the big state pension funds, New York's been particularly aggressive in this area, leaned into the proxy advisors. So, their policies were easily influenced in that direction. And unlike the institutional asset managers, they don't have to, retain capital. They just have to basically be able to help execute these voting fiduciary duties. And there's not the SEC has guided that there's not an express fiduciary duty to vote every share on every question, but there's an implicit assumption there that needs to happen, and so it's a way for them to discharge it. It's sort of it's effectively a safe harbor. You use the proxy advisor, you're kind of off the hook. It's not actually a safe harbor, but it's a de facto safe harbor, which is how they get this sort of level of influence. But when you control a quarter of the vote of all the big corporations, and then you're not at all, the transparent, you're not accurate, you have conflicts of interest. I mean, this is a big issue, right?
Yes, sir. You spoke about the market for doing this and how it's pretty much ISIS and Glass Lewis. I know there's been other folks getting involved, talking about getting involved, and you spoke to this briefly, but why the barriers to entry? So it's not is it a big capital cost to get into this business? Maybe there was a time when you had to have someone at the SEC looking through the physical, literal circulars. I don't know if that's still an issue, but
I mean, executing millions of votes every proxy season, and most clients, your institutional investors that would want to hire an ISS or a Glass Lewis, want to be able to execute on a global platform, so it's not just U.S. Right. It's a big enterprise, so there's a pretty big upfront cost, and as I said, a pretty low economic payoff. I mean, if your total revenues were 120 million. And only 2/3 of that, so only 80 million of that is in your proxy advisor business. That's a decade old. It's more than that now, but you're not getting massive cash flows from that upfront investment. It's something I looked at. I mean, I sort of was like, if I had enough capital, I'd want to do this, right? I mean, I think some of our rich billionaires may want to think about doing it as a loss leader to clean up this market, perhaps, right? I mean, but that's their money, right? But I think it would be kind of a loss leader. I mean, I think you could make a profit with it. I do think the economics are going to shift. I mean, part of what J.P. Morgan announced when they said they were going to do this in-house is that AI and other technologies will enable execution of some of the nuts and bolts stuff that traditionally proxy advisors took care of at significantly lower cost than it historically has been. So that may shift.
The custodian work they do.
That's right.
Go ahead, please. Go ahead.
Yeah. So I mean, I think technology and technological developments will shift the barriers to entry here, and that could be a good thing. And so we'll see how that evolves. I mean, sometimes the market will fix problems, right? But I don't think as a legislature you'd want to assume that it's going to fix it or assume that it would fix it in a good direction. But I do think that the barriers to entry there, could drop significantly in the near future.
Thank you. That makes sense. Mr. Bledsoe, you talked about the executive order, and thank you again for your work that you were doing then, where you are now. Tell us what the response was in the industry once that executive order, the one particularly about proxy advisors and about their advice, once that landed.
Yeah, once that landed, the response that we heard was overwhelmingly positive. So a lot of conversations with major company CEOs. They'd probably be upset if I said their names, so I won't. But what we can point to, which was mentioned a couple times already today, is that Jamie Dimon himself, the CEO of J.P. Morgan Chase, came out publicly and said, so it wasn't just some press release they dropped hoping it'd get buried. This is a pretty out there public statement that he said we were no longer going to use proxy advisor services. We're going to develop our own internal system. Where that goes, I think Jim's right. We'll see. We'll watch and see. But certainly a positive signal that major companies, asset managers are taking a second look of how this decades-old industry that has dramatically shifted towards politicization is going to operate.
So thank you. And Mr. Bledsoe, Mr. Copeland, Mr. Hubbard, Mr. Babcock, thank you all for your preparation, for being here, for sharing this with us, and the work you're doing. This can be pretty dry stuff, and thank you for helping it make sense. That's right, and helping it apply to the real world, and again, to Texans and to their retirement, to their savings and their investments. And yes, we want, as Senator Perry said, we don't want to mess it up. Texas is the economic engine, and I appreciate what you said. We were talking about redomestications. It's early, and I appreciate. I wasn't offended when you said the move from Delaware. The trend is mostly theoretical, but we're encouraged. We're encouraged. So things are moving in the right direction. And again, we'd love for Delaware to clean up their act a little bit, but it's fine if they don't, because there's a place here, and the goal of Senate Bill 29, which put those changes in place, was not to put a place where management wins, where the board wins, where one side with the deck is stacked. Their goal was to provide a predictable environment. So unlike the Delaware Chancery Court, which has just become kind of all over the place, the goal was to create a place where you can risk your capital and know what the rules are. No, they're not going to change arbitrarily. If you pollute somebody's water or run over them or blow them up or your product messes up, you're going to be held accountable for that, of course. But you're going to know what the rules are, and you're going to be able to risk your capital and create jobs, and that's going to be good for everybody. So thank you all for your testimony. Thanks for being here. You're excused.
Thank you.
We turn now to election security. The Lieutenant Governor has charged the committee to study how we can strengthen the security of our elections, guarantee access for poll watchers, how our counties are administering elections, and whether anyone has attempted to circumvent the laws that the legislature has passed. Secure elections, obviously, the foundation of a representative government that we cherish. Every Texan needs to know that their vote counts, that the laws followed in every county, that the rules are the same, and that the citizens of our law entrust to watch the process can do the job that they've been given. So we've worked to protect the integrity of our elections for many sessions, and if you look at the major reforms done around the country, Texas is there. Texas has led the way, but obviously there's work to do. It's never going to be finished, and where our laws are being followed, we want that on the record. Whether they're being tested or evaded, we want to hear about it so that we can act. And so the next panel on this topic, we call Christina Adkins, Jennifer Dornoff, Ed Johnson, Chad Ennis. Because this is a large topic, so we'll be talking about election security on this panel, then we'll be talking about election efficiency. There may be a little bit of overlap, a little bit of bleed, but be aware we'll be having a similar panel for two related topics. And obviously any senator is welcome to ask any question they wish. We will go through the whole panel and then go for questions unless someone feels strongly they need to ask a question before that. Ms. Adkins, welcome back. Introduce yourself and give us your testimony.
Good morning, Mr. Chairman, members. Thank you all for inviting the Secretary of State's office to participate in the hearing today. My name is Christina Adkins, and I'm the Director of Elections for the Texas Secretary of State's office. One of the primary goals of election administration is to ensure that we have safe and secure elections. And I think it's important to note that this starts well before the election process even begins. It starts with the voter registration process. An accurate voter registration list is critical to election security, and it is foundational to having challenge-free elections within our state. When we speak about voter registration, it's important to note that list maintenance is an important component to voter registration. List maintenance is the process by which we routinely review and review our voter rolls and look at data to determine if there's any eligibility issues or residency issues with individuals that are on the voter registration list, because we want to maintain an accurate voter registration list. Texas has a very robust list maintenance process. However, we have been under the moratorium imposed by the National Voter Registration Act, or the NVRA, since December of this past year. So this summer, now that the primary runoff has completed, our counties will be engaging in their routine list maintenance activities that are required both under state and federal law, and that ensure that our voter list is accurate and up to date. A couple of things that are important to note with respect to list maintenance. Most of our list maintenance activities are defined in state law. We have Texas laws that go back 30 years that give us strict parameters on how to run this part of the voter registration and election process. We require strict matching criteria for almost every data set that we provide to our counties, or that counties review on their own. And that's because we want to ensure that these matches are identifying eligible voters and voters that are on individuals that are on our voter rolls, that we're not being overly inclusive or overly broad in the matches that voter registration list maintenance might uncover or find. That strong matching criteria means that we're typically matching on first name, last name, full 9 of Social Security, Texas driver's license number, or a combination of those two things. It's also important to note that an important part of list maintenance is understanding the protections that are in place for voters. If a voter is incorrectly identified in the list maintenance process, or a registration is canceled, and we've discovered that the underlying eligibility issue is not an issue for that individual voter, Texas law protects that voter. It says that the individual is reinstated immediately, and if it's discovered in the election process, the voter can vote a regular ballot that day. And I think it's important to note that both sides of that, the strong matching criteria combined with the protections for that voter, that individual voter, is what makes our process in Texas such a strong process. Two things to note. We have two big list maintenance activities that are coming up here. One of them is brand new. First, we are doing our duplicate matching process this summer. This is where we go through to identify potential duplicate matches across the state to ensure that we don't have registrations or individuals that are registered in multiple locations. That can sometimes happen inadvertently in the election process. The other piece of list maintenance or the other new list maintenance process, rather, that we're about to roll out to our counties is a new process related to commercial mailboxes. This is an issue that's gotten a lot of attention over the last few months. We utilized our audit program. Our audit team that we have in our office has done substantial research, and by the end of the month, we'll have reviewed all 254 counties to identify potential commercial mailboxes in each county. That list of commercial addresses will be provided to each county so that they can review it to determine accuracy with that list. And then, of course, we do have a process from Senate Bill 1111. It's one of Senator Betancourt's bills that provides a specific confirmation notice process for these individuals that are registered at a commercial mailbox, which we consider an address under Texas law that's not a valid address for registration and not a valid address for residency. A commercial mailbox address can be used for mailing purposes, but not for actual voter registration purposes. And so this is a new data set that we're about to provide out to our counties. One of the other things that I think it's important to note, and that's gotten a lot of attention, is the Secretary of State's office use of the SAVE system. In 2024, we began the process of executing an MOU with USCIS to utilize the SAVE system, and we ended up signing that MOU in March of 2025. We used SAVE on a limited basis in the spring to determine its effectiveness in validating citizenship, which is something that is an eligibility issue in Texas elections. And so we looked at it, we tested the data, we reviewed the accuracy of that data to determine how this could be used in Texas to aid our list maintenance process. And at the time, potential discussions that were being had about front-end verification for citizenship. Since that time, our office has taken the steps to proactively verify the citizenship of all Texas' current list of registered voters through this federal SAVE system. Our office took these steps in order to ensure that most currently registered voters would likely not be impacted by any future citizenship verification requirements that may be imposed, and that only eligible voters remain on our list of registered voters for the state. This also helped us identify individuals who may have mistakenly become registered through no fault of their own and allow them to be removed from the voter rolls in a timely fashion. One of the things that we have noticed over the years, I've been at the Secretary of State's office from 2012, and going all the way back to 2012, we do periodically get inquiries regarding individuals that are in the naturalization process. And oftentimes, we will get inquiries from DHS regarding registered voter status. We get inquiries from those individuals that are being naturalized, requesting verification that of their vote history to prove that they've never voted, because this is something that could impact the naturalization process. And so, anecdotally, looking at our experience at the Secretary of State's office and in talking to many of our county election officials, the great majority of the time when we see individuals that are non-citizens that are registered to vote, it's typically an error. Those voters don't even know that they're registered and are swiftly taking efforts to remove their registrations because they don't want it to impact their naturalization process or their immigration status in the United States. So this is something that can protect the overall accuracy of our voter registration list, but it also provides protections for that individual to prevent them from making a mistake or having an action taken against them that could impact their immigration status and their presence in the United States. As a result of our work, our office identified approximately 2,700 potential non-citizens. This information was sent to our counties for further review. Again, it goes back to the initial point that I was making about protections for the individual. When this data is provided to our county election officials have an obligation to review that data and make their own determination as to what information or what notices they sent out to those voters. Our counties are well-versed in the list maintenance process when it comes to non-citizens because we have been doing a list maintenance process utilizing DPS data since 2021. And so our counties receive this information, they review it, they go through their own internal records and their own internal review process to make determinations as to whether any notices should be sent out to those voters. And I will say we have been discussing this with a lot of our counties. Some of our counties have requested some additional data from our Department of Public Safety, from DPS, to aid in their validations, and DPS has been assisting us in this area. We have recently asked them, several months back, we asked them to go ahead and do a full review of that 2,700. Since our counties were in that NVRA moratorium anyway, it gave us a little bit more time to do some additional reviews based on county requests, and we expect to get that information from DPS soon, so that we can do a comparison to see what information DPS has with respect to citizenship in their records and how that compares to the SAVE system. Current Texas law, however, or let me say what I've been discussing is the list maintenance process. This is how we validate citizenship on the back end. But our current Texas law right now doesn't provide for a front-end verification process. We don't have anything other than the attestations on the voter registration application where somebody says, I am a U.S. citizen, to validate an individual citizenship status. During the 89th legislative session, Senate Bill 16 from Chairman Hughes provided a documentary proof of citizenship requirement for all individuals that are registering to vote. One of the things that SB 16 did that ties back into the SAVE work that we've done is it provided for voter registrars and for the Secretary of State's office to utilize government databases to help identify U.S. citizens and provide that documentary proof of citizenship, which means that the work that we have done in SAVE already in running our voter rolls through SAVE means that we have already done most of the heavy lifting on that bill should that legislation come back and we have a front-end requirement on citizenship verification. Most of our Texas voters won't be impacted by that because we did retain that documentation that we received when we utilized the SAVE system. And so we stand ready to work with the committee or any members on any other legislation regarding citizenship or regarding either the list maintenance or the front-end verification process. But I wanted to provide context to you on what we had done with SAVE and how it could be utilized for some of the legislation that's come before this committee. In addition to that, I think it's important, since we're talking registration, to talk about the statewide voter registration and election management database that the state utilizes, known as the TEAM system. The team system is the statewide database that we are required to maintain under both federal and state law. We are on, since team first began in the early 2000s, this is, I believe, our fourth iteration of the team system. There have been various iterations of it over the years. It used to be maintained in-house. We now have a vendor relationship that has proven to be much more effective in being able to get quicker responses and to deal with the large volume of data that the system houses. As part of our transition to the new team system, we had to migrate over 20 million voter records in addition to millions and millions and millions of street-level data and data segments to ensure accuracy within the system. This is a monumental task. A huge data conversion project like that takes a substantial amount of work, and we are still very much working through this process, in particular with our counties that we can call our offline counties, the ones that use third-party voter registration systems. That process with those counties is very much still underway we've had a lot of recent changes related to redistricting that many of these counties are still trying to get in our state system and get that accurate. The timing of the rollout of this system was very well thought out. Our intention was to do it prior to a high turnout election and to do it prior to an election in which the counties had a lot more control and a lot more organizational kind of impact on how that election was run. And so we rolled out the system last July prior to our November constitutional amendment election. 2 weeks into our rollout, we had a situation occur that we did not anticipate, and that is that one of our third-party vendors that was utilized here in Texas, a company by the name of Votech, closed their doors. And we suddenly had 24 counties that no longer had vendor support for their third-party voter registration system. Of those 24 counties, we had 11 counties that ended up completely losing access to their data. They weren't able to process registrations, they weren't able to retrieve their data from the cloud-based service, and they could not go forward with the voter registration process because all of their data was housed in a system that they no longer had access to. This is something that had a significant impact on the redevelopment project and the rollout of the team system, because we had to, in order to ensure that our state had a November constitutional amendment election, we had to completely pause redevelopment of the team system. We had to pause the phased rollout approach that we had in place and shift gears to helping these 11 counties that no longer had a functioning registration system. Typically, when a third party, or when a county transitions from a third-party vendor into the state system, that takes anywhere from 2 to 4 months to make that happen because there's a lot of data validations and a lot of data conversion that goes into that. We were posed with having to onboard 11 counties in a 6 to 8 week period. Again, something that takes 2 to 4 months per county. We had to do all 11 at the same time, the largest of which is Bexar County, a pretty substantial county. We were able to work with our vendor to bring in some extra data teams, but again, we had to pause all redevelopment efforts in order to make this happen because we had some tough choices we had to make during that time. And we chose to make sure that our state could have a constitutional amendment election, that our local jurisdictions that were going to be impacted by their elections because of the county not having access to the voter registration system, we chose to move forward to help those counties to ensure that our local cities and schools could continue to have their elections in November as well. And that is something that put us very behind in the development project for the team system, without a doubt, because we had to make this tough decision to help onboard these counties. But we did that successfully. I will say it was at no small cost. There was definitely a cost to the state. It did cost the state about $600,000, between $600,000 and $700,000 to onboard these counties. This is not a cost that was passed off to our counties. We've never charged counties for onboarding into the state system, but we did have to, make some great efforts to make that happen in the time frame that was provided. But the bigger cost there was the cost that to our counties that utilize the team system exclusively. We have 24 counties that were utilizing these third-party vendors, or about 30 counties at the time utilizing those third-party vendors, and so everybody else was utilizing the state system. And in pausing our redevelopment of that system, it put all of those counties behind. Our online counties suffered because of the work that we had to do to bring these counties into the team system. But again, it was a tough decision that we had to make, but it was the right decision to make sure that our entire state could have the election that we were required to have in November. Shortly after the November election, we also had another situation arise in which we had to divert attention away from the team rollout into to another component of the election process, and that was redistricting. As we are all aware, that our state underwent some redistricting efforts last year, and all of that data had to be converted and put into the team system. That was another large project that was not anticipated in the rollout of our new system, and so that further delayed some of the development of the system. So for the last few months, because we have gone from this situation with the VOTEC counties to redistricting, and then to a series of 7 elections that we've had since the rollout started, we have not had the time to be able to address some of the issues in our system that we would like to address, and we have not been able to roll out additional functionality and modules that our counties very much want and need. But we have had 7 successful elections with the team system now. We do have a plan in place this summer to address remaining issues. Now that we are finally through this kind of tough election season where we had so many elections back to back, we now have the ability to clear out all of the remaining kind of smaller issues and smaller tickets that I think have been driving our counties crazy because it impacts the efficiency in their day-to-day responsibilities, but we're not core critical functionality of the system, things that will improve their workflow and things that will make their lives easier. But at the time, were not core issues that we had to address. So our plan is to work through that backlog of tickets. We also, in working with our vendor in the background, while we were supporting the ongoing elections, have identified several areas where we can make improvements in the system that'll improve efficiency, improve the report generation, and ensure that our system is functioning the way it needs to with the speed that it needs to. Some of these are architectural changes within the system that we're going to roll out. Again, we could not roll these out during ongoing elections, and so we have a plan this summer to phase in some of these bigger architectural changes in the system, and from what I've seen, vastly improve some of the efficiencies that we need in the processing of data that comes into our system. In addition to that, we do have some new features that we'll be rolling out in our system. We are going to be providing a service for our counties, for our military and overseas voters. We will be incorporating into our system an electronic delivery system for them. This delivers their balloting materials to military and overseas voters. Many of our military and overseas voters that are in combat zones or hostile fire pay zones don't have access to the mail, and so it's hard for them to get a ballot mailed to them, but this will find a way to securely, electronically provide that to them. Now, that individual will still have to download that ballot and mail it back in, but we are rolling out that feature to our counties so that to try to absorb some costs that they have and make sure that our voters are getting that ballot in a very safe and secure way. In addition to that, we're incorporating intelligent mail barcoding so that voters and counties can now not just track the ballot where it is with the county, but they can track a ballot for voting by mail where it is with the USPS. We have other things that we're working on long-term. We'll be rolling GIS into our system. Those are projects that are going to be coming out later this year after we complete the hardening of our system and address the functionality issues that we need to address to make sure that our counties have a system that improves their efficiency and is safe and secure and overall supporting the mission of Texas elections. In addition to the team system, there's a few other things that I wanted to address with respect to the security side. We oftentimes get questions about poll watchers in our election process. I think poll watchers, they are observers to the election process, and they're an important part of this election process. They're appointed by candidates, political parties, sometimes specific purpose political action committees, and they're done with the purpose of maintaining security in our election process. As observers, they're there to ensure that the process is completed the way it is required to be completed under the law. They're a necessary check on the system. All poll watchers in Texas must complete the SOS prescribed training. This is a requirement that came out of Senate Bill 1 from 2021. This prescribed training that poll watchers have to complete gives them a certificate. They then have to present proof of training when they show up to do poll watching. I will say, since the legislature implemented this training requirement for poll watchers, the number of complaints that we've had regarding poll watcher behavior and the number of complaints from poll watchers regarding their access to the election process have decreased significantly. And I think this is an example of where providing requirements for training and education, both for the poll watchers and our county election officials, have made an impact in creating a better environment for our poll watchers in our counties to work together. I think one way to show that this is working is I've heard anecdotally from a lot of counties that they will have poll watchers come into the process that are new to the election process. And the more they learn about elections, the more they want to participate. And it's not uncommon to see poll watchers sometimes get converted to poll workers in future elections. And so that's been a great tool for educating members of the public on the election process that can help address potential shortages that we have in workers long term. In addition to that, and I'll be brief on these other remaining items that I have, there is another bill that has come through Senate State Affairs that's important to note, and that's Senate Bill 827. It was Senator Parker's bill related to the post-election hand count audit. This is a process by which we verify the accuracy of our voting system equipment to make sure that the electronic count matches a subsequent hand count that's done in selected locations. The changes that Senator Parker helped create with this bill provided for more efficiency in the counting process and a more accurate comparison tool so that we are counting things by location and we can see the counts for a specific location from equipment used at that location to compare it to that hand count. The changes that Senator Parker brought out with this bill also greatly expanded the hand counting process to include more hand counting and to give our office the ability to prescribe procedures so that counties can add to it on their own as well to make sure they're incorporating local needs and local concerns. And that has been very successful in the implementation in that we are seeing a lot of ballots being counted, a lot more verification taking place behind the scenes after the election process, and that's an important tool. That auditing tool is important in ensuring that our elections are accurate. We have had some feedback from counties, and I'm sure Ms. Stoynoff, who's sitting here next to me, will speak to you about some of the feedback the counties have received or the counties have provided to her. In some counties, it has resulted in substantially more counting, and so I think there are some concerns in some locations about maybe ways we can review some of the requirements there and see if there's ways that we can address some of those concerns in some of our smaller jurisdictions that in some cases have ended up having to count almost all of their ballots in a given election. In addition to that, the legislation spoke specifically to county-run elections and elections in which we had a statewide measure on the ballot. Our local elections, those provisions weren't modified. They still have this post-election hand count requirement, but it's much more robust, and it may be to our advantage to look at the policy implications of aligning the county requirements to for our local jurisdictions to make sure that it's a similar process that the local folks are having to go through when they run elections on their own. And then finally, I think it's important to address when we're talking about security. You know, we've talked a little bit about the list maintenance process and security before the election. We've talked a little bit about poll watchers, the security they provide during the election process. And now we've talked about what happens after the election, thinking about our post-election hand count audit. But it's important to note that there is kind of a greater picture there. As part of Senate Bill 1 in 2021, the Secretary of State's office was provided the ability to audit county election offices and voter registration offices. It's a randomly selected audit. We select 4 counties every 2 years for the audit process. And to date now, our office has completed 12 different county audits. I think every round of audits, we've been able to improve upon the work that we have done in the previous audit, and we have a pretty good understanding of some of the reoccurring issues that we're seeing across the state. I will say that in 2023, there was another piece of legislation, Senator Betancourt's Senate Bill 1933, that created a process to address potential issues and reoccurring patterns of problems that we see within the election process. And Senator Betancourt's 1933, one of the things that it did is it provided our office the ability to place one of our audited counties, if we deem necessary, under what we call administrative oversight. Administrative oversight, I want to be clear, is not a state takeover of the Elections or Voter Registration Office. All of that authority remains with the local entity. It is the voter registrar's responsibility to register voters. It's the county election officer, county clerk in some situations, their responsibility to maintain and run elections. So placing a county under oversight does not put the Secretary of State's office over elections. We're not performing their duties. We're not taking on those responsibilities. But what we are doing is providing monitoring, additional training, and helping to remediate issues. For the first time, we have placed one of our audited counties under administrative oversight, and that county is Valverde County. Valverde County, some of the issues that we identified in our preliminary findings and audit report that was issued in July of last year, are specific to the voter registration side of the house. It is a county in which those duties are split between two offices. The tax assessor collector takes on voter registration, county clerk takes on election responsibilities. Prior to even auditing Val Verde County, we have known that there are some issues in Val Verde that we have attempted to help the county address with respect to voter registration. Going back to 2023, before this county was even selected, we had gone on site to that county to help them deal with jurisdictional boundary lines, some issues that they had where they were not maintaining those in the system, and to talk to them about workflow and process, because we were seeing that registrations were not being processed in a timely fashion, specifically those related to elections, updates through the statement of residence process, provisional voting process, and that we were seeing cancellations that were not happening at the appropriate time in the election process. And so we've done work twice on the ground with Val Verde leading up to this, and then the audit process showed us that some of those issues were continuing on in the county. What I will say to Val Verde County's credit is that they have been very receptive to the feedback that we've provided. Oftentimes, when we see county election offices or county voter registration offices that are struggling with some of the requirements that are imposed on them by Texas law, it can be because of needs for additional training. It could be because the county needs to provide more funding to an office. There are a lot of different things that contribute to that. But I will say, with this spotlight that we've shown, we've been able to shine rather on the Val Verde County voter registration process, the county has very willingly worked with us to try to resolve these issues. In fact, they've worked on creating a new policy manual for the office that our team is reviewing for them. And so we see this as the ability to help remediate these issues and get the county up to speed with where they need to be, because that's in the best interest of the voters within that community. And so we appreciate their willingness to work with us, that they have been receptive to this administrative oversight process. And I think it gives them the ability to make the necessary changes that they need to make in order to be compliant with Texas law, that sometimes it's hard to do. It's hard to do that locally. And this has given us the ability to give them that assistance that they need. And so election security and making sure that we have our secure elections, I think it's important to note. It starts before the election, it happens during the election process, and of course, with all of the tools that the legislature has given us on auditing our elections, in reviewing election data, that's how we ensure that the security process is maintained throughout the election and voter registration process, so that we can build on that and identify new and improved best practices and procedures to help us have strong elections in Texas.
Thank you, Ms. Atkins. We'll have questions for you after we hear from the rest of the panel. Thank you for your testimony. Mr. Dornoff, welcome. Introduce yourself and go ahead.
Thank you, Chairman Hughes and members of the committee. I'm Jennifer Doynoff. I'm the Hays County Election Administrator and also the Legislative Chair for Texas Association of County Election Officials, and I really appreciate the opportunity to be an invited guest today to talk to you about maintaining election security in Texas. The legislature has taken major steps in 2021 to improve election security over voter confidence in Texas election. Our state leads the way in safe and fair elections, something we're all very proud of. In Texas, county election officials believe it's important to highlight major changes in Texas law from the past few sessions. As Christina has said, this body and the legislature have passed a lot of really good laws that have secured our elections, and we just want to highlight a few of those. You've already heard Senate Bill 1 is one of the laws that we believe helps strengthen Texas elections. It requires ID requirements for mail ballots. It standardized early voting and gave authority and more clarity, better defined poll watcher access in the polling location, and then also established the use of reconciliation forms, which is very important to the process, transparency. These forms are put on every county's website, and it's a comparison of voters that have checked in with votes that have been tallied in the polling location. And I believe a lot of counties are actually using this in their canvass process with their commissioners' court to also give some comfort to the commissioners when they're canvassing an election. In 2025, the legislature made several important reforms to pre- and post-election audits, and we appreciate that. That would be Senate Bill 2166 and Senate Bill 827, which you heard a little bit about. 2166 helped define clarity in the logic and accuracy testing that we do before an election, which is our pre-election audit process. It helped define the representative sample, which was always kind of a term people threw out there, but nobody really knew what it meant. It also requires now that poll books be tested as well. And I think that gives some comfort to the voters in our areas as well. And then Senate Bill 827, improve the post-election hand count audit, which we effectively refer to now as the PECA or PCA, depends on what county you're in. And it did that in all the ways that Ms. Atkins talked about, but also one thing I didn't hear was that the early voting ballot board now conducts that count. And I think it really helps with transparency and also having other people come in to see and oversee that process. And then it also allowed counting by location, which you heard, and then also allows local authorities to expand that should they need to look further into any races. And then last session, 2217, built on Senate Bill 1 by ensuring that 30 days after an election, the county must do another reconciliation process by location that looks at voters that checked into the location, voters that voted at the location, and then makes comments on any discrepancies. And that is also on the website of every county. From TASIO, Texas Association of County Election Officials perspective, one of the most important bills passed in recent years was Senate Bill 1540 by Senator Betancourt. This is the bill that protects personal information of election officials and their employees by helping ensure it remains confidential. As was testified in the 89th session, there are numerous election officials, poll workers, and volunteers who have been threatened for their work in elections, and that's something that should never happen. During the most recent primary, some administrators were forced to stay in hotels with sheriff deputy staff nearby due to threats that they received. So there are some things that we would like to and have met with Senator Betancourt's office to maybe expand this a little bit further. County election officials look forward to continued partnership with the legislature and Secretary of State to improve election security. As the committee starts thinking about the next session, county election officials have identified a few areas in the election code that may need further legislative consideration. Ballot privacy still remains to be an issue that we would like to talk about. Election officials have concerns for voters across Texas. Several bills were introduced that address ballot privacy issues in the last session, but no law passed. Currently, the main tool counties have to protect is redaction. With redaction is better, but it is not foolproof due to human error and the sheer workload of redacting potentially thousands of data points. And then if you have somebody requesting from different offices and the same redactions aren't made, that further complicates the process. This is ballot privacy issues remain in all elections, regardless of the size or whether you utilize countywide or precinct-based. Some potential solutions discussed in 2024 interim hearings by the Secretary of State and county election officials were aggregated precinct reporting in hyper low turnout elections, increasing the timeline for certain election records to be released, and reviewing information must jointly be published by the Secretary of State and the counties to make sure that we're redacting the same way. Fail-safe voting also remains to be something that we need to address. Under current law, if a voter moves within the county, there are certain processes where voters are not supposed to be voting in those local elections. But to carry out this process is almost impossible for most counties, and also can lead to more ballot privacy issues. So we definitely want to continue to talk about fail-safe voting. And then further clarification, excuse me, on the post-election hand count recount process. Currently, there is no statutory process for a post-election audit of hand-counted elections. Given the growing interest in some counties in hand-counting election results, we believe there should be an audit of hand-counted elections. And part of the reason is because under 2217, we do have to do that reconciliation of votes that were counted and voters that checked in, and we have to describe discrepancies. And currently in a hand-counted election, there's no way to do that. So we do believe that there should be an audit process for hand-counted elections as well. We have some areas that we have spoken with Senator Parker's office on refinement areas for Senate Bill 827. For example, I think you heard this in Christina's testimony. In May elections, the processes are not aligned, and we're counting pretty much the full ballot. And a lot of times, it's a full recount in a May election. And the particular issue with that is, in even years, that timeline runs into a primary timeline. So you're doing that. All of that is overlapping. So we'd like to talk more about that. We'd like to talk more about a more equitable solution for how many ballots counties are counting, because 3 locations in a lot of counties that don't even have 3 locations doesn't equal to the same thing as 3 locations in Harris County, Dallas County, or bigger counties. So we would like to talk a little bit more about how to make a more equitable solution for that. And then now we're going to talk a little bit about team. For over a year now, counties have been working diligently with the Secretary of State to implement the new team system. Texas Association of County Election Officials acknowledges that the Secretary of State has faced significant operational hurdles throughout the implementation process. Counties have navigated challenges with team now spread across at least 4 elections. Some counties have had a lot more than that. And many of these issues have increased administrative burdens on county election officials, affecting other aspects of the election process. The Secretary of State's office and many counties communicate daily about the issues election officials are navigating. And Texas Association of County Election Officials recognizes the substantial role that Civics, the vendor, plays in implementing team and resolving potential issues. Some of the issues that counties have raised are issues with the accuracy of their official report, their official list of registered voters, which is different than all registered voters. That's the list specific that we use for programming for elections, and some inaccuracies there. And then also some significant issues with the ballot by mail module and how that's working. Again, this morning, I did hear that some counties were having issues with newly registered voters that didn't have EDR dates or effective dates of registration. We all know that a well-functioning team is integral in safety and security in Texas elections, and Texas Association of County Election Officials looks forward to our continued partnership with the Secretary of State's office, Civics, and this committee to identify and resolve these challenges. Election security is extremely important for all Texas election officials, and it's something our membership and profession take very seriously. Thank you for your time, and I'm happy to answer questions.
And thanks for your testimony. Mr. Ennis, welcome.
Thank you.
Even though we know you, introduce yourself and give us your testimony.
Thank you, Chairman Hughes. Chad Ennis, Honest Elections Project. Really be happy to be here back in front of this committee after a few years away. So I think Jennifer laid out some great things that you guys have done in the last few sessions to make our elections more secure. I want to talk about 3 things that actually this committee has passed and the Senate has passed, but we haven't been able to get them to the governor. So they're still important things and really important to election security and things we need to get over the finish line. Christina talked a little bit about documented proof of citizenship. And in last session, that was SB 16, passed out of this committee, passed by the Senate, didn't quite get it to the governor. But there is still a need for documentary proof of citizenship when someone registers to vote. I'm going to give you a few, draw out and look at nationwide, and then we'll zoom in on Texas. But Ohio has been a very big leader on this. They located 597 voters who are not citizens on their rolls, and 138 of them had actually voted. So 138. In 2024, Virginia discovered over 1,600 non-citizens on their rolls. They had to fight all the way to the Supreme Court to take them off their rolls, but they did, and now their rolls are better. Here in Texas, Secretary of State's office has been working on this issue. They've referred 33 potential non-citizens to the Attorney General and have identified 2,700 potential non-citizens that they've sent down to the counties for investigation. Those are big numbers, and they don't maybe sound initially like big numbers, But the Public Interest Legal Foundation has a database that will tell you tied races or races decided by one vote. Since 2002, in the United States, there have been 1,367 elections that ended in ties, and 527 decided by one vote. Here in Texas, we've had 13 ties, or 11 ties, and 13 or 2 more additional ones for a total of 13. That gets you to which were within one vote. So really having people on the rolls that aren't supposed to be there really matters, and it's important. So getting back to SB 16, SB 16 has gotten some criticism for being done in a certain way, but I want to tell you why the bill is set up in the way it is, because I think it's important to understand. Christina mentioned some problems with how the MVRA kind of ties our hands, the state of Texas anyway, as we look at these issues. And this is a place where the NVRA really ties your hands and like throws you in the water weighted down by concrete blocks. The NVRA created the federal form for voter registration. Federal form, it's one form that's supposed to work all across the country, one form to rule them all. And the problem is, you know, some states want to do more, some states want to do less on registering to vote. The NVRA does not require any proof of, or the federal form for voter registration does not require any proof of citizenship when you use it. You just check a box, and then you say, I'm a citizen, and then you get registered. And, well, you say, why can't we stop it right there? Well, there's a Supreme Court case that says, no, you can't stop it right there. You have to accept and use the form. Accept and use means that we're going to have to register that person to vote. And then if the Secretary of State determines that this is a non-citizen that inadvertently registered to vote, they're going to have to go through the process to take that person off, which is a much longer process than simply not allowing them to ever register. So, but that's only a problem for federal elections. The federal government can tell you guys what to do for federal elections, but they can't tell y'all what to do for state elections. So that creates an opportunity as well, at least to fix some of the problem. So you can run a state system of voter registration, which we do, and require documentary proof of citizenship. We already do this for most folks that register. I think close to 85% who register at the DMV. They're going to prove their citizenship right there. That's not the only way, though. We have databases that can be checked. The Trump administration has made it much easier to check, to prove citizenship at the state level through the use of the SAVE database and other databases. So it's a different even world than you guys were faced with in the last session, the last main session. So then you're left with these folks that register with the federal form but don't provide any proof of citizenship. In that case, you can, again, check the databases. Maybe we can prove citizenship by just checking the Social Security number, the driver's license number, these kinds of things. That's hopefully the plan. If you can't prove citizenship that way, you go to the voter, the last source of information as a last resort, and say, hey, please provide us some documentation that you're a citizen. And it works pretty easily. Arizona has this system. Utah has just started to go down this path as well. So it's a tried and true method. And then moving on, if we can't confirm citizenship or non-citizenship of that voter who used the federal form, we say, okay, feds, you can only tell us what to do in federal elections, so you will become a federal-only voter. And when we were developing this bill, I think with input from Jennifer and input from Christina, I think we thought of a great way to do that here in Texas would just be to create a precinct for a federal-only voter. The people who are only federal-only will be in a special precinct for their congressional district, and they'll be allowed to vote for Senate and Congress and nothing more. But the bill also builds in significant protections, and I think this is where Texas was really smart, by having a voter who comes in on election day and is on the federal-only list. They'll vote provisionally. They can vote the entire ballot. They'll vote it provisionally. then they have the provisional time to come back and prove their citizenship, giving them the chance to get that full ballot and hopefully get the information that the state needs into the voter rolls, and we get some cleaning of the voter rolls that way as well. So other states are taking different ways, but I think really the Virginia or the Arizona method, which this is based on, is the best way. There's currently a cert petition. They've had parts of it enjoined, but there's a cert petition going up to the Supreme Court. So I think it would make a lot of sense for Texas to go ahead and get this in place. So when the Supreme Court rules on it, they're ready to go. Well, that's the first thing that we didn't quite get over the finish line last session. I've got two more smaller ones, but not any less important. And you guys heard, this committee heard Senate Bill 2035 last session. This is the ban on foreign funding into ballot measures. It is illegal at the federal level to give foreign money to candidates, and you guys can't take money from foreign candidate or from foreign nationals for many different things. But there's a loophole for ballot issues. Federal law applies to elections, and ballot issues measures where you don't have people involved are not considered elections and therefore not subject to a federal ban. And this is a real problem. There's a Swiss billionaire, Hansborg Weiss, who spent $130 million gave $130 million to the Arabella Networks. Arabella Networks has changed their name, but they're a big left-wing advocacy group, and they've given, I said that backwards. Hansborg Weiss, I understated it, which I shouldn't do. Hansborg Weiss has given $280 million to Arabella, $280 million, and Arabella has turned around and given $133 million or so, $130 million to ballot issue campaigns in 26 states, including $100,000 in Texas to an Austin local measure. In 2024, Ohio was the first state to pass this. Since then, 11 states have passed a ban. And I think you'll see, and what worries me for Texas is that as that money is pushed down out of those states, the more money will come to Texas, and we will have a problem. So 2035 is a pretty simple model. Basically, you prohibit directly giving to a ballot campaign by a foreign national, and you also prohibit indirect giving, that giving where I give to one group and the group gives to the ballot measure. Also, same thing, direct and indirect contributions to independent expenditures. With those, we don't want either from foreign nationals. And then also some donor disclosures, or donor disclosure protections. So when these cases do get litigated, all the donors to a certain ballot campaign lose their privacy. Finally, an issue near and dear to my heart is, as many of you know, I for Secretary of Scott, started the audit division at the Texas Secretary of State and performed the first couple of the audits that, the first handful of audits that Ms. Atkins described. And last session, you all passed 1863, Senate Bill 1863, which strengthened the audit process. And I think that's another good issue to get election security more at the forefront. It required more audits. Right now, it's required to do 4 audits every 2 years in 2 big counties and 2 small counties. Well, if you're a small county, that's pretty good odds. That's pretty good odds you're not going to get audited. So it expands the number of audits. It clarifies, which wasn't clear in the statute, that even that if you're auditing a county, even that school board election run by the school board should be audited as well. I think the Secretary of State's doing that, but I think it needs to be clarified in the statute that those need to be covered. The statute is also, as it exists, not very specific on what should be audited. So I think y'all can put some real good teeth into that and say audit the voter registration list, audit the procedures for testing voting equipment, chain of custody documents, and provisional ballots and mail ballots. It requires cooperation by the audited parties. Some of you might remember when I audited Harris County, we had a bit of sometimes not wanting to provide documents or help And really all that I could do to get compliance was try to be really nice. There needs to be some teeth in there, so when someone's being audited, then the Secretary of State says, I want to see this document, that they get it in a quickly and timely fashion. There's some stuff that gives in that bill that allows the counties time to review the audit findings and respond ahead of time. I think that's a good thing. And it requires a public report. But those are three things that you guys have passed in the past, sometimes multiple times. They're still important, and I hope going into the next session, those are places y'all look to legislate as well. Thanks.
Thanks, Mr. Ennis. Thanks for your testimony. We'll have questions for you after the panel. Mr. Johnson, welcome back. Introduce yourself. Give us your testimony.
Ed Johnson. I'm with the Harris County Ballot Security. And I'm going to get my iPad back up here. Y'all have heard a lot of my testimony already, so I'm just going to kind of play a history and best practices coach here from what I've seen in the past. To start with, one of the issues in this thing was the poll watchers. Still have problems with poll watchers, and actually it's on both sides of the aisle. I personally think that we need to look at the authority given to an election judge. For one day, they get to be the same authority as a district judge, which is a lot of authority, and that tends to lead to lots of confrontations. That's one I think you should look at. The other bigger overarching for ballot election integrity, ballot security, all that other, is the enforcement of election laws. We have, you just heard, we have a lot of great election laws that y'all have passed. We have, plugged just about every hole you can think of. Problem is, it never gets enforced. And that is a big problem. Senator Betancourt had a bill last session, my glasses on here.
Senate Bill 2020.
It was 2020? Okay, thank you. It was, all right, so it was a Marshall's bill, and it would create a statewide expedition to get things to a court fast, to get, some authority into a polling location that was trained to, supervise the situation so they don't get out of hand and don't blow up. That would be a huge tool to have better elections and for, better integrity to actually force these laws. One that was mentioned earlier was your Senate, was it Senate Bill 16, separation of elections. We lost the national, FPCAs, federal postcard applications, actually is a huge problem, or getting to be a bigger problem. This is when you're overseas, how you apply to vote. There is zero validation that you are who you say you are or where you are. So we have people overseas mailing us applications that you, even if you know they weren't a citizen or know they don't live here, you're still forced by federal law to send them a ballot. If we separated that into a state and federal, you could send them just the federal ballot and not the state. You could have tougher requirements there for the state. Harris County last election lost a statewide court due to the FPCA slipping it. Republican won, FPCAs, because you have 5 days for them to come in, changed that race. So it is an issue, and it is actually becoming more of an issue every time. That's one I would hope we could look into. The Secretary of State over here is doing a great job, trying to clean the voter roll and doing this. The mechanism, the actual, physical force of this is the counties. They're the ones that she said, Christina said she sends a report to these counties and they're supposed to act on it. Well, if they don't do it, it doesn't get fixed. And she really doesn't have that much of a tool or a strong tool to do it. And we need to set guidelines. She can withhold Chapter 19 funds, which are funds that are provided for election support help for workers. But I think y'all should look at specific guidelines of events that happen that she shall do this and not make it into their discretion of what is an infraction and what isn't. We need to define that better. And on the Chapter 19 funds, this was something that was created in the 1950s as a funding mechanism for helping during election times register. It has never increased since the 1950s when it was created. If the state wants to have some authority and be able to have the big stick to do it, we should look at the funding of Chapter 19, because you could withhold that from a county and that would get their attention. Right now, it's getting so low, some counties really don't even care if they get it or not anymore. So that's another one we should look at. Is it worth helping ensure we have good election workers in there? On her team problem, you got to remember, Chapter 19 is paying for these employees at minimum wage. The people you have entering your data and typing those cards are minimum wage people that couldn't get a job at Burger King. This is the problem. You will see. I have a letter I'll pass out here in a second. Lee County, where I spend a lot of my time at my ranch, they had problems sending their data in, voter history data in, and getting it to upload, and it was told because it had too many spaces in the characters and things like that. When you have this low quality temporary working staff entering this, you end up with data problems, and that just spreads the problem on down the line. So it's something that I would really hope you all could look at, of trying to increase the quality of workers, and also give the Secretary of State authority to enforce these things. We were talking about the hand recounts, where we're hand counting the paper in some counties. I can give you an example. Briscoe Kane had a primary runoff race, and it was in the teens vote different, 10, 15 votes different between, of course, his opponent. Briscoe was winning. His opponent wanted a recount. He wanted a recount by paper. And at that time, Harris County was on a direct electronic machine, so what you did is you exported a print file out of the machine, and then you printed that paper. Well, on a text file, you can do a word search. And before we handed, and these are two teams that we knew of people recounting a couple of thousand votes, we did a word search for each name, and we knew exactly how many votes, how many net times that name was appearing on these pieces of paper. It took them 5 times to recount it to get the correct answer. They were off by as many as 10 votes sometimes when they were doing this. So hand count recounts really need to be audited, because it is very easy to make little bitty errors, especially when you do a lot of that. So I think that would be a great thing to do. Jumping down to the team system, if I could give this to the clerk, you could pass them around. This is from the local county judge in Lee County, where I was kind of helping with some races. Had extreme problems, this is on the political side, of getting voter history out of the team system. I would look at it, and I was helping with some Lee County races, and they would have 150 voters one day, and you go to the website, and the website would show 5 voters. I was told that it was a problem with, the data not being in the correct format, too many spaces and things like that. I think we really need to ask the team vendors to try to scrub this stuff before they import it. Ones that when I was working for the best tax collector assessor ever in Harris County, over there, we went through a data conversion from a mainframe to a network PC system, and it took 2 years. We ran in parallel a lot of times. Another good practice is you should roll out changes to a small county first on a small election, test it, make sure it works before you let them roll it out statewide. It solves a lot of frustration. And I've heard from a lot of these counties, there is tremendous frustration out there of not being able to get, data entered. I'm looking at voter history online that's not correct. You had all the counties actually had to create sites on their website to post their voter history so they would be compliant with state law. The ballot by mail tracking process had problems. You couldn't, you would get different answers every time when you would go to the Secretary of State site a lot on the ballot tracking by mail, which caused counties to actually put that onto their own websites too. So that's frustration for that county and cost to them. But the really big one is really frustrating to voters. And it really lackens their confidence. So I would almost encourage the Secretary of State in the next bidding process, or when they do this, is to have some kind of parallel testing built into the bid, and a eased rollout so you can make sure you catch problems before they happen. And you're going to always have problems. Being there, I've seen and done it. The other one that I would say that you would never do is make any changes to your election software 90 days before an election. The world's greatest tax collector assessor made that a law in the office of we are not changing anything before this election, because that has a trickle-down effect to the local counties too, because it messes up their software. It could affect their software and cause them problems also. So these are some good practices that hopefully maybe Secretary of State or y'all could look at to try to get implemented in here. So I think that's for topic A, about everything I had.
Thanks, Mr. Johnson. Senator Hall, you're recognized.
Thank you, Mr. Chairman. And first I want to thank Jennifer and Christina for working with me and my office with the attitude of how can we make this better rather than trying to defend the status quo, which is I get from so many people, well, we don't want to change anything. I really appreciate that. The question I had is, we've got another panel coming up. Do each of you have a separate statement for this next panel from this one? Okay, because my question is I'm kind of having a hard time distinguishing between one versus the other here.
It won't hurt to cover what you want to now, but we'll always have a crack at it on the next panel. If you let this one pass, it's not the last train out of town. So
okay.
Whatever you prefer, it's really either way.
Actually, there's like 6 trains on the next one that will go out of town with you, Bob. So.
Oh, okay. So I do have a few questions here that this is timely to do. One, I just want to go back to what you were talking about, the issues that we have with our voting rolls, and as we move forward, and how do we make sure that we don't have this third party problem anymore in the future, and how do we have a system where there's more than one set or one organization that's really looking at the voter roll to validate that the voter roll is accurate? And I ask that question because I've had numerous people from various counties come to me, and their story is all the same. We got a copy of our voter roll for the county, and look what we found. And they have, 20 people, 30 people living at the same address. They have people with an address in a convenience store or a mailbox kind of place. Or I found my grandmother, my aunt, and one of my cousins, all who died 6, 7, 8 years ago, still on the voter rolls. That kind of thing that they were bringing in overall. It's like nobody was looking at it in there. How do we go forward so that we make sure we have a high degree of confidence, and that includes the concerns of people. I know you're going through some pains with teams and other things like that, and that's fine. Just so as long as our vision is out there when we get there, we have this confidence that the voting, if you got somebody got it and they did an audit of it, they would find Fred and Nancy living at 17 Maple Street, and that was it, and that's where they lived, and nobody living in the FedEx mailbox down here. So,
Yes, sir. Senator, that's a very big question. So I think to start with, I think we have to acknowledge that the model that we have in Texas right now is we have this requirement for a statewide voter registration database, an election, and full-on election management system. It's much bigger than just voter registration. And for many years, we have allowed counties to use their own third-party vendors. And I will tell you, initially, when we first rolled out the statewide voter registration system back in the early 2000s, that was absolutely necessary because of capacity issues, because of technology issues. And so initially, that was an important piece that we allowed for that, and that we provide ways to validate that data and ensure that we have the correct and accurate transfer of data between county and state. Over the years, the number of counties that utilize these third-party vendors it's gone down, and that's because the state system has improved over the years. We know more now. Technology's improved. We have, been able to handle capacity issues as as the technology has, improved over the years. The difficulty in that scenario, and this has been the case the entire time, the difficulty in having third-party vendors where counties maintain voter registration locally is that you will almost never have perfect alignment between the two systems. Things change all the time. And it's, unless you have a county that's doing everything in parallel, doing everything in their third-party system and doing it in the state system at the same time, there's always going to be data discrepancies there. That's just an inevitability of the systems. And we have worked very hard with our counties over the years. Some of our counties have done a great job in trying to address the discrepancies between their local system and the state system. I think that issue right now is getting a lot of attention because of the recent redistricting efforts, because our counties that have third-party systems went and did redistricting in their local system, and now they have to align it with the state system. And that's been a challenge. And I think, folks are under the impression that if it's accurate in my local system, that's all that matters. And I will say, for voting purposes, to ensure that voters are getting the right ballot and we have accurate elections and accurate results, that's correct. Locally, if the data is right locally, and that's what we're building our election off of, then we know that we're having accurate elections. But from a data standpoint, and making sure that what is consistent across the state and what matches in the state system, which is where all of our big entities come to with data requests, the RNC, the DNC, all of the big data consultants come and get the data from the state. If that data is not right in the state system, then we're going to have a problem because it's not an accurate representation of what transpired in that particular county. And so that data alignment issue is a problem. And that's something we are working very, very hard with our counties, our offline counties with right now. We still have leftover issues from redistricting that we are still trying to get that data right in our system. We're very, very confident by the end of the summer, working individually with these different counties, that data alignment will be where it needs to be. But it is very labor intensive, this work. And it's something that if we're going to continue this model where we have these third-party vendors, where counties have that ability to run things locally and then they're required to match it with the state system, if that's the model that we're going to continue with in Texas, we can support that. But I think I definitely need more technical folks in our office to help with that data alignment and to help with maintaining those systems. Because there are days where we spend 60 or 70% of our time at the state working just with those offline counties. That means that's work we're not spending with our counties that just exclusively utilize the team system. And so it's doable, but it's quite a bit of work. And, it can be done. It takes quite a bit of effort.
Well, as we go forward here, as you're looking at those things that are coming up here, if there's a path we need to take that's different than what we're taking to do something of whatever it is, come talk. Let's talk about it, because we need to get this right. It's something that's so fundamental to the voting process that we need to have the voter list that we have.
Yes, sir.
Blind, not blind, but knowledgeable belief that it is truly accurate in there. So we would. Yes,
Senator, can make a comment here. One of the other big things that has changed, where you're talking about, voters that see multiple people registered at a house. In the Texas Election Code, it says if you have personal knowledge of, someone that doesn't live there, someone that's not alive, could be deceased, you could challenge them. The legal and some legal interpretations now is that the only people that have personal knowledge are relatives. So in Harris County, we have put out great efforts to go and try to identify these people that don't live in there anymore, 100,000 records, and we submit them to the voter registrar, and they tell us, you don't have personal knowledge. You can't do this. So we really need y'all to redefine or come up with a definition of what is personal knowledge, so that you can actually go in and pursue, if someone doesn't live there, you could pursue challenging them and put them on suspense, that you could, get them registered in the correct location.
Okay, that's what we need to do. Anybody else on that? If not,
I was going to say the same thing, that there's processes in place. So if you do identify that somebody is not at a eligible address, or there's the challenge process, which I know a lot of counties have been doing. Also, we do have local citizens that check and scrub our voter rolls for both parties. So that's also a good way to handle it from that aspect too.
Okay. With all of what we saw in this last year in particular, with election after election after election going on, overlapping, following up, and so on, why would we not consider seriously going to a single voting period each year? If you got something up, whatever it is, whether it's city, county, bonds, school boards, state, or whatever it is, it's all done at the same time. That one time from whatever it is, the May to November, whatever the dates are, a single voting period, get it in there. We saw very poor turnout at a lot of elections. I really believe because we had so many going and people were confused, they didn't know who was voting when and when early voting was on election day for them, some of them overlapping even. What are your thoughts on going to? And I'd like to hear from each of you.
Well, I can start. First of all, going back a bit to something Jennifer hit on, I think one thing this body could do that would be very helpful is open up the number of data sources that can be used for list maintenance, and really say, look, we've got commercial data, we've got state data, we've got federal data. Allow the counties and the Secretary of State to utilize that data for list maintenance. Now, they still have to go through strong matches, as Christina said earlier. You can't just throw people off. But at least you begin to get indications of when people moved or moved or died or all of these things, and you can get the rolls clean because the data is out there. We just need to tap into it. With your second point about election days, how we have too many elections, I totally agree. And the next page in my outline is that exact thing to talk about in the next section. But I can certainly give you a preview, because you're absolutely right. We have too many elections, and it causes several problems. The low turnout problem you mentioned earlier. Also, you put tremendous stress on these individuals over here on my left by having to continually run elections when you consider 2 weeks of early voting, long time for mail-in ballots. It stresses the system, and the more times you do elections, the more chances there's going to be for you to make a mistake. So you guys passed a bill last session that actually did that, got everything down to November, plus primaries and specials as needed. But that is a wonderful way to do a lot of good things.
Okay.
I'll be happy to go next. On your question about the continuing voting period, one of the big
it isn't continuing. It's just a single voting period each year.
Yeah.
No matter what it is, it's on board for that.
Correct. So we're talking about everybody in November, correct? This is what you're talking about, having one voting period.
Right.
And that actually, statistically, it shows it increases the turnout from a 3% turnout to about a 30% turnout, 30 to 40% turnout in the small entity elections. And if we need to work on the, I guess, rental structure of how you pay for this, because a lot of small entities, small little cities, and like in large counties, small little cities like Harrison and places, I live in the little city of Bunker Hill, And if we were to join Harris County's elections, well, now we're paying for a percentage of the whole county's election, and it's only one, the city's only one precinct in size. It's only 3,000 voters. So really need to look at how counties can charge entities for going in joint with an election, because right now, for some of the really small districts, it's more, it costs them more money than it does save them money, because now they're paying a percentage of this larger, this huge election, instead of just their one little precinct. So that's something that y'all can maybe look at.
Okay, and what you just said there is what I'm asking for is when we talk about doing something to improve the system, and we have something in place over here that somebody, well, this is going to keep us from doing it because we have to do this. We need to know what that is, because a lot of this stuff got put in place that nobody had any idea why. Somebody just dreamed it up and threw it on. I mean, our election systems for folks long before we got here that worshiped the word convenience and didn't even know how to spell the word security got us into the mess we're in. And we got to make sure that we are not, and efficiency is just a first cousin to convenience. We want to be efficient, but we don't want to give up security for it. But those things like that, if you would come talk to us about, okay, we want to do this, then we got to fix this, this, and this behind it.
When Senator Betancourt was tax collector assessor, we had 4 actual voting periods across the state. And there were some voters that were having to go to over 6 to 7 different polling locations on election day to vote in all the different districts that they were in, MUD, cities, schools. You go down the list, because they were all holding separate elections, which was extremely frustrating to voters. So your idea is best for voters, to help them. We need to work on the financial part of it to make it to where the entities can afford it.
Okay, but remember, one of the things I get from the counties, with all these elections, it costs us a whole bunch of money because we got to do this over and over and over again, sometimes 3 or 4 times. This is one. It's just a longer ballot. It's what it is.
No, it's actually more efficient and should cost less.
That's what I meant. That's the point. It would be a cost savings and a worker fatigue, which gets me down to the next question, unless somebody else had a comment on that. Yes.
I have one other comment on that. We've had a lot of discussions, I think, in the community right now about this idea of election consolidation. It's coming up. It's come up in other legislative hearings, having fewer election dates. Mr. Johnson talked about maybe thinking about this from a legislative perspective on how we can cap the costs for local election officials so that it's not going to cost them more to do an election in November, for example, if that's what the legislature settles on. But there are kind of 2 other points I'd like to bring up with that. The second is that right now, only our elections administrators have a duty to contract with our local entities in all circumstances. And if there is a push to try to consolidate election dates, that's something else to think about, is perhaps imposing requirements on our county clerks that they are willing to contract with those local folks to ensure that local folks aren't having to run things on their own, apart and away from the county office if they want to contract with the county. And then the other thing that I think folks don't realize that creates a lot of time and energy, or draws a lot of time and energy from our local election officials, are elections for our home rule cities that have vacancies. Under our Texas Constitution, these cities have to have an election within 120 days of the vacancy. Right now, that doesn't even get you to a uniform election date in many circumstances. And then they have a majority vote requirement, so there might be a runoff election. So our cities are having to have an election and then a runoff election. And a good example actually is the city of Houston just had a situation where they were staggering elections with the primary, the May uniform date, the primary runoff. I mean, I think they had 4 elections all right there, and they all were separate from each other. And so there is another thing to consider, is for those local entities, for those cities that have this constitutional requirement. I just want to make the committee aware that there may be a need to talk about
that's exactly what I'm talking about. It's one of those things, there's no good reason for it. It's just the legislature requires it. And if that being the case, that's what we're here for, is to unrequire those things that don't serve a meaningful purpose on their own. It's just the way it was done to make sure it happened, and it was done independent of all the other stuff coming on in there. Anybody else on that? Yes, Jennifer.
I'm going to, just for a minute, be the devil's advocate here. So our association is about 50-50 split on this issue. And the reason is because I think it is longer ballots, but particularly when we're talking about all the cities on one ballot, all the cities doing charter amendment elections. That causes ballots that have a reaction to the voters, voter fatigue. Voters don't want to go down the ballot. That's a lot of reading. We saw it in the last constitutional amendment election. So I think that's where we're coming from. Also, I do want to mention there are models for cost allocation that is more equitable. For if everybody was in November, it would be a more equitable cost. So I think that's a training issue that we can also touch on.
All right.
And share with you.
I'll just say one thing to that. The potential for voter fatigue when you get a long ballot is certainly there. But we're comparing that to, need to not forget, a 5% turnout election in May. It's voter fatigue not even showing up at all.
Right.
So at least if you get them in there in November at a 40, 50, 60% clip, some of them, the people who care, will gut it out and get through that ballot.
Okay, thank you. And the first cousin to that, a lot of discussion I had was, again, worker fatigue, and is the length of our voting period almost 3 weeks long right now. Do we really need that? Could we not accomplish this in a week, 10 days, 12 days, 6 days? What are your thoughts on a shorter overall voting period? Ed?
So actually, we did the math on this when I used to work in the county clerk's office under Stan Stanart. In fact, I had a conversation this weekend over when we were redoing it. Probably you have 1.5 million voters in Harris County, probably 1.6 million this next November election, and to vote them, in a week time, you would probably need at least 100 early voting locations, which they currently have ramped up to now, maybe a little more than that. But shortening it to a week would actually save the county a lot of money, because they're almost running 100 polling locations now, and then you would just, it's the access to the facilities. You're almost need some kind of legislation from y'all mandating schools, large schools, facilities be open for this early voting period, so you can spread them around the county adequately to cover this. But you would need about a week to handle all the early vote. Okay,
and I think that's the point I'm getting at, is a week is adequate. We just need to make a few other changes there to make that possible, because I visit an awful lot of polling locations, and I very seldom ever see a line that's very long at them. And I've been a judge, and I've sat there, cobwebs almost growing between voters showing up in a smaller county.
Well, I mean, and that's what the data shows, Senator Hall. You see, day one of early voting is a huge spike of people, and then it trickles off pretty good. You catch a little on the weekends in that. We've polled this actually at Honest Elections Project a few years ago to look to kind of where the public is. And you can imagine if you say, you've got Virginia, who has 42 days of early voting, which is insane. But you can kind of see the tail, and you ask them how long you kind of satisfy, and you see a bell curve, right? And the bell curve actually falls about where Texas is, which is about 2 weeks. Most people say, and I think you get up to even like 80%, like that 2 weeks, with excuse-based mail balloting, not, no excuse blasting out ballots. It's like, we like that kind of system. I think there's room to shorten it, probably a little more to a week or so, and especially if you get those weekends in there and a few things like that people find very convenient. But, I think it's something that this body should consider.
Okay. Yeah, I think about if it's a week, whatever day of the week you have off, at least it's covered. But doing something shorter fits with what I think we've been trying to get to in sensible efficiency and working out. One last one here is.
Make one more comment on that.
Okay.
The other big problem with 2 weeks of early voting is worker fatigue. It is very, very difficult to find people that can work for 2 weeks, take off the job for 2 weeks to go run this.
Right.
Usually we have to find split shifts or everything. A week would be a lot more manageable.
Okay. And then along with issues have brought up about Harris County having problems because of its size, other counties, Hayes County, Van Zandt County, different in its size, population, demographics. What would your thoughts be on if we set rules around the election process that took into consideration the size of the county, the population, the demographics, by making some flexible requirements? That is, maybe instead of requiring everybody, no matter where they were, be open 12 hours, we had something that said at least 7 hours, or just along that line, without going through a lot of detail, but rules that would take into recognizing that we want to make sure that across the board in Texas, everyone has equal access to voting, but having different hours would not really affect that, because you got different challenges when you got a Harris County where you got people lined up some places and others where they're not there. But just the idea of, and I'm not trying to pick any specific ones, but just the concept of approaching some of these things that we do that drives inefficiency, that we make it flexible. Comments? Ed?
Okay. I've actually studied this quite a bit. So now living kind of in two different worlds, I spend a lot of time at my ranch in Giddings, Texas, and Lee County, and then, I'm back at home in Houston. But helping with some elections in Lee County, I found out real quickly that you have a large percentage for the county. It's not a huge number of voters. We're talking 12,000 voters or something like that. But you have a large percentage of them that work in Austin. I mean, that's the big city that's around. So they get up in the morning at 6, they go into Austin all day, they don't get home to 7 or 8. And when you have the limited hours of polling locations in these small counties that only open during business hours, well, during the week, they can't make it. They're at work, they're on the road or at work. And then they only have one day on the weekend to do it. And Lee County's not huge, but they only have one early voting location, and it's maybe a 40-minute trip to get down to Giddings from parts of the county to, go vote at that location. So these people, due to their working everything, are disenfranchised, but they're driving into a town in Austin where they're voting all night long. It's I don't think it's fair to the voter. Now, it's not a huge number of voters affected, but I don't think it's fair to these voters that are doing to their work.
What's not fair? I'm not sure.
Well,
point?
if they're working and the polls close at 5,
okay,
in a small county, well, they don't get to vote during the week.
I'm talking about allowing the counties the flexibility to do what they think they need for theirs.
Yeah,
that we set the standards of a minimum or a maximum that would encompass the large and the small.
The county commissioners like to save money, so they're going to have fewer hours. That's what I've seen as a trend.
Jennifer?
What I think is important to keep in mind with this type of flexibility, which the law already allows currently, is that voters have the right to petition for additional hours, and I would suggest if we had this type of voting that we would continue to give that right to petition for additional hours.
Okay.
I mean, SB 1 addressed a lot of this with hours, and that's when we saw it was in response to Harris County going to 24-hour voting and taking it to the extreme. And I think you have to be really careful when you get too big of a bracket. And there's a bracket now in the law where you get a little wiggle room. that, you know, a nurse that works nights in Tyler needs to have the same opportunity to vote as a nurse that works in Houston. So you really don't want to get too far off that because you just run into, I wouldn't call it a constitutional equal protection problem, but in a conversational equal protection problem.
Okay.
Yeah.
Okay. I've got a couple more, but I think I'll wait till we run to the next panel.
No problem. Thank you, Senator Hall. Before I recognize Senator Betancourt, I'll note that this committee and the Senate last session passed Senate Bill 1209 to move those May elections to November, and I'm glad we had the discussion today because I think there will be another discussion about that when we get back. Senator Betancourt, you're recognized.
Thank you. In the interest of time, I'm going to try to blast through some of this so we can get to the next panel and then the next call after that too. Ed, you mentioned Senate Bill 220. We're going to file that again because that does have a rocket docket to take election contests and get them immediately resolved because otherwise we're going to see what happens in Harris County, habitually is somebody will keep the polls open and the Supreme Court will then overturn them. And then the question is, what do we do with the 500 votes that were cast during that period of time? And it did affect an election outcome. Harris County is the only county that actually had a successful election overturn from the 2022 election cycle. I think your comment, Chad, about foreign money ban is very critical, okay, because that is a tremendous amount of money coming in on ballot initiatives in the state. I think that was Senate Bill 1863. I think it was the chairman's, I'm going from memory.
2035.
2035, all right. I do think we need to add something to that, Chairman, as well as I think Ed, your comment about the expatriate vote, for lack of, it has absolutely no documentational evidence, period, end of statement. It's a total wide open can opener. I think that needs to be closed. Jennifer, your 1540, yes, we're going to expand that because the fact that we've got people that have to stay in hotels surrounded by sheriff's deputies is just a terrible indictment of what's happening and how frothy things are, because the elections officials are not the ones responsible for writing the law. We are, and they have to be protected in its implementation. And that level of threat applies to their deputies and others, and it's just a wonder we have people that want to do this job anymore. I've just, any comments on those three things, because I have to talk to the deputy secretary or your assistant?
No, sir, Director of Elections.
Director of Elections, sorry, about teams. Any comments about those?
Just thank you.
That right. And Christina, look, voter roll integrity is paramount. I testified 20 years ago as the, quote, greatest tax assessor in history. Thank you, Ed. I'm going to remember that. And I went to Washington and testified for photo ID and a citizenship list. 20 years later, it is still, Senator Hall has not passed. And the younger congressmen look at me and say, effectively, I'm a living fossil. Then I refer him to Bob. Never mind. That's right. Who is going to be going at this when he's at 100. But it is a simple concept that we've avoided for 2 decades at a federal level. It does talk about the interplay between the NBRA and the Help America Vote Act and all these other problems that we've got that we have to deal with. So, but voter roll integrity is totally number one. And with that, we do have to talk about teams, because I have got just a Christmas tree looking, set of problems that came my way yesterday. And I do want to point out, yes, you absorbed VOTEC, which was unusual. And yes, you have to absorb redistricting, and you've had a whole bunch of things to do this, Christina. So I'm not trying to pick with that, but we've got a problem in Harris County, Seabrook, Texas. Harris County verified 1,700 voters. The team system says there's 181,000 voters there right now.
I can explain that.
Okay, well, quickly, okay.
So this Harris County is an offline county.
Right.
They don't utilize the team system exclusively. In the system, if they don't have the right precinct assignment, the system will default it to a specific precinct. And so it goes back to Harris County. All of our offline counties have a responsibility to make sure that their data is correct in the state system. If we don't have the precinct assignments correct, the system will just default it to one precinct, and that's what's going on there, is we don't have
Kevin in
precinct
Natchez
assignments
County
correct.
has the same problem, right?
sorry?
Natchez County, Kevin, you know,
Nueces County, offline county
No,
as well.
sorry, Nueces, right, yes, right, same one. Now, this goes to a question that I've got. There's a tremendous amount of technical support for the offline counties and for the online counties through Team. And the problem is the aggregate is not strong enough to do what's necessary right now. At least
Yes, sir. That's
right,
correct.
I don't believe so.
That's correct.
Now, I have to ask, your vendor now on 4.0 Teams is Civic.
Civics.
Okay, how big of a company are there? How many states are they operating in? How much technical resources do they have? Because there is right now no chance to bring the offline counties into a system that has that level of complaints.
Absolutely.
Right, so I'm trying to understand how big of a vendor did we pick?
Sure. So we had a competitive bidding process for the contract, and we had 2 vendors that bid on the project. And Civics was a vendor that was ultimately awarded the contract. These are records that individuals can request and review to understand what took place in that competitive bidding process. I will say I can get you details on Civics and their kind of corporate makeup and the number of clients that they represent, but there's multiple components to that company. They don't just work in the election space, but they do also work with a handful of states, providing the same kind of voter registration support and services that we have. Louisiana is one of their big customers. I think Iowa is another one.
But Texas would be an order of magnitude larger.
We are the biggest, without a doubt. And I think given everything that's happened this year and the additional support that we have needed, I think most folks would say we're probably the customer that's getting the most attention at the moment.
Well, I would hope so.
Without a doubt.
Yeah, right.
And without a doubt. And, you know, when the VOTEC situation occurred, and we had to pause the redevelopment project. And I will say, you know, Mr. Johnson talked about what he would recommend, a phased rollout, no major changes in the system within 90 days. That's exactly what we were doing. We had a phased rollout scheduled for this, a phased approach where we were releasing different modules. We had a plan to work on issues every week that they were coming up to resolve issues within one individual module before we moved into the next one, until that situation happened. And the VOTEC situation, I cannot underscore enough how catastrophic that situation was and what we had to do to stop everything that we were doing to support our online counties to make sure that we had that election in November.
No, Christina, because there was actually a possibility at one point that
Yes, sir.
that vendor was claiming they were bankrupt, they were refusing to cooperate.
Yes, sir.
They asked for unbelievable amount of money from the state of Texas, and that was a difficult situation to
Yes,
get
sir.
through. And so I know that. Now,
What I would say, if I may add one thing, sir, what I would say is, given the fact that we don't make big changes to our system when we're within so many days of an election, and we have not been without an election since November, given that we had congressional vacancies and a Senate vacancy that we had to fill in January, we had the March primary, we had 3 elections in May, here in June.
we have runoffs, we've got.
Absolutely. We have not had the time to go in and address the big issues that our counties need us
Okay,
to address, and we do now.
You're leading the point. It is
Yes, sir.
critical that you try to get these big county, and also I'm going to read several small county issues
Mm-hmm.
here resolved while you've got about a 60-day period to do it.
Yes, sir, that's correct.
And that's why I'm asking, is Civic big enough to handle the questions? Because these are really big problems that I see in the system right now.
Yes, sir.
Okay, and really we're capacity bound by the vendor to be able to make some of these changes, true?
Yes, sir.
Right. Kim Wren from Austin County Tax Assessor Collector asserts that much of the information in the SOS utilizes flawed, bad example of, she's got problems with the ballot by mail module that
That's
you've talked
the one
about.
that needs the most work for our county.
Right, because they've got all sorts of problems with individual, I won't even go into the individuals that have had issues. And the new software did not recognize change in registration statuses that was sent back and forth between 2 counties. Monica Foster, Jackson County Tax Assessor Collector. Their online echoes frustration with SOS Office and their responsiveness to these. You've got to set up version control, okay, where there's specific understanding of individual changes that these counties want to make, so they have some idea if there's ever going to be progress or not, because they're saying there's 20 or 30 reps that they work with and they're, quote, demoralized, at least from the Travis County view. I'll get to that in a second, because they're not given any data as to when these problems are going to be resolved. Travis County's had to do workarounds of,
Absolutely.
because they're the largest team system, okay? They have 940,000 registered voters. And Christina, Jefferson County says that when Teams actually puts initial voter registration roll in, it never gets changed. At least that's what they view. Now, there's all sorts of, we could spend hours here talking about that. I just want to just absolutely encourage you as a former elections official. When I get half a dozen counties with their hair on fire, and some are small and online and some of them are big, it means that the vendor is behind on actually delivering fixes to the system. And those fixes have to be done, because if we go into a November election and we can't claim that we have integrity in the voter roll, we're going to have questions with people on recounts, questions with people on election results. So I don't know what else we can do except encourage that they work whatever they can. But I could spend another 30 minutes going into detail stuff, which I think you're aware of.
Absolutely, sir.
And it just has to be implemented as soon as possible.
Absolutely. Sir, there is nothing more important in our office than this project. I can assure you of that. And I can assure you that we are dedicating every possible resource that we have within our office to resolving these issues.
Right.
It's a combination of issues. It's not just system issues. Some of it's data issues with counties, some of it's workflow. And I promise you that we are doing everything that we can to resolve this issue so that we will not have another discussion about this with respect to the November election.
Because we just don't have time.
That's
We're running
correct.
out of daylight.
That's
because
correct.
these
Yes,
changes
sir.
have to be made in the next 60 days,
right.
tops 75, and otherwise we're staring down a major election for the state.
That's right. Yes, sir.
And consternation is at all-time high. I want to thank you for your comments about Val Verde, Texas. That was the purpose of 1933. I've got it posted on my social media. People believe that that was a punitive law. It was really a what gets measured gets fixed law. And to prove that point, Senator Zaffarini was a Democrat county judge that asked for that oversight over a Republican tax assessor to get that problem resolved. And I think that, so I appreciate that. And also, we do need to strengthen this whole concept of Chapter 19. That has to be reviewed, because that's another bill that we passed, which was Senate Bill 1113, that gave you the power to withhold it if people weren't doing the work to clean up their voter rolls. But all this goes back to one thing. If we don't have voter roll integrity, we will not have faith in the election process. And that's just the end. That is the key thing. So we have to have a statewide voter roll with integrity, as well as the local rolls as required right now. And they're going to run in parallel for some period of time.
Absolutely.
And so we're going to have to figure out how to make those sync up.
Yes, sir.
Okay. Anything else? Did I miss anything? Comments?
I just want to thank you. You just echoed some of the anxiety that I think election officials all over the state are feeling, not just the tax assessors. But I also want to give you the confidence in knowing that your county election officials do know what they're doing, and they have run the past 4 to 8 elections by taking lists, comparing lists, doing a bunch of
workarounds.
A bunch of workarounds. So I don't want anybody to feel like the elections are not secure. They are secure. I just don't know if that's sustainable moving into November.
And Jennifer, and here's the point. We're going to look at these recounts too, Chad. That's something we should probably look at, whether they're automatic and the state pays for it, and also recount mechanisms on hand-counted ballots. All this stuff has to be looked at. But if we've got an election in Seabrook and somebody files a contest, and the local group says it's 1,700 registered voters, and for whatever reason, the state has 181,000 voters, then we got a problem, because that election contest has two separate sources of fact, one the state and one local. And while there's been workarounds to fix all this, okay, eventually this is going to catch up. So I'm just trying to make sure that we just, whatever we have to do to try to get, and that's why I'm concerned about civics. And to the rest of the panel, and I think Senator Hall knows this, there's a problem with how much capacity any one vendor has to handle all these problems at one time. Part of the advantage of having vendors do offline work is that multiple vendors were doing it until Votech it just, literally poured gasoline on the fire and disappeared. So when we look at having to make all these technical changes, Texas is an enormous place. We've got more taxing jurisdictions that can level a property tax than any other place in the country. We have more elections. We have more individual local governments. Trust me, I count all 4,500 of them all the time. So I really have to I need some data on how big Civic is and are they big enough to handle this problem, because all these changes that they're requesting are going to come through that one vendor.
Senator Betancourt. One comment on this. We really need that enforcement tool, or Secretary of State needs that enforcement tool to make these counties get in sync with the state, because under Help America Vote, the state voter roll is the official voter roll, not the counties.
I know, and Mr. Johnson, I'll use formal terms too. Okay, when the locals are running a workaround, as she said, and they're using a local roll, that is a trouble for an election challenge, because the state roll in Seabrook's case is preposterously wrong for whatever reasons, okay? And so that's what I'm concerned about. And as much as we can tighten all this up in the next 60 to 75 days, we need to do it. Got it? Okay. All right. Thanks.
Thank you, Senator Betancourt. Senator Perry, you're recognized.
Thank you. And so take a deep breath, Christina. Just relax a little bit. So here's kind of, and I'm dealing with this over on the HHC side, and I'm dealing with it in just numerous areas. But here's where I'm at. This is Groundhog Day for me again. This issue regarding voter registration is never going to go away until we plan at a very granular level. And then we set time. And as a budget item for the state, we fund. But then we hold people accountable. And Christina, bless your heart, I think you are doing a yeoman's job. And, people bring bigger challenges. But what I'm getting to there is somebody at a very high level that understands big data, AI, movement of big data, security around big data, has to be the point person. And it's not only your agency, it's HHSC. We're going through the same thing conversation, because I'm tired of doing this process every 2 years to say, well, we still have this problem. We still have this problem. So garbage in and garbage out. Groundhog Day for me again. So you can't do this, Christina. This is not your role. You know what problems are. You know what probably should be done. But when it gets down to the nitty-gritty of actually fixing data and making it accessible in a real-time fashion, that's not your expertise. And I don't think, honestly, the state has those internal resources at agencies. They have data people and they have technicians, but they really don't understand probably the AI concept and the clouds. If we're building out all these stinking cloud accesses, then it's big enough to hold the data. It's 20 million voter rolls. Mm-hmm. It's a lot of data and it's history. But where I'm coming to is, Mr. Chairman, it needs to be, I guess, by bill, but someone needs to take the bull by the horns and put it in a formal process that we have X number of years, and we're going to require all these local offshoots of third-partiers out of the system, give them a window to clean up their data, and then you suck it in. And if there's data errors, there's a cost for them to come in and help clean it up. But we need a very detailed plan to get through this process, because if we just leave it up to us every 2 years in interims to have a conversation about data integrity and the problems it creates, I promise you, if someone to do the economics of it, we're spending more money on the back end cleaning up messes and all of the hyperbole that comes out of it and all the voter consternation, that the falsities that we chase as politicians, that this is all hairy-carry, hair's on fire. It's time to stop. And you've got to have someone that can work with us and sell us on the idea that this is doable. So whether Civics is the company or not, the technologies have evolved where it can be done. And I don't know if Civics is. And if this isn't their sole purpose in life, then they're not big enough for Texas. I promise you that. This is an all hands on deck. This is a huge contract. This is a huge maintenance contract going forward. So they could almost be our stuff if they choose to do it as a business model. But I'm done with the conversations around voter integrity roles until we actually put in place a required scheduling of this is our benchmark. The locals get on board, get the data cleaned up, because we did this in HHSC for 30 years. What we would do, and Ritter, it's on us to give them the plan.
Right.
It's not on them to determine the plan, because what we would do in HHSC for decades, Mr. Chairman, we've spent billions of dollars with Deloitte's and Accentures and all these guys and IBMers of the world and Ross Perot's old company, and only to find out that they did exactly what we told them to do in a siloed fashion. But you know what they were fighting is they did what we told them to, but our data was so bad that the output was worthless. But they did exactly what we asked them to do. But what the HHSC group, to their credit, has said, we're not going to have any of that conversation until our data is clean. So that's where we're at. But if we've got third-party vendors already in the system, they can clean that data up. And then the state's data needs to get clean too, because I promise you, being in the software world and the programming world and COBOL world and Fortran world, there was a time when you didn't put in checks and balances in it. You could actually have an alpha character in a numeric field that didn't catch it and throw it out and say this doesn't work. So I know what your data looks like. It's junk, I would guess, on a large input. For over the years, people put in crap that the fields didn't catch you and throw you out. So the AI world, this is what Elon did. He looked like a hero, but he just took AI data, he converted it all to a system, threw it into a spreadsheet, and where it had data death, if that was an alphanumeric in there, he'd throw that one out and go look at it. I mean, it's doable now, but I'm tired of chasing this. And so you need to be very thoughtful in what I'm going to tell you. Find somebody in your organization that can be lead to tell us with a detailed plan. Before we go out and find a vendor, tell us what the issues are in the data. Tell us a time frame that y'all can manage it. And tell us when we can get these third-party vendors into the system. Because until you get a single data depository, y'all are going to be chasing it, and we're going to be having these conversations going forward, because you can't have one truth.
That's right.
There's only one truth in life. The Bible's one truth. In data, there's only one truth. If you got one database, you now know everything in there is either accurate or not, but you don't have to chase why it's in there if it's not. You know to go to it and fix it. And this conversation about multiple databases, and we think we can have consistency in the data. And then with that, you're going to have to give us a framework. How much real time can we expect from the system? So prior to an election day, what is the deadline cutoff for any changes into the system? And then who is going to be the keeper of that input? And who are they going to put? Is it the locals that can input, or can you be technically savvy enough to say Charles Perry moved from this block to this block today, and there's a reporting database that you don't have access to, that if you had access to it, you would say, oh, Charles Perry moved today, let's just make that happen. Because if you can eliminate people's inputs into the system, you eliminate data errors, except for the guy that's responsible for putting my move in. But you got to be very detailed on how this works. And I don't think we have the expertise on this committee. We know a lot. But without that roadmap and without that plan and without a holistic approach to what deadlines need to look like to guarantee real time, and then you catch it at the polls when they say, well, you don't live there, I'm sorry, we'll put you on provisional ballot. And now you're working with a subset of a very smaller group because you will never eliminate 100%. So if they're right coming out of the registration and someone goes to vote and it doesn't match the registration, you put them on provisional, you clean it up, that's manual process, whatever. But this is getting old, people. It's getting old for this legislature. I'm in the 20 year of my life cycle, my season. I bought my last truck. But I'm not going to spend 10 years of the next 20 years at the Capitol talking about voter integrity rolls. Not when technologies and clouds and data movement, data block, or whatever the big data move software exists. We're better than that. It will not happen without a plan. And a granular plan to where this legislature, the next 5 sessions, will have an accountability function. Where are you at? You said you'd have all these guys in and do it, because it ain't going to happen because you're too busy managing the multiple election dates and the problems that just come with it. This is not your job. You shouldn't be in this conversation today again. It's on us. Thank you.
Senator Perry, one of the things that the legislature could do to help this project, just as we're talking about, is give the state the ability to match against other databases, and when they find this error, to match up with the National Voter Registration Act, you have to send the voter some notice. That tool does not exist right now.
I appreciate all the minutia, but it still starts with a database. Here's the other thing. Then you're questioning which database is right. If you're comparing it to 15, which one's right? Secondly, I'm sorry, Mr. Chairman, we're having this conversation about federal and state separation. I understand the need for it. It makes sense to me. It doesn't make sense the feds can't do smart, common sense things that they're not going to because they're not smart and common sense. But here's the question. All these things that we're doing in this environment of teams and coming on board in data, are they already visionary enough to say we're going to separate federal and state, or is that going to be a complete overhaul if the state chooses to go there? So it's those thoughts that I hate to even ask the obvious, but I found as a legislature, if I don't ask the obvious, then we are disappointed 5 years in and say, you're going to have to spend $20 billion to actually get the federal and state separation. Are we in that conversation with these vendors?
What I would say to that, sir, is that question has come up enough over the years. That was definitely part of our calculation when we were building out this new system, is making sure that there was some flexibility should that be the direction that we have to go, and it wouldn't require some kind of massive change or massive build to the system. Okay. That doesn't mean there won't be some cost, but it won't be what it would have been 5 years ago.
Let me give you a good example. To add a field in the database over at HHSC, when we ask for a different field to track some data point, it comes back sometimes as silly as $40 million to change that field. So being visionary, this is not rocket science. We know how to get a good voter integrity roll. We know what that expects. We may add some data points down the road that don't exist today that make it easier, but just as long as that's in the conversation. On the one that left us hanging, do these contracts have some remedy provision that when the state has to clean up their mess and is out $600,000, do they have to pay us?
No, we don't have anything in state law in particular. You know, when a county onboards to our system.
These are contracts.
So we were not a party to those contracts, sir.
Okay.
That would be a question for those local governments.
I appreciate it. I'm just saying we can fix this, but we're never going to fix it if we keep doing this routine every 2 years. And you can't stop long enough during a year to actually address it. So you find somebody, and lastly, shame on you if you come to finance with an LAR that does not specifically give me a time frame to fix this voter integrity roll and personnel. I don't have to have a vendor, but you better have somebody that's top shelf that's willing to work 7 days a week for 24 hours a day for the next 6 months just to have the conversation to find the right vendor. But if you need people and you need resource to close the door on this conversation and you don't ask for it, because I'll be your biggest advocate. This guy will be. I think Senator Hall's on there to fix it. But if you, and I'm not being exact, if you say, I think we're going to need these people and these are people we're talking to, let them talk to us too. But that is your job, kind of at that level, to make sure the LAR respects what we're trying to do. But technology, you made a great point. we had to use third party before technology. You know, when you could store 100 gigabytes and that was massive. Now we're building petabytes, petabyte, whatever it is. We don't have to be reliant on technology limitations anymore. Plain and simple. That's kind of scary, but there really is no end to capacity. And real-time access, I can pull up 2 different AI companies right now and ask whatever I want on my apps, and in 30 seconds, I usually have a response that's more detailed than I'd have gotten if we'd have put a bill together to study it for 3 years. So it's here. Just tell us you got the people, you need more people, and then we'll go find out vendors. But we've got to fix our ship before we hand it over to somebody to direct. Thank you.
Senator Parker, you're recognized.
Thank you, Mr. Chairman. Well, appreciate you all being here today and the seriousness of what you're taking up all of these issues. And Christina, in particular, I want to thank you for all the good work you've done for so many years. And I'll tell you firsthand, I'm taken back when you're going through personal difficulties of great extreme with your family and some of the horrific things in life, and you're there to respond to my calls, and I always appreciate that very much, particularly when we're talking about all the hand count audit bill and Senate Bill 827. I was very fortunate to carry that bill, and I've gotten a lot of good feedback from people from a lot of the smaller counties and so forth that it was really working effectively. So I'm very thrilled with that. But I would like to get your thoughts. Of course, I think that hand counting audit is vitally important for the future of our state to ensure election integrity. A lot of those counties now are literally hand counting everything, which again I think is a good thing. How would you supplement or tweak or help them to be able to continue to do what they're doing? Are there any adjustments that you would make to that legislation, now seeing it implemented now this cycle, that would improve what we're doing in terms of accuracy and in terms of the support for the smaller counties in the state?
Those are great questions, and these are things that we've had many conversations about, and I will tell you, Ms. Doinoff also has some suggestions in this area. One of the things that we have noticed is that when we were looking at Senate Bill 827, you're looking at legislation, I think we addressed some of the concerns that were out there with making sure that we were doing more hand counting in more races and giving our local entities more control over that process, where they could add locations, they could add races, so that it was reflective of the needs of that local community. There are some other provisions there related to our cities and our school districts where we didn't make those same alignments. And in talking to our local political subdivisions and in talking to our elections administrators, I think mimicking some of those changes that we made so that those changes apply to our local folks as well. Right now, actually, the way the law is written sometimes requires a full recount in some of these local small jurisdictions, and making what they do more analogous to the counties, where it may not be a full recount, it may be selected races, but it gives them more control where they can add additional races as needed, add additional locations to reflect what's happening within that community, or if there's issues in particular parts of their jurisdiction. To give them that same kind of authority and those same requirements that the counties have, I think would help tremendously in some of those situations. The other thing that's come up is, and Ms. Doinoff mentioned this, one of the other changes that you made, sir, was to put the ballot board in charge of the hand count process for this post-election audit. Right. That was an excellent change in that it provides more separation from the county to the individual, to the counters. We don't have the county checking their own work, so to speak. That has been great in adding that level of separation there, but it has increased some costs, in particular for the primary, because that hand count is a responsibility of the general custodian. It's not a responsibility of the party. But because it's a responsibility of the custodian, it's not a reimbursable primary expense that the state can pay for.
I see.
And so there may be a few other little tweaks like that that can lift some of those burdens on the counties to help make this process just more feasible for them on a regular basis from a budget standpoint too.
Oh, that's very good. Thank you for the feedback. Look, I just think, the hand count process is critical. That audit component was very important, and it was great to work with you all, and thank you for implementing it so well with such fidelity. And I appreciate the feedback for what we can do going forward. I want to switch gears for a moment on some of the things that my colleagues were talking about, big data and obviously getting one repository of data. I couldn't agree more, obviously, with the importance of that, obviously, to be able to have true election integrity in the state of Texas. And one of the things, whether or not we're talking about the cloud, whether or not we're talking about AI or the future of quantum and all those things that are coming at us very rapidly, I think it's vitally important that we recognize that we today, here in Texas, last session, I was very fortunate to carry another bill, which is the establishment of Texas Cyber Command. And now that Texas Cyber Command is getting operational, I believe we'll have the finest cybersecurity capabilities, not just to play offense, where I should really say not just play just defense, but to play some offense as well with bad actors around the world that are threatening Texas. But I think it's very important for us to talk about how you all, from an SOS perspective, can utilize some of the talent that is there right now that we're amassing with regard to data. We've got some great data scientists there. We've got great AI experts. We've got some really brilliant cybersecurity professionals. And I really think when you're putting together that LAR to come before finance and put together the full package about what needs to be done, because look, we're so grateful for what you're doing, but you need to have the tools. Yes. So give us the tools is what I think Senator Perry is saying. We'll get you the tools. Just tell us what you need, put that roadmap in place. But I think utilizing the assistance of Cyber Command could be of great value to you in this process. It's an investment the state has already made. And I think it'll be one of the finest investments we ever made because, again, at the end of the day, there's nothing more important than the safety and security of our people, whether or not we're talking about physical security, which obviously is impacted by the digital footprint, or whether or not we're talking about election security. It's all vital that we tackle it. And so I just think there's a real opportunity that we can leverage the good work that your office is doing with Cyber Command to be able to address these big data and AI challenges and really get some out-of-box thinking from state personnel before you contract with the private sector. So
absolutely, sir. Data security and data accuracy are two sides of the same coin.
Yes.
And both equally important, and we will absolutely do that.
Great. Thank you all for all you do. Thank you.
I'll just add one thing, Senator Parker, and this goes to what Senator Perry was saying too. You guys are both right over the target nationally of what other states are looking at. You look at Ohio, they established in their Secretary of State's office an Office of Data and Data, can't remember the full name of it, but data purity, making sure the data is correct.
Yeah.
Right? And they have a dedicated team to that, someone who can look at data, know the limitations of data, talk to your vendors and say, oh, you're trying to charge us $40 million to change that field? I know that's, out of bounds. That's ridiculous. So Florida's done it. Ohio's really led the way on it. So there are models out there that Texas should, grab a hold of and then, make them Texas worthy.
No, look, we want to lead on all things, right? Texas needs to lead on all things, and so we need to do this right. This is the next objective, obviously, in this realm of election integrity. And look, I've done a lot of big systems projects for years before the legislature, and garbage in, garbage out, right? If you don't have good quality data on the front end of the process, you cannot hope for a good outcome, right? I mean, that's just silly. And so we just got to recognize that. That's why I think all the commentary from my colleagues is so spot on that we've got to get to one repository, period. There's got to be one repository that is king and without question, the one source of data that is accurate. So I think we'll get there. I know we will with your support, this team's support, and the help of the legislature. So thank you all very much.
And thank you, Senator Parker. The Dean of the Senate is recognized.
Thank you, Mr. Chairman. I'm particularly interested in Ms. Doynoff's responses since you represent the election administrators and officials throughout the state. And first and foremost, we've talked about the number of days and how long early voting should be, and we've talked a lot of related issues. What would you think if we just ran up to Election Day and worked backward, regardless of the number of early voting days, if there was no period between early voting and Election Day?
So we are discussing that in the next phase of this in our panel for Senate Bill 2753. Mm-hmm. And we are working with Senator Hall's office on a lot of initiatives that we think can help implement that process a lot more seamlessly. Some of that being scheduling, because we do hear a lot that the number of hours, especially the 12-hour days leading up to a 12-hour election day with no break and 9 hours on Sunday, tend to scare some of our poll workers a little bit that are probably the average age of 72 and older in some areas, and already exhausted, even with the break in between. So we're working with Senator Hall's office. We don't have, our membership is compiling ideal schedule because I think some of our membership think that 5 days or 7 days may not be enough time. And so we're looking at other options with maybe hours and things that we can change with that. We're not done with that data, but we have talked with Senator Hall's office and plan to get him something like that.
And I know that some of the confusion was that during early voting, in some cases, voters could go to any voting site, but on election day, they had to go to their designated precinct. So if you consider that, I would hope you would also consider applying the same rules, election day and the other days especially, if there's no period in between.
Absolutely. That is actually a part of our next panel discussion as well. But yes, we believe 2753 works best in counties that operate under the countywide polling.
Good. Second, somewhere along the line, and I don't know when, we increased the number of days for the runoff from 30 days to now, what is it, 84, 85?
Days of
How would you feel about shortening the runoff period? I heard more complaints about that long runoff period this
We're talking about for the primary?
for the primary.
Okay. I think a lot of that depends on what is decided with the legislature on the May election. Just because those timelines do overlap, it is a lot. It's very confusing to voters. And I think we have a lot of good ideas coming this next legislative session for filing, maybe changing some of the filing deadlines and you guys looking at the May elections.
Dean, I was going to ask that same question. You'll recall we extended that, or the legislature extended that time frame. It used to be the runoff was 30 days after the primary.
Which
It
was too short.
Yes, ma'am. But it was extended, as I recall, because of overseas military ballots.
Yes.
So, Ms. Atkins mentioned of changing that, but what about that? If we wanted to, could we shorten that?
Sure. So a big part of that change has to do with federal law requires that military ballots be sent out no later than 45 days before Election Day. And so because they have to go out during that time frame, you have to get through your canvass, you have to get through the programming of your equipment, the testing, before you can even get to the mailing of ballots, which is why we have that long runway. For our congressional vacancies, legislative vacancies, those elections are about 70 to 77 days out, typically, from that main election. It's a long time. Now, I've been asked this question recently about why we're hearing about other states that have a much shorter time frame and why can't Texas do what they do. So I've called around and I've talked to my counterparts in other states to find out kind of what their scheme is. And in most of the states that have a shorter time frame between the runoff and the main election, to address the issue with military ballots, they typically have instant runoff for those ballots for the military voters. Not widespread throughout the election, but just contained to that group of voters where they're ranking their choices. It's a form of ranked choice voting. And then those ballots are held and they don't have to send another ballot to those military voters. And that allows them to not worry about that 45-day deadline and they can move their runoff period much earlier.
Thank you, Ms. Were you going to say something on that, Mr. Ennis?
Yeah, SB 1209 from Senator Hughes last session that consolidated everything to November and got rid of that May election, the May constitutional, did shorten the period. So we shortened it by, I believe, 2 weeks.
2 weeks.
With that, we thought you could still get in the things Christina was talking about and the things Jennifer was talking about and still have that election. And then the other thing is, as Christina says, there are ways, if we want to shorten it more, to get there. It just takes some work to handle those overseas and military ballots, so we give them every opportunity to weigh in as well. But there are ways to do it across the South where we have a lot of runoffs. The states deal with it. Georgia deals with it with their short one. Mississippi. So there are models out there.
Thank you. And back to, did you have something?
Please, Dean, go ahead. Thanks for letting me interrupt. Go ahead.
Thank you. Back to Ms. Doynoff. On June 3rd, I wrote a letter to the Secretary of State, and I'm going to follow up with her successor. Much as we'll miss her, we will have a successor soon, so I will follow up with that successor regarding a request that the Secretary of State appoint a permanent standing committee, as long as it's needed, of local officials that would address the issues related to team. Would that be helpful to you and your other election officials?
I believe so. I think probably if I could have everybody here in front of you right now, they would say the biggest thing is they don't know what's happening. And there's a big feeling of what are we going to do if these issues aren't fixed before November? And so I do believe that that would bring more local officials into the process, and I do believe that that would give that feeling of our voices being heard.
Good, thank you. Thank you for those answers. And Ms. Atkins, specifically regarding the non-citizen voting,
Yes, ma'am.
why were DPS records not initially cross-checked before counties received flag lists of non-citizen voters?
For two reasons, ma'am. First, because DPS utilizes the SAFE system as well. And so we had no reason to believe that there would be records from DPS that would have a different response than what we were getting from the SAFE system. So that was the first reason. As we have heard more from counties, we have identified some inconsistencies there, and we have worked with DPS on this. So we did ask them to do a full review and look at all 2,700 records. And that leads to the second reason why we didn't initially make that request. When we first received that data and had some conversations with DPS about it, there is no easy way to do a search on their database for that level of detail. The database itself does not capture the type of document that's presented when somebody provides proof of citizenship. So they have to manually review each individual record to look at the scanned images of the document that was provided and locate the data points that we were asking for. That process has taken them, we made the request several months ago, and we're still waiting for that data. They are working on it, and they are giving us updates, so DPS is being extremely cooperative. I want to acknowledge the hard work that they have done there. But in reviewing that data and looking at where we were on the election calendar, given that we didn't expect the inconsistencies, and given that it would have taken DPS a significant amount of time to do that research, we thought it was in the best interest of those individuals, these potential non-citizens, to provide that information to our counties so they could begin their investigative and review process. Because our counties may have access to more data than we have. Some of our counties keep records on naturalization ceremonies. Some of our counties work with their local law enforcement to get data. Some of them work with local DPS offices to do additional verifications and data. And the biggest thing that came out of this is that many of our counties, well, I will say generally all of our counties, I believe, do this. The first thing that they do when they get a non-citizen match, and we've learned this from the non-citizen matching process we've been doing for the last 5 years, is they go to the original registration application to look at what that voter put on that application. Because people sometimes make clerical errors. And when you talk to our counties and you ask them about what what they see in the data that's been provided, many counties will tell you that they found mistakes where they maybe had temporary workers assisting them. A voter properly identified themselves as a non-citizen on the application, but the application got processed anyway. And so for those situations, the county can very clearly see where a voter was properly disclosing their citizenship status, or rather their status as a non-citizen, but the registration happened anyway. That was not the voter's fault. And it's in that voter's best interest to quickly take action on that and remove them from the voter rolls, or go through the process of removal where they send out a notice and notify the voter, because I think our election officials in our office, we know the consequences of that. We know that DHS and that folks that are pursuing naturalization, these are things that can harm their immigration status. And in most of these situations, you don't see voting history on these records. That's a strong indicator that these individuals are not aware that they're registered. And so for where a county could take action quickly, we thought that it was in the best interest of those voters, too, to give that information and to put it in the hands of the county so they could begin that process and address the issues that could quickly be addressed while we all continued doing research and looking into those records.
Thank you. And as of today,
Yes,
how
ma'am.
many non-citizens have actually voted in elections over what period of time?
I don't have that data. That is something we will be doing some more research on when our counties complete their part of the process, their investigation process, when they provide all of the responses to us of individuals that confirm citizenship, so we know what individuals to remove from that list that we're evaluating. At that point, we'll be able to run numbers on there to determine if any of those individuals that have where we have indications in multiple databases, I'll say potential non-citizens, where we have indications that these are potential non-citizens if there's voting history tied to
You have
those.
a range of your expectations? High and low?
I don't, ma'am, actually. I don't. I would say I don't, because The only thing that I would have to base it off of is maybe work that we did about 5 or 6 years ago. But I think because we have engaged with DPS and we have this weekly DPS non-citizen list maintenance process, I think we've been able to tackle a lot of the potential non-citizens that were on the rolls, again, in many cases inadvertently. So I don't know, I don't have a sense of what those numbers would be now, but that is something that we will look at.
Thank you. Mr. Chairman, this particular aspect of the issue hasn't been brought up, but the issue of buying votes, and that is certainly related to election security.
Yes, ma'am.
So if I may, even though we don't have a
Please.
representative of the Attorney General here, I'd like to ask these panelists, suppose that there is a voter in any county in Texas who knows that a candidate has attempted to buy votes. What should that voter do? What are the steps to ensure that that law is enforced?
They have several options in front of them. They can always make a complaint to local law enforcement, though I understand sometimes there's sensitivities about handling that information locally.
But by local law enforcement, the DA, the police?
DA, they can go to the DA, they can go to the Sheriff's Department. Those are the two, usually typically the first two places that individuals will go is their local Sheriff's Department and
What
the
if it's a
DA's
sheriff?
And that's where, I think that's where the state comes into play, ma'am, because individuals can make complaints to our office, and we have statutory authority to make referrals to the Attorney General's office for their review, so that they can investigate and consider the situation there. So when we get a complaint that comes to us providing evidence of potential ballot fraud or voter fraud, we do a referral to the Attorney General's office where they have investigators that'll then take the issue and look into it more. In addition to that, I know that the Attorney General's office has at times partnered with the FBI because we have answered questions for the FBI on this issue. So I think there's also avenues through the federal government as well. But typically, our first move at the Secretary of State's office when we're provided information of a potential criminal violation is to go through the Attorney General's office because of the mandates that we have in state law to report there first.
Mr. Chairman, I really think this is something we need to look at and to have a very specific procedure because there is such a case. And basically everybody was pointing to everybody else. The district attorney said he could not react until he got a report from the Texas Rangers. Then at the state level, the point was that they had to hear from the district attorney, and so we don't have a specific procedure. And it's a very serious question. I'll send you a video about it.
Senator Zaffirini?
Yes.
Senator Betancourt's bill he had last session, we nickname it the Marshall Bill, but it addressed that because I see that problem in Harris County and all over the state. It addressed the ability to have an investigating group that could immediately respond and then a fast track through the court system so that you could resolve it. Because if you don't resolve it while the election's going on, it's too late. So I would help you. I think you could get Senator Betancourt and express those to him and make sure his bill's covering what you want.
Thank you. Thank you all. Thank you, Mr. Chairman.
Thank you, Dean. Senator Hinojosa, you are recognized.
Thank you, Mr. Chairman. Ms. Adkins, as you know, I'm from Nueces County, and Nueces County is one of those offline counties with regard to the team system. And first of all, thank you for your rapid response and taking my calls and trying to help address the situation. But for the benefit of the committee, could you kind of go over that scenario and what happened with those offline counties that were trying to upload their data,
Absolutely.
where the data is not correct at the state level versus the county, and what's being done to resolve that, just for the sake of the committee?
Absolutely. Yes, Senator. So we had a situation in Nueces County where it was brought to our knowledge during the primary, during that early voting period, that the redistricting data from Nueces County had not been fully updated and put into the state system. Again, I want to reassure everybody that from a voting purpose, people locally were getting the right ballot, and this did not impact the accuracy of somebody coming into a polling place and requesting a ballot, getting the right ballot there, because the data was right locally. That being said, it had a huge impact on the reporting of voting history to the state, and it had a huge impact on the reporting of in general accurate voter lists that the state produces for all of the various requesters that we get in this issue. And with redistricting, when this happened, our counties that were online, that was a much easier fix for them. It was a much easier process in some situations. Some of our counties had to go in and manually make all of these changements to their street segments, to their districts, and manually make changes to what voters were in what districts to align with redistricting. And it was pretty substantial in a lot of counties. I say this because I know that Hays County had to do all of this work manually. We had some counties, and this is specific to our offline counties, where they don't have that level of detail in our team system. We don't have their streets in our system the way online counties are in our system. So we worked with our vendor to develop a process where we could upload a series of reports that made changes to the streets and to the district assignments and to the precinct assignments for all of their individual voters. We contacted every offline county to say, do you need assistance, or is this something you're going to try to do manually? Or can we help you with this upload process because this was so substantial in some counties? And so we did work with a handful of counties early on where we were working on uploading this information. And then, of course, the county has to go back and validate to make sure that that upload occurred the right way and that all the assignments worked as they should. Nueces County, my understanding from working with the county is they thought they could go in and do this upload process in a different way. They had not contacted the state on the front end. We, in fact, had confirmations from them that they'd already handled the redistricting, so we thought they had made those manual assignments, but it turns out that they thought they could submit the files in a different way. And it didn't process them the way that it needed to. And so we went back and worked with Nueces County to help them generate the files that they needed so that they could get that data in our system. And then, of course, Nueces has to go back and validate and make sure that all of that information was entered into the system correctly. I think over the last few months, we have discovered that not all of the system is accurate. Not all of that data is accurate. That local validation of data is an extremely labor-intensive process. It takes a long time. It's very detailed, granular work. And I know many of our counties, because of where we were on the election calendar, were not able to perform those detailed validations as quickly as we would have liked them to do these validations. And so we're continuing to work with counties. Nueces is one of them. Mm-hmm. I think they're almost fully there in getting that data aligned between their system and the state system. But we are continuing to do that work with all of our offline counties right now that we're past the election process, to make sure that the data is validated, that the county has signed off and reviewed what's in the state system, and they tell us that it's accurate, because they are the keepers of that data. We don't have the county level data. We don't know what it's supposed to be. The counties know what it's supposed to be, so only the counties can tell us if the data in our system is accurate. And so we're going through that process slowly but surely with all of our offline counties to ensure accurate data going into November. And this will impact the uploading of voting history. If their data is not right in our system, then the voting history won't be captured properly, which is why people were seeing information that was inconsistent on the state website than what they were getting directly from the county.
And is your confidence level that this is something that, for these offline counties? I mean, obviously, going through an experience like this, a lot of these counties are even more hesitant to want to come online, right? And is your confidence level such that the problem has been properly addressed? There is a process to rectify the situation. As early as, I guess, maybe a week or two ago, apparently that still it is not synced properly, or it's not, the numbers are not.
75% accurate is what I would say for Nueces County, and talking to my team.
Okay.
That we're still seeing discrepancies. About 25% of what we're seeing or we can attribute to discrepancies in this area. What I would say is that we have properly identified the issue.
Okay.
The state knows what the issue is. It's up to the county to get it right. It's not about the state trying to fix these issues on behalf of the county. This is where local counties, when they take on these third-party vendors, it's their responsibility to make sure the data is aligned with the state system. Nueces County is working very hard to do that. So I want to assure you there that they are doing their part. It's just a difficult process. And
was there any other counties that experienced something similar in the upload process? Because that was what was initially the complaint on my end. And again, I appreciate your responsiveness to the situation, but it was in the upload process where they felt that there was it wasn't syncing right. So you're telling me that interchange, the upload process.
The upload process was fine. They were trying to upload it through a different mechanism. In the daily files they send us, they thought if we just change all the precincts there, it'll change the precincts everywhere we need to in team. And that's not how redistricting works. It's a much bigger process. So I think that was where Nueces County made an error initially, is they didn't tell us what they were doing, and they thought they could do it through this daily upload process, and that's not how redistricting works. Once we went back and worked with them and explained to them the differences and worked with them on generating files, that's how we started getting resolution on this issue. Again, it's contingent on the data they put into the system. If the data they put into the system is in the format that it needs to be, if it's accurate with respect to what's in their local system, then it'll upload okay, and they can go through and make those validations and tell us that, and then we're good to go. But it's up to the county to ensure that the data is in the right format, that it's read correctly, and that our system reflects what's in their local system.
And I appreciate that. You brought up another point about redistricting, and I don't think it's too common, but it did occur in Nueces County where we have 2 Senate districts, and at some point, the precincts were split.
That's right.
Which created yet a further issue. And again, is that rectified by what you just described, or is that just another anomaly piece that we need to look into and address when precincts themselves are split in ways like that?
So state law says that you can't split a precinct with a Senate district. And so that's something that locally the county has to go back and redraw those precinct lines to account for that district cutting through a precinct. And so that's more work that the county has to do. And the result is now we're probably going to have 2 much smaller precincts instead of a bigger precinct that has those lines that cut through the precinct.
But that created yet another challenge.
It creates
right?
another challenge. And what I would say to that, sir, is that's where we see issues, as Ms. Doyneff brought up, with some ballot secrecy issues. The smaller the precinct, the more likely it is to be able to tie a ballot back to an individual voter. There are a number of laws that we could look at. We don't necessarily need our precincts to be that granular. Now we can accommodate multiple senators in a district. We can accommodate multiple commissioners in a district, in a voter registration precinct, what I would say. And in making changes there, we could address some of the ballot privacy issues that we still continue to hear about, because it would give us larger precincts.
Yeah, thank you. And thank you for addressing those questions. I really appreciate that. And then to you or any other panelist, we talked about the audits, right? And the randomly selected audits for after the fact. Is there any mechanism, kind of to Dean Zaffarini's point, where if there's a whistleblower who says, hey, I've seen a lot of discrepant activity in this particular county, where an audit can be directed to a county that, was being observed as not doing things properly?
Under current law, there is no other process for triggering some kind of county audit. Right now, if we randomly select your county, you can be audited. That being said, I think it's important to remember that all of our election records are public records, and we have a number of groups that are out there, a number of individuals and community groups that routinely request this data and routinely review this data on their own. And I think that idea of a citizen audit is a pretty important part of the process. We want transparency in the process itself. And some of those individuals reviewing those records have brought issues to the attention of our county election officials and to our office that once we know about, we can fix. I've yet to run into a county that has told me they refuse to fix something that has been brought to their attention. Most of our counties want to make things better and want to improve process and procedure. And so when the state comes to them saying, here's an issue we've identified, in most cases, they very willingly take efforts to try to remediate those issues.
Thank you. I want to be respectful of the committee's time, but if you would just briefly kind of go over what that audit entails. I know I had personal experience in my first run for office, and there were some issues that we've all noted here are under state law. And, some of those, I'm not going to name counties or anything like that, but one in particular, I believe, had an audit, yet, through my recount process of my first election, we found quite a few things that were highly suspect and discrepant in certain areas, including mail-in ballots. Mm-hmm. Could you just briefly describe what your audit process is and how, how would we be able to find those types of...
Sure. So the audit process is something that we have developed. Our audit of our different selected counties, we've developed over time. And Chad can probably speak to this a little bit as well, because he helped create this audit process that we have in the state. But it's a comprehensive audit. We look at voter registration records. We look at compliance with list maintenance. We do comparisons between the different data sources in elections, the data coming out of poll books, data coming out of voting machines, the vote totals, and how it aligns with voter registration data to look for consistencies or problems where we don't have an alignment of data. We look at chain of custody procedure. We will take a sampling of polling locations and recreate the election from a chain of custody standpoint. We look at policies and procedures. We look at security records. We look at training records. We try to take the most comprehensive view of specific elections, but also the organization of a given office. And so we will do a piecemeal approach for the election, and we do it for various elections because we audit multiple elections within a 2-year cycle. What we have found is that typically once we've done 1 or 2 big elections, we pretty much know what the issues are in a given county. But it's getting very granular with the data that they present to us and validating records, validating voter registration actions, and validating, to some extent, outcomes where we can.
And what is the enforcement mechanism for that? You mentioned something specific like chain of custody records. And again, just speaking out of personal experience, when we were running a recount, again, not naming any specific counties, but there was one where we requested the chain of custody records, and they were like, we don't have any. So now what?
Sure, that's an interesting. This is kind of the plight of the county election official in some ways. Counties can do all the training in the world, and they can provide all the documentation, but sometimes it's hard to get the workers to do the documentation. And we do think that that's a training component. That most of that can be addressed with good training and good procedures for our local election
what's
officials.
The enforcement aspect of it?
There really isn't one, sir. There really isn't. It's not a criminal offense to not complete your chain of custody paperwork. Not currently, anyway.
But yet it's a law.
Yes, sir, that's correct. And what I would say is, unfortunately, the time where we see these issues come up and where people pay attention to some of those problems that they may identify, because oftentimes it may be, one polling location where the workers are repeatedly making the same mistakes or repeatedly not following procedures. But because of the way the appointment process works with workers, county can't replace those workers.
And Mr. Chairman, I think that's the major flaw of what we're doing here. We're creating law. We have no enforcement mechanism in enforcing these laws. Thank you for your time. Sir, maybe.
Well, Senator Betancourt's enforcement bill would be a great help on that. But beside that, though, in the chain of custody in the law, it just names, these workers, this staff. I think if you went down to an individual person, like the head of the administrative election, the election judge at the location, and put them personally in responsibility, I think they would get it done if they knew that they were on the hook.
Yeah, I'd be happy to work with Chairman Betancourt, and you're welcome to visit my office too with any additional ideas you have. I appreciate that feedback.
Well, and speaking for county election officials, I know that we know we're on the hook if we're not following the processes. So I believe that every county election official wants to do the very best job they can there. And I think you have to take a lot of different things into account. What kind of election was it? Was this somebody that was appointed by the party? Because in my county, there would be a lot of ways that I would look at that if that was a problem and address that with the party, perhaps, if they were appointed or so on and so forth.
Yeah, I don't have too much to add to that. It's, the procedural audit aspect, Senator Parker's bill kind of, it dealt with the hand counting, auditing of the machines, making sure they're counting correctly. But this procedural audits we're talking about, I think it was really important for us when we started it out to really get down to base level and not take the report printed out at the end of the election as gospel, but get down and look, what happened at machine 1 in precinct 1? And if we add that to 2, 3, and 4, do we get what comes up for the precinct? And then do we go up another level and the numbers match? I hate to call it an accounting game, but done right, it's an accounting game because you really want to track ballots through the system. Well, people come in, they turn into ballots, and they come out as votes, right? And so you really want to track that whole system and make sure that those steps are being followed everywhere. And as you said, a problem is that a lot of these steps don't have any teeth behind them. Well, you're supposed to keep a seal log. What if you don't? Well, there's nothing. Nothing happens. But when, as Christina said, a lot of this data, a lot of our counties are doing a great job of putting out the seal logs and putting out all the documents and putting them online. Well, if someone goes and says, hey, where I voted, there were no seals on this machine ever, according to the paperwork, that's not good. And I think the counties that have been audited, I think, they get it in stark numbers where they need to fix. And whether it's a training issue or an encouragement issue, however you want to talk about it, I think a lot of those things get fixed. And that's why I think it's really important to do more of these. Because as Senator Betancourt said, I mean, if you're a small county into the system right now, you're probably more likely to get struck by lightning than get audited, because every 2 years out of 230 of the small counties, I'll take those odds. So, updating the frequency, putting some teeth behind it, giving Christina's team tools to say when they ask her something that they get it. Some type of I hate to say subpoena power, but something similar, right? Where if I'm after a record, I can ask for it and I get it. Those kinds of things would help a lot.
I'm all for training and encouragement. I think it's time we get some enforcement, right?
Right.
Thank you.
Thank you, Senator Hinojosa. Senator Hall, you're recognized.
Let me just follow up the point. The concern about no penalty. It's against the law, but there's no penalty. That's a major problem we have, because as soon as you start talking about penalties for things in elections, you start losing election workers. To figure, if I make a mistake, I'm going to go to jail. So I'm not going to show up to work, which makes it even more important that we carefully look at what we do in policy and procedure, where we minimize the opportunity for error and fraud, so that we don't have to worry about that. So that was one of the drivers behind getting rid of the gap between early voting and election day. We took out a plethora of opportunities for errors to be made and for fraud to take place in doing that. And that's what, as we go forward and looking at maybe what we're going to do is cleaning up the voter roll and bringing it in-house where we have much better control of it, we take out a lot of opportunity there. So the concern about not having penalties, because I don't, as much as I would like to do that, I recognize the real problem. We'll run off the workers real quick. So as you go forward, keep that in mind, and every time you can see something that's being done that says maybe we can eliminate that step, or we can do this instead, that makes it less chance that there be an error or fraud in there, as just a part of the basic process of making it simpler and more secure.
Senator Hall, thank you for bringing up that more criminal penalties really aren't fixing the issues. I do believe that the audits can be more robust in that they can have follow through. Right now we do the audits, we get reports, but I think Christina can probably describe it better, but there's really no mechanism for fixing the issues that the audits find. So maybe that's, instead of penalties, something we can do that actually will address the issue.
Right. If we use the audit as a part of the process to make sure we got it right, and then where we didn't, or where there's something in there, look at the next cycle in there. What do we do to fix it? What went wrong? And is it something we can change, do it differently, or get rid of it and do it altogether? So
I think you raise a good point on complexity. I think if you look back at our 2020 audit, you'll see the more complex the process, the more mistakes you make. And I know that sounds revolutionary, but it's common sense. You look at election day voting. You come in, you show an ID, you get your ballot, you put in the tabulator, you walk out. Not a lot of mistakes get made there. You start stretching it out for 14 days of early voting, things can get a little off. You talk about mail voting. And then you look at all the steps in mail voting and all the places that can have something go wrong, then you see a process that's bad. In provisional voting, you go a little even further because there's more decision-making in that, more people involved, and things get tough. So I think simplifying is a great goal.
Absolutely, but those things, provisional votings and the others, are smaller numbers in there. And if we look forward to making some other changes that we're looking at, but when we get to where we have a single in-person voting period, it's going to put us in a position of being able to have much tighter control over what happens. You run that zero tape on day one, and then when the polls close on election day, you immediately run a results tapes for the polling location, everything in there. And that gives you an anchor of what went into those machines right there before anybody gets a chance to take a memory out and take it someplace else to print it out or whatever it is. It's just push the button and get your printout right there, which is going to give us a much better, clean insight into what actually took place in the voting location, because we've got it boxed in from one end to the other in there. And then that tape witnessed, signed, and there becomes your anchor. And then you follow through with that so that when the county puts together the county's results, the judge from that polling location verifies that the county results are accurate for their polling location. And then when the state gets it and they put together the total results, before they publish that, they check back with the county and say, did we accurately put in what you think you sent to us? And the county then verifies it. So you have steps in there that are verified each step of the way, just to take care of the error or fraud in doing it. So I think we're on the path to doing that. It's just getting to that point where we have that single in-person voting period and then the other little changes to make that fit together. Yes, sir.
Thank you, Senator Hall. A couple more things, Ms. Atkins, and I think you and I think each of our panelists, and we're going to have a few more questions in a moment, but on this part of our discussion, we were talking about the list of maintenance and the frustrations, and we talked about some of the tools, and I'm going to ask a question I don't know the answer to. What happens about when the Secretary of State flags a concern? There's evidence this person on the X county voter rolls is not a citizen. You send that to the county doesn't adequately deal with it. You now, as of the last few years, since 2021, I guess, have the ability to withhold those funds. We heard more about those. Have you resorted to that? Have you been in a situation as the Secretary of State's office since that time withheld funds from a county because they were not doing their job, not following the law on maintenance of the list?
No, we have not withheld funds from any counties at this point. So what we have been able to do is we've been able to look at the data that's being sent to our counties, and for our counties that are part of our online counties, part of the team system, we can look to see if they've sent notices out. We can look to see what actions that county has taken. There are circumstances where they will review a match and say, no, I've got data in this, other data outside of the system that shows me we've already resolved the citizenship issue on this individual, for example. And they'll resolve the task, is what we call it. They'll resolve that issue. It may mean that they don't do anything, but they have reviewed it and taken action and looked at it. In some circumstances where we see that counties are maybe resolving a lot of tasks, but we're not seeing a lot of work going along with it, we'll contact the county and reach out to them to get more explanation as to what their process and procedure might be in that circumstance. And by and large, the times that we've had to do that, counties have good documentation, and they show us what actions they've taken, and they'll show us what determinations they've made, or they will provide proactively an explanation as to why they're pausing on acting on some data sets. For example, some of the citizenship data, we've had some counties that have told us that because of their ongoing research, they were waiting before they took action in some of these areas. A good example of that would be Harris County. Harris County, when we provided non-citizen data to them, they were already under the NVRA moratorium because they had a federal election for a congressional vacancy. So they have been keeping us in keeping in close contact with us about their efforts and their intention to act on this data at a later date. They've requested updated information from our office. So a county like that, they were legally prohibited from acting, but they have been keeping us informed and working with our office to ensure that we know what steps they're taking until such time that they can take additional actions. And so that's what we have found with a lot of those counties. I will say for our offline counties, I don't have that same level of insight. I don't know what actions they're taking. I don't know if they're sending notices out to voters. It's dependent on their communication with our office and how much information they provide us when we call and request that data. By and large, most of those counties have been very cooperative. Again, I'll use Harris as the example. I think they've been actually more communicative on some of these issues than some of our other offline counties, because I think there's a great deal of scrutiny on Harris County. But a lot of that is contingent on just what information they provide us. I don't always have insight into what they do.
Thank you. And so in those cases where your office sends the information to the county, is there a process for following up? If we don't hear from them within X days or weeks, there's a process for following up?
Yes, sir. So we'll monitor the tasks that they have.
For those who are within the team
For those who are within the system, we monitor that, and we can see what work they're doing. We have 25 people that support our team system. Every one of those individuals is assigned to select counties. They work with those counties, they know those counties, they know that county level data. And so they are astute at noticing patterns or noticing actions that their counties are taking. And then, of course, for those offline counties, we do, look to see if issues are ultimately being resolved, and we will contact them if we're not seeing movement in a certain area or if we're seeing no work being done, in a certain area. We do reach out to them proactively.
And so far, as a result of what you've just described to us, you've been able to resolve to your satisfaction every case?
Yes, sir. I would say so far when we contact a county and say, we're concerned because we're not seeing compliance with state law in this particular area, most counties very quickly work to resolve those issues or provide documentation showing us what they have done or have not done outside of the system. Especially our larger counties, I would say for those larger counties, those are the ones that are more quick to respond, because withholding Chapter 19 funds for them is a more significant issue because they have more funding available.
Right.
That ability to withhold Chapter 19 funds has been a huge or a great tool in our toolbox for ensuring compliance.
Senator Hughes.
Thank you.
One of the things that would help legislatively, y'all were talking about the fundings and everything, is to give teams the ability to bring in notices from offline counties. They need to have that in their structure and need the funding so that they could manage that, so she could see what offline counties are doing.
Makes sense to me, Ms. Atkins.
What I would say on that is that's less of a team limitation and more having to do with what the third-party vendors have and can. I mean, it's modifications to those systems to provide that data and to provide that level of detail. So it's not just about modifying team. Other vendors would have to make changes to their systems.
Are there statutory or SOS rules or other state regulations which put parameters on what the counties can do? Can they just say, I've got my own vendor and then that's it? Or do we put some requirements in place, some baseline for those who are without the team or not in the team system? They're their own vendor. Do we have any control over what services are offered?
No, sir.
We don't.
No, sir. No, the only
the Secretary of State does not.
The Secretary of State does not have any authority over those third-party vendors. We don't even review them for legal compliance. So I don't know the inner workings of that system. I don't know whether the systems are compliant with state law. I don't know what their security protocols are. The only thing that we have ever done is we make sure that the data transmission works, that they can send data to us, we can receive it, we can send data out to them, and that they can receive it, that file transmission. That's the only thing that we review. Because and the reason why is because we don't have statutory authority to do more, to create a more robust kind of certification program, if you will. And we don't have any enforcement authority over those third-party vendors. Those are local contracts.
Thank you. Senator Hall.
Just one last to follow up the comment, and all of what said Senator Perry, Senator Hinojosa, and all this discussion and the answers that you're given in there, we're trying to fix the unfixable here in this thing. If we can continue to mess with it, we have got to step up and move to a single integrated system that takes all of this stuff out of it, depending on people doing this and doing that and following this rule and this and that and multiple vendors and multiple levels and so on. The state's too big, it's too much, and it's too important that we get it right in the voter roll. That's an incredibly important task that we have. And I truly believe that the only solution, we talk about fixing what you're talking about, it's like patching something with clay. It's going to fall off of it. It's an unfixable system. So I think we got to recognize we've got to set some money aside and do this. It will save us money and the benefits to come from it in the long run, to have a single system. And when I say us, I mean the counties and the state together. The getting it together will cost money, right. But then we'll have something that is much more manageable, much more transparent in there. So I think that needs to be a fairly high priority to get our elections to where we need to have high confidence in them.
The concept of counties maintaining their own roles is something that Texas has had. We're all for local control until we're not. And this is a case where it's so important that it needs to be done right and done. I agree with you. I think you're right.
Well, it's like the other stuff. The world has changed.
That's right.
It has changed. It's different. And we have tools today that we didn't have when we said, we don't want that big mess up here. Let the counties handle it. We could pretend it wouldn't exist out there. But now that we have the tools that are out there, between what we know with AI and programming and data, and the ability to do that, this is a different world. Right. And it's right. Just like many of the other things we're going to have to make decisions on, is recognize that the Texas we're trying to keep glued together today is not the same Texas from 25 years ago.
That's right.
And it's the rest of the world.
That's right. I agree. Senator Hall, I think our discussion has prompted Ms. Dornoff to make a remark.
Yes.
Please go ahead. And remember, we're coming back, so we're wrapping this panel up. But go ahead, please.
Once again, play devil's advocate just at this single time, at this single moment where counties are having such problems with the team program and the things that are in place today. I just want to caution that, yes, if we could take care of some of the issues that we've heard today, if we could have a system that would put everybody in and could give accurate information that election officials could, because I would say right now, counties are probably pretty happy with the fact that they've been able to take their own data and correct some things that have happened currently.
No, thank you. We understand that it's always going to be a balance. We're going to have to strike, and we need your help as we do that. I've got one last question on this topic, and then after this, we're going to do just a slight rearrangement. We're going to bring in an extra chair, and we'll have another witness helping us on the next panel. And for the benefit of those paying attention, well, I'm sure you're all paying attention. For the benefit of those in the room and those watching, well, we do have another elections charge. We've covered a lot of it, and so the next one may not take this long. But I think we agree this is important stuff. We want to get it right. We don't want to cut it short. It's important to have these discussions. So, Ms. Atkins, a question I think I do know the answer to, but I want to make sure. Since 2021, with some major election overhaul work that was done in Senate Bill 1 and related legislation, my recollection is since that time, Texas has removed over 1 million names from our voter registration system for various reasons. Please verify that for me and break that down for us just in general, where those numbers come from. What is the total and what were the reasons they were taken off?
So that's correct, sir. Because of our robust list maintenance program, there's a number of different things that impact the removal of individuals from our voter rolls. We do have list maintenance programs related to non-citizens, to felons, for mental incapacity individuals, that fall under these categories, they are sent notices before any kind of removal action is taken and given an opportunity to respond. We also have a very robust program with respect to deceased voters. In Texas, if you pass away within the state of Texas, we typically get that data 4 or 5 times from 4 or 5 different sources. That is the only category of list maintenance in which, when there is a strong match, meaning we're matching with social security number, with driver's license, first name, last name, date of birth, a combination of those records, it might result in an automatic cancellation. When there's weak matches where we don't have all those data points, we do send those out to the county, but again, there's an investigation process. And then some of the bigger categories are related to individuals that move within Texas and even out of state, and what we call the address confirmation process. If individuals move, if we have reason to believe that they've moved, those individuals are placed on suspense for 2 federal elections, so they stay on the voter rolls for a while. If they come in person and vote, they can be removed from suspense and placed in that active status. But this is a process dictated in federal law that after so many elections, those individuals that have been on suspense, their registrations will be canceled. And that does account for a large number of cancellations within the system. We are about to place updated numbers on our website for our cancellation trend reports, and so those should be posted in the next day or so, where folks can go back and look at historical data over the last 6 months, actually even going back years, to see kind of what those trends have been month to month. But it's typically in that cancellation process, the suspense cancellation process for individuals that have been on suspense due to questions on residency. That's typically where the largest bulk of cancellations occur.
Thank you. Thank you very much. Members, no other questions on this topic, nor we're going to have another crack at our witnesses. We're going to ask our panelists to step back just for a moment so we can do a slight furniture rearrangement. You don't have to go anywhere. You probably shouldn't. You just really need to. And we're going to move on to our second charge, election related. And of course, that's efficiency. Security and efficiency aren't the same thing. They're related. Y'all step back just for a minute so we can get the other chair in and move that down. You don't have to go far. Well, individually, you bet. We're going to start without you, but you okay. Go ahead. That's okay. And so they're obviously related. They're not the same thing. Election can be honest and still have problems, still falter, still have long lines, confusion on where to vote, technology that doesn't work or work as it was represented. And, of course, those lead to concerns about whether we can trust the results. And that's a problem for everyone, regardless of where we are on the political spectrum. We have to have elections that are secure and that work. That's what it's about. And so we're going to look at the systems that counties rely on, where the state can bring more consistency, how polling places are designated, and challenges in this process. And so that's what this next related charge will be about. And so we'll call back Christina Adkins, Jennifer Doynoff, Ed Johnson when he gets back is fine, Honorable Chuck DeVore, and Chad Ennis. So you'll notice there's an extra seat there. And Assemblyman DeVore has a commitment off campus a little bit later, so we're going to let him go first. Welcome back. Introduce yourself. Give us your testimony.
Thank you, Mr. Chairman and members. My name is Chuck DeVore. I'm the Chief National Initiatives Officer at the Texas Public Policy Foundation. And my remarks are probably best understood through the lens of being broadly in support of last session's SB 1209 by Mr. Chairman, a bill to consolidate elections in Texas. I have 10 points to make. My understanding is that I have a paper that may have been passed out or is available. These 10 points are the highlights from a recent research paper that I completed at the foundation about a month ago. The first point about uniform election dates or consolidating elections is that they do result in higher voter turnout. There is some savings in election administration costs. There is decreased likelihood of special interests dominating a low turnout election. And there is reduced election worker burnout, which I heard mentioned once or twice previously in the prior panel. To give some historical context, prior to the 1890s, most local elections were held ad hoc. They began to be consolidated in off-year elections because the technology of the day, it was very difficult to deal with long ballots using the basic paper ballots, right? It was physically difficult. So about 110 years ago, you started to see local elections separated from federal and state elections. The other thought was that if you separate them, it would reduce the partisan inclinations at local office, which at the time were thought to be injurious. Today, as many as 60,000 of America's roughly 90,000 school board members are elected in elections with turnout of only 10 to 15%, and that applies to Texas as well. There is an incentive for local governments to essentially choose their voters by having elections at odd times with low turnouts. You end up with people voting in an election that have the greatest stakes in that local political jurisdiction, which kind of warps the preferences of the broader electorate. By consolidating or not consolidating elections, pardon me, studies have shown, these aren't my studies, but other studies that I looked into and thought that they had good methodology. But when you don't consolidate elections, there is a higher chance of passing tax increases. Again, going back to the theory of low turnout elections resulting in essentially choosing your voters. There's a significantly increased chance of candidates endorsed by the teachers' unions winning elections, and there is higher pay and benefits for public employees at the local level. That's what happens when you don't consolidate, and again, that's what the data shows nationally. Here in Texas, a good example of the massive difference in turnout, in the general election in 2024, you had 61.2% turnout. In two recent local election cycles, you had between 4.9% and 17.8% turnout, and that would have been for your local May election. To put that into comparison with the 2024 general election turnout, that's 1/12 to 1/6 of the turnout happening at the local level. Point 7 is the cost. Now, here's where things get a little challenging because there are wide ranges of estimates of what it costs to run an election. There's studies all over the place giving information looking at the hard costs. This would be, of course, for the printing of ballots and related documents, the salary of the poll workers and other temporary staff, the renting of polling places, and postage for informational materials and mail ballots. Of course, we don't do a lot of mail ballots here compared to other states like, let's say, California, where 75 to 85% of the ballots are going to be by mail. Here in Texas, other than the COVID year where it was around 10%, it's usually around 3 to 4%. But those are the main costs, and you note that not part of that list, of course, is election equipment, because election equipment is a capital cost, and it's going to be there no matter how many elections you have. But even so, the rough estimate based on the methodology that I looked at with multiple different studies is that by consolidating Texas elections, let's say just getting rid of the May and Saturday election, we could look at about a $29.5 million to $129 million savings, which would accrue to local government. So it is a wide range. I apologize to the committee that I couldn't find better data that would narrow it down. But of course, there will be some cost savings. We know that for sure. There is, of course, an issue or concern about what's called voter roll-off or drop-off or undervoting. I heard this mentioned in the prior panel. I went ahead and looked at some data from my old home county in California, where I used to live 15 years ago. They have consolidated elections there. There's, I think, 6 states that have required election consolidation. And so what was interesting with that is that in a recent election in Orange County, and again, this is to test the proposition of roll-off, in the city of Santa Ana, which is the biggest city in Orange County, the lowest ballot item was 26 items deep on the ballot. Okay, so you had to wade through 26 choices before you got to Proposition FF in the city of Santa Ana. And the roll-off was only 7%. So if you go back to the top of the ballot and all the way down to the bottom, you only lost 7%. Now, again, variable depending on the position you were looking at. The greatest roll-off was in my old area of Irvine. It was for the Irvine Ranch Water District, District 4. It was 8 positions down, and it had a roll-off of 13.4%. So to give you an example, though, to go back and then to compare it to Texas's recent Saturday and May turnout, right? Those 2 positions, the one that was 26 items deep, the overall turnout was 54.5% for that Proposition FF, even though it was 26 positions deep. That would be roughly like 10 times greater than some of the typically low turnout elections that you see in Texas for these Saturday and May elections where you have 5% of the people turning out. So 54.5%. For that Irvine Ranch Water District, where you had the biggest roll-off from the top, that was 8 positions down, they still had a turnout of 63.7%. Again, higher than Santa Ana because generally in Irvine people were more likely to vote than in Santa Ana. It's a area where you have a higher turnout typically. So then the last issue, many of you know Derek Ryan. He's a data analyst for elections. I've worked with him over the years, and I asked him a lot of questions about this issue. And there was a portion of our conversation that I recorded that I used with his permission in my report. Because I've heard concerns from members of the Texas legislature about, well, gee, if we consolidate elections, won't it potentially cause some sort of a partisan advantage for one party or the other in the general election? And this was the question I asked Derek Ryan. And I'm going to quote now, this is in my report, from Derek Ryan. This is a conversation that occurred on December 11th of last year. He said, quote, "I am all for moving May elections to November, not for any partisan gain, but because I think it's easier for voters, it's cheaper for taxpayers, and lastly, from a data collection standpoint, it would make my life easier professionally. I think, if anything, some of the data refutes the argument that conservatives want to move the election to get better results." Now, what he's referring to there is I specifically asked him, in certain jurisdictions in Texas where local elections were in fact consolidated, because we leave it up to localities in Texas so far to determine when they're going to have their elections. And I asked him, test for me the proposition, looking at the voter turnout from a partisan standpoint, do you see any particular partisan advantage with elections in November in those jurisdictions that have consolidated? And he looked at the data in Texas's largest counties, and his answer was no, it's a wash. You'll see that in some jurisdictions it seems like there's just a little bit of a boost for Democrat voters, and in other jurisdictions it seems like just a little bit of a boost for Republican. So overall, he thought it was a wash professionally. And so with that, members, that is a summary of the highlights of this 10-page report that I developed a few months ago. Happy to take any questions subject to the committee's interest, and I do apologize. I have an eye doctor appointment that I have to get off to in about 15 minutes. So,
thank you for your testimony. Thanks for being here, and we'll go while we're down here. Mr. Johnson, you want to go next on this one? Do you have opening remarks, or just here for questions on the next charge?
I'll just be here for questions on this. Let him get
Very
to my
good.
doctor.
All right, Mr. Ennis, you're recognized.
Yeah, just a few more things on consolidating elections. We've talked about it earlier, and Chuck's paper is fantastic. So if you really want the full primer on this, definitely read his paper. But I think another thing to note is that this is a growing trend.
Pull that a little closer, Chad.
This is a growing trend we're seeing across the country, consolidating elections. States are realizing that they're doing way too many. Just in 2026, this year, which this body wasn't even in session, 31 states introduced 74 bills on election day alignment, up from 7 and 10 in 2025. So you can see where it's getting a lot more attention. Since 2022, Arkansas, Louisiana, New York, and West Virginia have consolidated, and 3 more have empowered locals to do it as well. And even 2 more states, Indiana and Virginia, have launched feasibility studies on how they can do that in their election systems. So I think this puts Texas, as usual, as a leader in getting this done, and we should get it done in the next session.
Thanks, Mr. Ennis. So on the efficiency charge and what we haven't covered yet, Ms. Donoff, you're recognized. Go introduce yourself, give us your testimony.
Thank you. I'm Jennifer Doinoff. I'm the Hayes County Election Administrator and also the Legislative Chair for Texas Association of County Election Officials. And the 2 topics that I had to address in the efficiency charge were the implementation and things that we were meeting with Senator Hall's office for the implementation of Senate Bill 2753, and then also some issues and challenges we saw in this last primary election that we think we have some remedies that can help with efficiency moving forward. So on that, we'll talk about the primary election issue first, and just say when it comes to selecting polling locations and preparing for the primary, counties need to have the time that they need to prepare as much as possible. Currently, there's no deadline in the law for political parties and counties to contract to run an election, and that caused problems in this last primary in Dallas County and Williamson County, and even in Hayes County and some other counties where contracting went on for quite some time. We saw in those counties some what was defined as chaos in the primary election because the counties didn't have time to adequately prepare for the changes in the election process that were being requested. And so we feel like a deadline for these contracts would help that. And then we also think some other things that could help in a primary situation when one party wants to run an election one way and the other party wants to run their election another way is to have that freedom to do so, particularly when it comes to countywide polling. Right now, both parties have to agree to do that. And if we could find a way that we weren't restricting the other party to do that same thing, that might help eliminate some of that. And I know there's some concern that maybe that would cause more confusion, but I would say in some counties where they were consolidating precincts in one party and combining in another and then had different parties going to the same polling location, that caused what I believe probably may have been a little more confusion. So I think that probably wouldn't be the case if the other party could still hold their election in countywide polling, for instance, if they wanted to. That's the biggest thing, and we would like to continue to work with this committee on that, on some ideas of that, so that we can help maybe make sure that those instances don't happen again. And then on 2753, we've been working closely with Senator Hall's office on some things that we think can help make the implementation of that bill easier for us when we do decide to do that. I don't think we're there yet because I do think there's going to be some things that we need to address in the legislature, and we're working on some scheduling things, and we're working on some other processes that are still left over in the election code that we think can help make that process a lot easier. And I also think Christine is going to talk a little bit about that as well, the steering committee and some of the work that they're doing on that as well. And I'm going to cut this short because I know we've been here a long time and we've already talked about most of it.
Thanks, Ms. Dornoff. Ms. Atkins, welcome back. Introduce yourself. Give us your testimony on the efficiency.
Thank you, Mr. Chairman. My name is Christina Adkins. I'm the Director of Elections for the Texas Secretary of State's office. I will also try to keep my remarks brief and limited to 3 different things I'm going to bring up to ensure that we can move forward with some great questions and some discussion in these areas. The first thing that I wanted to mention, and this relates a little bit to what Ms. Doynoff was talking about with efficiencies in the primary election, but it's kind of a different perspective or a different angle. And this relates to the type of voting system and equipment that's being used in polling places today. And I say that it relates to the primary because this is where we saw this issue coming up the most and becoming or we're seeing a greater awareness of the type of equipment that's being used. There is a movement right now where folks are pushing their election offices and their counties to move to voter-marked ballots. These are ballots where the voter is using a pen or a pencil to mark the voter or mark their selection, and then that's being placed into a scanner, in contrast to the widely used ballot marking devices that have been in use all over the country and very prominently here in Texas. We have recently had a number of counties move to these voter-marked ballots, and the way they're able to do this in a large jurisdiction where you have lots of polling places and lots of precincts is to provide what we call a ballot-on-demand system. So it's a ballot printer, essentially, in a polling location that can print a custom ballot for that voter, so that they're not having to pre-print ballots ahead of time and keep track of the different ballot stock and run the risk of running out of ballots for their voters. And so these ballot-on-demand systems are gaining in popularity, and they're gaining in widespread use across Texas. We have a number of counties that have been using these for years. It was typically concentrated with one vendor who had a very easy-to-use solution in the polling location. Denton County and McLennan County are examples of counties that have been using these ballot-on-demand systems for a long time. We recently had 3 more counties move over to the ballot-on-demand system, and it was widely used in all 3 cases for the primary election, and this is where we saw a little bit more of a challenge. I think it's important to note that ballot-on-demand systems, many people assume they're part of a certified voting system, but they're not, because they are simply a printer that is printing up a ballot. Our federal law, our Election Assistance Commission, and the voluntary voting system guidelines that they promulgate, for which Texas adheres to, doesn't include ballot printers. It doesn't include these on-demand systems, so they're not tested and certified as part of the federal certification process. Sometimes they're brought in as a peripheral device for testing, but they are not part of that federal certification process. In Texas law, they're not part of the definition of a voting system, and so they can't be part of the state certification process. So we don't have a lot of regulatory authority over these ballot printers that are used in polling locations. And from what we were hearing from our counties that were out there, while we have had some of these systems demoed for us, because we don't have regulatory authority over these ballot printers, it's hard for us to provide guidance to the manufacturers on how their systems comply with state law. We can notify them about what we know about, but we can't thoroughly test them the way we do certified systems. And so if there's going to be a strong desire to move to this model within Texas, that may be something that we think about, is giving a little bit more regulatory authority to the state so that we can test them and certify them the way we do other types of polling place equipment. Though they may not be part of the counting and casting of ballots, it is printing up a ballot, and it is used in conjunction with the other equipment in the polling location. And being able to ensure legal compliance there, I think, would help from an efficiency standpoint, as one of the things that we heard from some of our counties utilizing this new technology is that it may not have been as efficient as they hoped it would be, and they did have some struggles in some of those locations with that transition. And so if we can help in that area, we want to be able to provide some additional guidance to vendors to ensure better compliance with the law. The other thing I would like to discuss from an efficiency standpoint is to speak a little bit more about what Ms. Doynoff mentioned, and that's Senate Bill 2753, which was Senator Hall's bill that creates or eliminates the gap between early voting and Election Day and creates a single unified early voting period. Our office was charged with implementing 2753 and making the determination on when the state is ready to begin this process. This is a new way of doing things, and there really aren't any other jurisdictions out there that do things exactly the way this bill is moving Texas, in the direction that for which it's moving Texas. Understanding that a new scheme, a new way of conducting voting is going to have its challenges, and also understanding that it's the county election officials that do the heavy lifting here. They're the ones that conduct the elections. They're the ones that do the work. They're the experts on the process and procedure related to administering an election. Our office convened a steering committee to assist us with making decisions about implementation and education on Senate Bill 2753. Our steering committee consists of county election officers. We have county judges on on the steering committee, and we also have some local representatives, because it's not just counties that are impacted by this, but our cities and schools and water districts will also have to make this change in the way they conduct their election. Steering committee has met several times over the fall. We've had several meetings here in the spring to discuss the best course for moving forward with this bill. It became very clear in our discussions that from an educational perspective, counties were struggling to wrap their heads around what this change would look like for their individual counties, because again, it is a new way of doing things. And so with the support of our steering committee, we, the Secretary of State's office, put together a workshop. And we have been workshopping Senate Bill 2753 with counties all across the state. To date, we have workshopped a total of 54 counties over the course of the spring. Some of these are one-on-one, us going to a county office, sitting down and working with them to go over their unique scenarios in their counties so that they can look at what this is going to do for their county from a resource and cost perspective and from a training and education perspective. We are also in the middle of doing regional trainings this summer. We have 15 regional trainings scheduled across the state, and this workshop for 2753 is a major component to this regional training. By the time we get to the end of July, we will have workshopped Senate Bill 2753 with about 3/4 of the state, if not more, where these are counties that we are working with one-on-one with our election trainers and our election attorneys, sitting down, educating them on the bill, and then filling out, we've created a workbook and a series of worksheets that help with cost calculations that they can use to help them make projections as to what they're going to need for the implementation of this bill. I will say, by and large, the participation has been wonderful from our counties. They are very eager to get into this process, to better understand how this is going to impact them. We're hearing various things from our counties on the impacts. Many of our smaller counties and smaller jurisdictions are telling us that with their projections, this change in law could result in a cost savings to them. If there are some additional tweaks or modifications made to the process itself to account for some of those increased costs that come from having your polling locations open later. We have some counties that are concerned from a cost perspective that there may be an increase in cost because of the length of the early voting period and the length of hours for which the polls have to be open, that without having that transition period between early voting and election day, there may be a fiscal impact to the county. I think the largest thing that we're hearing from our counties, though, is that they're at the end of their budget cycle right now. And implementation without some modifications, a few tweaks that I think we have discovered in the course of educating our counties on this bill would make the implementation much smoother, is going to be difficult for our counties to do in the short term. I will say, by and large, though, our counties are coming to the table prepared and ready to work through these issues, coming with productive suggestions, and they want to get this right. They want to make sure that when we change the scheme for how we're conducting in-person voting, that it's done as seamlessly as possible, and that it's done in a way that is accessible to voters and accessible to their community. And so we have had some feedback from the counties on some tweaks that we could make to the law that would make this a more seamless implementation. A couple of things, and I think Ms. Doynoff had mentioned some of these, and I'll elaborate just a little bit more. The scheme right now allows for very long hours, 12-hour days, and in some of our counties that may not be necessary to have that many hours of voting for small counties that don't have high populations and maybe don't have the resources to staff those polling locations. And so this was discussed earlier, but the idea of providing a little bit more flexibility under the law, maybe with some minimums and maximums, some thresholds for which counties can make some selections that are right to customize it for their county needs. Couple of other things that we're hearing about, the mandatory hours on the weekends, Saturday, Sunday, Monday, again, for particularly our smaller jurisdictions that don't have the kind of staffing that larger entities have. That's going to be challenging for them. And I think challenging for them more so in the short term, just because of where we are in the budget cycle. And so I know they have been visiting with Senator Senator Hall, and a lot of these issues have been communicated to the senator as well. And then two other areas where we've identified some potential tweaks that might make this process more seamless. Right now in Texas, we have a requirement for our early voting ballot boxes to have 2 locks on them. And this 2-lock requirement, transitioning from early voting to election day, so everything up until election day, is actually a little bit challenging because it's our law enforcement that typically holds that second key. And so being able to get out there to get those keys to those jurisdictions from law enforcement to be able to successfully transfer chain of custody in our larger jurisdictions is going to be very difficult to do in that short time frame. Some counties have proposed some solutions, perhaps changing who the custodian of that second key is to give authority for that to go back to the county office at some point so that the county can possess that key and get that back out to those jurisdictions, because you need to have both keys on election day to close out your polling location. And so it's a practical step. And so there are some discussions there, and the counties have come to the table with some great ideas on how to resolve that. And then finally, one of the issues that's been brought to our attention from the perspective of the county, but also our political parties, is the appointment of election workers. There are different appointment procedures for early voting versus election day. And since we're talking about a uniform early voting period, we may need to make some modifications in how we're appointing workers to make sure there's consistency across the county and how the workers are being assigned to locations and how the county is determining what party serves as the presiding judge, for example, in a given location, as the law for early voting and election day prescribe different procedures. And so our parties are also telling us that some small tweaks in these areas would make a more seamless transition into this new way of doing things. And I will say one other thing that we have mentioned already, but I do want to highlight is there has been a little bit of discussion on ballot privacy and ballot secrecy. One of the things that we have looked at and talked to our counties about is whether we believe that this combined early voting period will help improve ballot privacy. And by and large, our counties are telling us that by combining those buckets, early voting and election day, and grouping our voters together or reporting them as one number, can help eliminate some of the ballot privacy issues that we've seen. In that it doesn't allow for such small categories of voters. It's a bigger pool to aggregate. There are still a few little areas that we have to think about from a ballot privacy perspective. We still need to think about our provisional votes. Those voters are always going to be a smaller category, or precincts where we may only have 1 or 2 voters that vote, which goes back to one of the issues that we talked about, Senator Hinojosa, and the way we draw our precincts. There's some additional things that we can do there to help ballot privacy. And then, as Ms. Duenoff mentioned, fail-safe voting, where somebody moves within a county, they have to get a custom ballot. There are a few little things there that we need to think about addressing that, but by and large, this transition to the single voting period could have a positive impact on protecting ballot privacy.
Chairman, I didn't realize the ballot marking was on this session. Could I?
We did security, now we're doing efficiency, so there's going to be a lot of questions, but this is our last election panel. So if you need to say something now, or you can do it in response to a question.
Can I make just a quick comment on that issue?
Up to you.
So in the ballot marking devices or hand marked ballots, I think right now I'm with Ed Johnson with the Harris County Ballot Security. I think we have the best of both worlds. We have a official paper ballot that's coming out of a electronic marking device, that now you have 2 records. You have an electronic device and you have official paper ballot, which helps you in auditing elections come up to make sure that everything was correct. In Harris County, I don't believe that we could do the hand-marked paper ballots. That logistically becomes very, very difficult. So you have it's going to be 1.6, let's just go 1.5 million votes. And taking a ballot by mail, because that's what you're talking about, is basically producing a ballot by mail ballot for people to go hand mark. Right now in Harris County, with over 100 races, that's 4 tabloid pages that is sent to a voter. That's about the equivalent of at least 10 8.5 by 11 pages that would be printed. So now you're talking 15 million pieces of paper for an election. It gets to be very, very difficult to manage keeping all those pages together in someone's ballot to count and recount them or to scan them. Harris County had extreme difficulties when the verifiable paper trail first came out, the paper ballot, because it was on 2 pages. And there was a huge number of second pages that were lost and voters were disenfranchised. So we are, fearful of the hand-marked paper ballots being so large in large counties where you have a huge number of multiple pages of keeping them together. And then just the logistics, if you waited till election night to start processing these or to scan these, I estimated you would need 2,000 scanners with about 6,000 additional employees to get it done within a 24-hour period.
Well, if I could, Mr. Chairman.
Oh, actually, Senator Hall is
Okay.
is going to be
Okay,
is
sorry.
the first one up after this panel, and then we'll come to you next.
That's fine.
So in large counties, there are huge logistic problems with the hand-marked paper ballot. Once again, I go back, and now in our system, we have a paper ballot, and it is a summary that's shown to you. That's real easy to count and track, and it's on a single page, which makes logistics, a whole lot easier. The other thing is you will never be able to, I don't see that you would ever be able to get rid of the electronic marking device due to ADA requirements. We're required to have those to help blind people or people with disabilities. So you're always going to have that equipment in a polling location to assist the handicap. So I don't see us ever being able to get away from having that. And then you're set up with 2 different voting systems in a polling location, which get to be more complicated as you go. So in large counties, this would be a very difficult thing to do.
Okay.
And thank you, Senator Hall. You are recognized. You have the panel.
Oh, okay. Well, I'll back up a little bit here. So, do you not have the ballot marking devices where they do it electronically, then it prints out a piece of paper?
That's currently what the state law.
So what's the difference in the number of pieces of paper that printed out from the machine and those that are hand marked?
So a hand marked ballot would have to be, you would have to give the voter the whole ballot. What's currently coming out of the tabulator or the electronic marked is just a list of who you voted for. It does not have all the positions. It does not have all the other candidates on the ballot. So by the time you add the titles and the multiple candidates onto a page, plus space to mark them.
Okay, so we're back to putting convenience ahead of security in there, and that's one of the reasons we talked about flexibility, because I know we'll always have counties who don't want to do things. So they will take the approach. They refuse to try to figure out how to make it work. They want to not. So we're working on being flexible to allow some counties who just refuse to try to do things a better way to be able to do that. So I think we'll probably have that solution. Question I wanted to ask about the ballot secrecy issue, because I think would we all agree that ballot secrecy is more important than convenience in voting? That keeping the ballots secret, that we don't come up with a convenient solution. That is because a number of people have recommended, well, we just redact on the ballots. Redaction is not, to me, is not solving the secrecy problem, because somebody saw the ballot to be able to do that.
That's correct. I would say that ballot secrecy is paramount to the election process and to voter confidence in the process.
Yes, okay. And the issue about the printers, what certification process do we go through for the companies that print the ballots?
We don't have a formal certification. We have a notification process. They notify us that they are printing ballots for a given election, and it's only certain elections.
Okay, so we haven't lost anything there because we don't certify those printers.
That's correct.
They
Yes,
print them. So we got printers here that aren't certified. But I'm
correct.
And I'm not arguing maybe we should have in there, but some process. But I hope we wouldn't come up with something so complicated it kind of makes it difficult because our certification processes are difficult enough as it is.
Yes, sir.
But one of the other questions I had, I don't think we addressed, unless it was addressed while I was out for a moment or two, the issue of closed primaries. Have we discussed that? I would like to hear what your thoughts on it's been brought up, talked about. We're talking about, consolidating elections, and this is an issue that's been a lot of people are very passionate about over there. I'm almost as passionate as those that like hand counting. But I'd like to hear what each of you have to say about closed primaries. Christina, once you start it off.
Yes, Senator. So I had a conversation with Secretary Nelson because we anticipated this question and this topic coming up for discussion today in the hearing. And I want to make it very clear. Secretary Nelson has never taken a position for or against closed primaries. There is some pending litigation on this matter. And I think it's important to note that this litigation, the Secretary of State's office and Secretary Nelson, she's a constitutional officer. And she, as you all know, served in the Senate for many years and has been on that side, has done the legislative work, has been part of the folks that determine and set policy and set laws here within the state of Texas. And the litigation that's there is about the role of the Secretary of State's office and the role of the legislature. Should an executive branch agency be making policy and making rules that are typically under the purview of the legislature? When we talk about closing the primaries, people assume that it's a switch that you flip, that it's an easy thing to do, that all we have to do is make the decision to close them, or the parties tell us that they're closing their primary, and it's an easy thing to implement. And there are probably 10 or 12 different policy decisions that have to be made on how a primary is closed. For example, if one of our parties says they want to close the primary, does that close it for both parties? If we're being asked to capture affiliation in our state database, does this mean we capture affiliation for both primary holding parties? Do we capture affiliation for the parties that elect their nominees through the convention process? What about new parties? When does affiliation begin? What is the timeline for which somebody has to affiliate before they can participate in a closed primary? And these are very big policy decisions. And the litigation that's there is about who should be making those decisions. And I think Secretary Nelson, has never stated a position one way or another on the closed primary issue, but feels it's very important that her role is to defend the laws that the legislature has put into place.
And I understand that completely. And I'm not looking for a position. You guys are somewhat experts in the area of the election process. And my feeling here is we're here today to talk about the process, the procedures, the good points and the bad points without advocating.
Yes, sir.
I'm not asking for advocating, just raising the question, do you see a great big red flag on something that says this, it sounds really good, but when we get down to this, it's going to be almost impossible to do it? Or the other end, hey, that's going to solve a lot of problems and make it a lot easier. I'm just looking for general, from a procedure standpoint, things you feel good or bad against it. That's all.
Yes, sir. And I would say the list that I started to articulate of some of these big policy decisions, I think it depends on how the primary is closed. How those decisions are made and what the scheme is that's put into place will determine how easy it is to implement or not. I would also say, if there is an intention that registration, that affiliation be captured with registration and that the state maintain that listing of who is affiliated with what party, we have to understand that there's 3 state agencies that are going to be impacted by this. It's not just the Secretary of State's office, but the Department of Information Resources, who handles online updates to registrations. Their system would have to be modified, and the Department of Public Safety, DPS, because 85% of our registrations come to us from DPS. And so again, going back to whether it's complicated or easy to implement is going to depend on what those policy calls are, because there could be a fiscal impact to the state as multiple agencies would have to change the systems that are in place for registration to accommodate capturing affiliation in a state system.
Okay. Jennifer?
And just because we have to say it, we also would not take a position on this. We run elections.
No, I'm not looking for a position. I'm just, thoughts. I'm just looking,
Yeah.
do you see a big stumbling block, or do you say that it would fix something? Or what do you think would
So
be
I
the
don't
big
see
issues?
either. I
Because
don't-
the authority would come as legislation,
Mm-hmm.
and then we work our way down. So the legislature would have to take this move. I don't see it happening any other way. Some people obviously do think it can happen that way. I don't think it is. But say the legislature did, we're looking for what do we need to address so we get it right when we put it out there, if we do.
So from the perspective of an election official, I would say for us, it's not fixing anything. It's not also, it's also, we're used to laws changing and adapting and doing those things. I think the biggest thing that we have to keep in mind when it comes to these changes is educating our public and ensuring that the public understands the changes. And that sometimes sounds very easy, but sometimes it doesn't happen quickly. So I think for us, it would be educating the public of the changes.
Okay. Chad?
I mean, I think if the legislature, which I'm assuming you guys will consider this heavily next session, and I think they're spot on. There's so many issues to consider and to do in a thoughtful way. If you look at open or closed primaries just across the country, there's a lot of flavors of open and closed primaries. A closed primary can mean that you've had to have been registered in a certain party for a certain amount of time. Some closed primaries are you can come the day of and change your affiliation. So whatever policies y'all decide are important when you switch to that, if you do, they really need to be hashed out to give these folks the guidance so they can actually implement it. And I mean, there are just a lot of things to consider, especially things like how often or when. What's my time frame for changing my party affiliation? What if I decide I've changed teams and want to go to the other side? So I think there's a lot to work through. I fully have faith in this body to do it, but there's a lot to think about.
Oh, absolutely. That's why I asked the question. It's not so we get beyond it's a good idea or it's a bad idea. I'd rather have a logical argument one way or the other on it, on why it's a good idea. It has more good points than it has bad points, or oh my gosh, it's so bad, you can't say anything good about it in there. So we make an informed decision on it. I don't want to blow this off just based on this group's for it and this group's against it. I want to have a logical, foundation for it one way or the other. Ed?
Yes. So to me, it looks like the problem trying to fix going to a closed primary is the other party trying to manipulate one party's outcome in an election by switching parties that they typically would have voted for or are affiliated with. To have that effective, you're going to have the date that you commit to what party you are pretty far out, so that they can't make this last-minute decision to switch to try to monkey other parties. The downside I really see to this is then you're going to be the I guess middle ground group, the independent group that really is not that politically active. You will be cutting them out of the primary process. Which I think is probably more hurtful than the potential of a party trying to manipulate another party's race. Because we're trying, I hope the group here is trying to encourage people to vote and participate in the process.
Okay, thank you. Okay, thank you, Mr. Chairman.
And thank you, Senator Hall. Senator Betancourt, you're recognized.
Thank you, Mr. Chairman. And I want to make a point about scalability, because we'll talk about Harris County and we'll talk about Loving County, then we'll go to the state. I think one of the issues that we have to look at on any change is scalability, because we go from Loving County with, last time I checked, there were 64 residents, to Harris County having 4.5 million and 2.669 million people on the voter roll. or at least that's what last number. If I'm wrong, Christina, correct me. So I think that having a discussion about what can be done and what not done is also what needs to happen, Senator Hall, because I looked at Ed's, I just did the math here on your numbers that you're talking about. I remember that Briscoe cane runoff, and I remember that everybody stood by the 20 scanners and about 750 ballots could go through because it wasn't a full-blown situation where people were checkboxing, but there was still multiple pages. And I'm pretty sure that took most of the night to do 15,000 scans. So your upgrade to having 2,000 scanners is rational based upon the history. And we just need to understand that that's a rational thought of what it takes to do something like that. Now, and I want to tie that, so whenever we're looking at these type of changes, and I think, Senator Hall, you've talked about having some flexibility with different size counties, et cetera, but there are some fundamental physics that can't change, which is how long it takes to do scans, how fast it can be done, how many people it takes. You got to make sure you haven't mixed the ballots up. There's all sorts of things that go through this, because I remember that runoff was very contested. And again, back to the point I made earlier, Christine especially. So let's go from Loving County, Harris County, but let's look at the whole state now. So I missed a little bit of the discussion, even though Chuck DeVore handed me his papers on the way out, so I had a chance to read. When we're looking at all of this, we have to make sure we understand that as big as Texas is, if we have a vendor, which in this case, you've got one, this is like the third vendor for, this is, right. So Civics, or it could be IBM, it could be whatever, anybody, okay? They're going to have the resources to do all of that. So if we decide that we're going to make every county go on the line, okay, then we're going to have a resource capable, upsized vendor to be able to do it. Because no matter what happens is those support services, those questions, those comparing those lists, because to get to a voter roll with integrity, and you were right, because the SAVE Act, the American Help Program Act, says the state has the priority on the list and not the locals. But if we have locals that are having to do workarounds to get their list ready, then all that effort, regardless of who's wrong, who's right, up or down, in and out, somebody has to make it work at the end. And what gets measured gets fixed. And that's why I'm strongly suggesting, Christina, that whatever can be done with these software changes, and there has to be version control, they have to be showing that transparency, because the more we rely on one entity, in this case the state, to do it all, then we have to have an upsized, robust ability to be able to do it. And that's always the cycle in elections. Because I don't think there's anywhere else in the country that goes from 64 people to 4.5 million people to 31 million people. And we're supposed to have uniform election laws in the entire state of Texas. So I just wanted to make that point home, because scalability is real. It's a real problem.
Okay.
Thank you, Mr. Chairman.
Mr. Chair.
And thank you, Senator Betancourt. Senator Hall, you're recognized.
No, I appreciate that, because I think we agree all the way around on it. And in the past, and what I'm trying to do is trying to get a little bit of a sea change in the thinking process, that Texas is big and different. And because all of our laws always are like uniform all across the board, exactly the same everywhere. And I think it's not necessarily fair in this situation, that it is actually fair to everyone, where you have a set of laws that treats a Harris County the same as you treat a Loving County, and vice versa in there, because they truly are different. And then I think it's incumbent upon us to to recognize that we can better serve the people, having flexibility in what we say want done in order to meet the outcome, a common outcome, and that's an honest, accurate election. And so doing that, we may have steps that Harris County takes that are somewhat different than what Loving County would take, and maybe some of them in between, that gets us to that objective, because that's where it is. It's out there in that the accuracy and honesty of the end of the election is what we're after, and we have to maybe create a pathway for each county to adapt to get there a little bit different. So as we look at changes that are going to be made to adapt to the new system, it may include what we've talked about here today: uniform election dates, the possibility of closed primaries, just a possibility, but those kinds of things, and recognize the ballot secrecy, precinct voting, hand-marked paper ballots, machines, the combination of them to allow some flexibility that this part in between fits the bigger counties and smaller counties, so we get to that end objective across the board. Because if we don't, we're going to have something that matches over here for the big counties that doesn't work for the little counties, and vice versa. And I think we've changed it. So yes. I've said it a couple of times. I want to make sure it's kind of a different, to me, it's a different approach for the legislature that always looks at one size fits all, no matter what it is, period, bang, down the hammer goes. So thank you, Mr. Chairman.
Thank you, Senator Hall. Senator Bettencourt.
And I would just add, Senator Hall, that I think the one element that we're missing in all this discussion is when we're making these type of major election changes. I remember that we purposely ran in parallel for up to multiple years to make sure that we had a primary system and a backup system, because the problem is once you lose a voter registration roll or lose a tax roll, it's very difficult to recover it, okay? And the idea of having some of these programs piloted is really important into the field, because some of the technology we're discussing today doesn't even exist. Some of it does, okay? And we still have a paper ballot at the end of the day with the system we have right now. But then what do we do with it? Do we hand count it? Do we recount it? Do we automatically recount it? Do we pay for it? There's all these deals. But I think importantly, we should be looking at trying to do testing first on some scale before we launch. Because one of the problems, and Christine, I'm going to use the civic situation because I think it's perfect. You were ready to launch some of that. You had gotten the software to a point, and then we ran into unforeseen problems. People going bankrupt, and then trying to literally ask the state for tens of millions of dollars to stay in business. I see one person laughing. The person that got asked didn't laugh. Okay. Now, and that presupposes that the question was even valid. It wasn't, but you had to make tremendous accommodations and use the manpower and the resource that you had available in that vendor to solve that problem. And then redistricting came along. You had to use the same set of real. And now we're in catch-up mode in the summer. I'm not trying to be negative about it. It's just a fact, okay? So I just want to point out that whatever we do, we have to look at scalability, but we also should be looking at testing some of these systems. And we used to be very good at benchmark testing systems from all over the country. Now, I will leave you with this. ESS actually failed once or twice, if I remember correctly, because of, or companies like that failed because they weren't counting the votes correctly. And there was one classic example where a county judge saw the same ballot run through 3,000 times, right, Mr. Johnson?
That's correct.
And she wouldn't vote for it. And so, shock and horror for some of the Republicanos in the audience, that was Lena Hidalgo, because she didn't want to vote for a system that couldn't separate 3,000 ballots of the same thing. So we always have to be open to this and scalability. But the resources, Mr. Chairman, are almost now the critical path because of everything we're trying to do. This is an enormous project to bring everybody online to the right level that they want to be, much less add all the online counties. There is no state this big that's doing it, okay? And if anybody wants to claim California's done it, well, at least we can count votes in less than a week after the election.
Ms. Atkins, go ahead, please.
I would be remiss if I just didn't say one thing, Senator. It was Dominion voting that failed multiple exams, not ESNS.
And,
Right, sorry,
oh,
right.
no, thank you. And on Dominion voting,
But it
just,
was ENSS that, on the other example, that was actually true. Okay, so-
Correct.
there's been a lot of discussion about those Dominion voting machines and litigation. I think everybody here knows, but I want to ask you again, are Dominion voting machines certified for use in Texas by the Secretary of State?
No, sir, they are not. We do not have any Dominion equipment in the field in Texas, in any county or any local jurisdiction.
Thank you. I knew that, but I want to make sure we all heard that again. Thank you for that.
Good counselor always asks questions that he knows.
Hopefully, thank you, Mr. Chairman. And on those machines, thank you. Thank you for that. As we close this out and we think about the methods whereby we vote in Texas, many of us in the election integrity work are fairly new to the process. And electronic voting, voting machines, those terms all kind of have different uses. But let's talk about DREs, direct recording electronic voting machines. I hope the answer to this question I'm going to ask is no. But are any of our counties still using those machines? And for those listening, those of us who like paper, it hasn't been that long ago that most voters in Texas voted on voting machines, not what we have today. You voted in this electronic machine, and there was no paper record ever. It was all internal. And, of course, you talked about that transition, Mr. Johnston. We fought hard to get paper backup to move away from that. We did that with carrot and with stick. We told counties we'll pay for you to get better machines. We won't certify the old ones. And I don't know the answer to this one. I'm violating the rules Senator Betancourt just reminded me of. Do we have any counties in Texas that are still using those machines where it's all where you vote on that machine that records your vote and there's no paper? Is anybody still using those?
For this November election, all of our Texas counties will have moved away from DREs. They will all be on paper-based systems for their primary method of voting.
Okay.
There is a small carve-out in the law for people to use DREs for curbside voting.
Okay.
And there's only a couple of jurisdictions that do that.
Okay.
So by and large, we are no longer utilizing DREs in Texas as a primary way of voting.
Okay. After the hanging chads and the Florida stuff in 2004, some are old enough to remember that, the federal government in its infinite wisdom, and yes, I'm being sarcastic, they passed the Help America Vote Act, and they forced states to lurch over into that direct recording electronic voting machines, which nobody trusts. However, for those folks with special needs, curbside voting, things like that, there does have to be a special accommodation for them. It sounds like most of our counties have gone to a ballot marking device or something else, but you said in a few places we still have those DREs for those limited uses, folks with special needs who can't vote in the mainstream process. Is that right?
That's correct. Very, very limited, but by and large, all of our counties are utilizing paper-based systems.
Good. Thank you. Senator, go ahead.
You brought up one last. Okay, that being the case, on the ballots that are being printed out with the names on them, if you read, are all of the machines that are now going to read that ballot, are they optical character readers, which are actually reading the written, typed out name on the ballot, or are they reading a embedded code or QR code that tells them what that is?
Not all of our counties are utilizing a system that has that optical character recognition or reading the words.
Right.
We still have counties in Texas that utilize systems that have a barcode on there where the vote is embedded in the barcode. It has a printout with the name. The name is also there. And so in a hand count, it's the name that's counted. That's the ballot of record. But yes, there are still systems in Texas in use that have the barcode with the vote embedded on them.
Okay. And I suggest that's something we absolutely need to eliminate. You only catch it if there's a hand count, the accuracy. Thank you.
Senator Hall, that's right, and thank you for that. And you said we still have some, so we're moving toward the optical scanner that reads candidate X that the voter voted for. I'm hearing you correctly.
One of our vendors, we have two certified vendors in Texas. One of them exclusively uses some form of optical character recognition where it's reading the text. The other vendor that we have in Texas, those systems have been in place for over 10 years now with the barcodes. They are moving that direction as well. We have seen the new generation of system, or the next generation of voting devices, where they have moved away from the barcodes, and now it's reading the character on there. And so we are anxiously awaiting that process to complete the federal certification process, so we can review it for certification in Texas.
And that's good, because from a practical standpoint, there's no difference between that one that's reading the barcode and a DRE.
The only difference is, for a recount or an audit, we do have
For a
to take
recount, that's
record,
that's
so-
all there
yeah,
is, and that's
right.
only when it becomes effective.
That's
and
right.
you would never even look for it
Yeah.
unless you had some reason
That's right.
to do a hand count, to do a recount in there.
That's right. That's right.
What's that?
OCR is the right. Optical character recognition.
Oh, absolutely. No, that's if you've got to do that, if you just have to do that, then that's it has to be. But allowing it to be embedded in a barcode or QR code, we have got to eliminate that. Period.
Chairman.
Mr. Johnson, go ahead.
On the same subject, but a little change. One of the things that I hear all the time is when you have a race that's close and you want to do a recount. That recount is still being paid for by one of the candidates. The candidate that's wants the recount that's in second place closely. This gets to be extremely expensive to do. Especially after you've gone through a heavy campaign season and spend all your money doing campaign work. Now you got to pay for a whole staff to come in and count paper recounts. And it's to validate that the system is working correctly. I would love to see y'all look at possibly within certain limits funding some of these recounts so that people have more confidence. Because I know a lot of candidates that get close and they say, I don't have the money to do that. I can't do that recount. And it just goes away.
So that if a race is within whatever margin it might be within, if it's close, then the government, the taxpayers who put the system in place, would be responsible for the recount. It wouldn't be the burden of the losing candidate. Is that what you're talking about?
That's what I'm saying, yes.
Kind of like a verification vote in the House, Senator Perry. But those are within 6, I think. There is what's the law on that today, Ms. Atkins, please?
If there's a tie vote, there's an automatic recount.
Okay.
That's at no cost to
All
the
right.
candidates. But I think what Mr. Johnson's referring to is when we have a very, very small threshold separating those votes, that losing candidate still has to incur those costs. Unless, of course, it changes the outcome. And if the recount changes the outcome, then that losing candidate does not have to pay the cost. The county or the jurisdiction holding the election would pay the cost of the recount.
So then, as a practical matter, the losing candidate request the recount. Do they then have to pay something?
They have to pay a deposit.
They get their money back.
They would get their money back if the outcome changes.
Okay. Mr. Ennis.
I think one more thing that maybe this committee should look at in the next session is what Florida has started to do. So Florida has ballot marking devices, I believe, in counts, just like Texas does it. But they also have a second process where they have an independent machine count. There are certain companies that will come in and OCR the ballots and look at them that way with a fresh look. So it's not ES&S verifying ES&S or Hart verifying Hart. It's you do the count and then you come back and you run them through a second machine that's independent of the other. That's become really popular in Florida. They love it. It doesn't slow results down. It's something we should look at that they do.
Mr. Chairman.
Well, I think Senator Hinojosa had his light on, then I'll come back. Go ahead.
Thank you, Mr. Chairman. And thank you for bringing that up, Mr. Johnson. Actually, I went through all that and had to pay money on my first campaign for a very small margin. And the other issue I think that we need to look at with regard to recounts is when you go to recount, you certainly start to see discrepancies in things that could potentially impact the outcome of the election. But apparently, under our current law, you cannot contest the validity of the ballot if you see something discrepant. You can only recount, making sure that the count was accurate. So whether all you're doing is recounting incorrect ballots, again, so really there's very rare circumstances where a recount actually changes the outcome of a recount. Now, then it would have to go to a contested election. And there is no real framework. And a matter of fact, the amount of time to contest an election when you would have to gather the resources, try to build evidence, and do all those kinds of things really should be looked at as well on how contested elections work versus recounts. That is something I think that is worth looking into. So I appreciate you bringing that up, and I can provide a lot of information regarding that. Ma'am, just real quick, you had mentioned the one question that kind of was triggered when you talked about curbside voting. You said very, very few places still do that. How many exactly?
I should have numbers on that. I can look into back in the office so I can get you an answer, but I think that it's only maybe 3 or 4 counties that are.
Is one in my district, because I still see that happening. So I'm just wondering.
It's possible that one might be in your district, sir.
And
I'll
so-
double check that.
Hang on. If we can clarify,
Yeah.
curbside voting happens everywhere for folks who have special needs.
Yes, sir. That's
But
correct.
So that was
curbside
going to be
voting-
my follow-up question
But
here.
curbside voting using a DRE, is that the question?
Yes,
I'm
yes, sir.
sorry.
I'm
Go ahead.
sorry.
I was getting confused. Go ahead.
That's okay, and I appreciate you, Mr. Chairman, for clarifying. But I guess my other point to that is, what are the qualifications for somebody who's eligible for curbside voting, and how strictly enforced is that? Probably a better way to phrase that.
So curbside voting is something that must be available at every polling location across the state. What I was referring to with the question you asked before was the use of DREs for curbside voting. Very few counties do that. But curbside voting must be available at every polling location. The law says that people that are eligible to vote curbside are individuals that, I'm not going to quote it exactly right, but are unable to enter the polling place without the likelihood of injuring or impacting their health, or some kind of creating harm in some way to their health. And I'm paraphrasing there, just to warn you. And so when a person appears to curbside vote, the polling place workers go out to the polling location. Now, as a result of some recent changes in legislation in 2025, curbside voters have to sign an affidavit indicating that they meet those qualifications or are otherwise requesting some kind of accommodation to be able to curbside vote. But
Okay, that was my follow-up question. So it's basically an affidavit. They're just saying, hey, I can't, it'd be hard for me to come into. And I don't want to diminish that. There's obviously a good utilization to help people who are disabled or can't otherwise get into the voting center. But I have seen it in certain areas where there are longer lines in the curbside,
yes, sir.
as opposed to, actual walking into the center to do the vote. And I'm just wondering what the criteria or what enforcement mechanisms and checking. But at this point, it's simple.
It's an affidavit. It's an affidavit that the voter signs, and other than that, there's no other mechanism in place for validating whether somebody meets the definition required under the law. I think there's some ADA considerations with asking too many questions or putting conditions upon voters that need to curbside. But I will say there is that affidavit now, so there are records on the numbers of curbside voters that voted a given location and who those individuals are. I will also add that there was also another change in the law in recent years that requires if people are curbside voting and somebody's driving 7 or more curbside voters to a polling location, there's another form that individual has to complete as well. So we are tracking larger numbers like that, though I will say we have not had many of those forms filed with the state.
Okay, very good. Thank you.
And Senator, it's a tremendous point. Back in 2021, and going into the 2021 session, we heard a lot of sworn testimony about abuses. Somebody pulls up with a vehicle with a lot of people, says, hey, we need curbside voting, and then they just pass the machine around. No poll watchers, not sure if the folks are even voting their own ballots. So there were definitely abuses, and so we're always looking for those things. Boy, as you said, we want to help folks that need help, and of course everyone has the right to vote, and if they can't make it into the polling place, we're going to accommodate them, but we can do it and still make it secure and still protect their privacy and the security of their vote too. So thank you for flagging that, because it's been a real challenge, and as Ms. Adkins said, we've tweaked those laws the last few sessions, but whenever there are abuses, that needs to be addressed.
Thank you. Thank you, Mr. Chairman.
Senator Perry, you're
Mr.
right.
Chair, I'll be quick. First of all, if you're not careful, if you don't leave, the loser has to pay for the recount. You incentivize stall and dragging things out just for the sake of dragging things out with no intent of overturning the election. So I like the idea you got to pay for it if you ask for it, because I don't want to incentivize stalling out the election results for whatever reason those people may have, because there's no bottom to depravity of mankind. Second, closed polling, you know, I would like to think it's to the candidate, quality of the candidate that gets people to the polls. And to be perfectly frank, I can say that's been a challenge on both sides of the aisle. So I don't want to lock me out of being able to vote for the quality of a candidate. So I haven't switched my votes, but you know, my party tests my limits sometimes. So just saying, and as we continue on the path we're on, we're going to get it down to where if 5% is all that's showing up, it's just 1 million votes probably that you got to even manage. So it's going to make your job a lot easier. There's bigger issues here, is my point. And we got to be really careful to try to do something good that really just makes it that much more of a less important priority for people to want to get out and go vote. And I don't blame them, but I'm disappointed, and our republic depends on participation. And the smaller their participation, the more extreme the outcomes. And right now, the tail's wagging the dog. And both parties, all parties, and politicians alike, have a vested role in why that apathy exists. So if we really want real elections that produce really quality people that really have a servant's heart, we need to look inward before we have to worry about a system that catches the byproduct of that issue. So just saying, before I jump off here on cliffs trying to fix voter apathy, we need to look the reason we're having voter apathy to begin with. But as we tweak it, we may actually just create another demon to go slay.
Senator Perry, thank you. If there are no more questions, Senators, I thank Ms. Adkins, Ms. Dornoff again, Mr. Ennis, Mr. Johnson, Assemblyman DeVore, who's off campus. Thank you for your testimony. You are excused. We have one remaining charge we'll be taking up, and so as you're making your way from the room, please keep your voices down so that we can continue the proceedings. Our charge to protect the unborn. We're asked to study the threat of abortion-inducing drugs shipped unlawfully into Texas, monitor how the protections that were enacted last year are working, and recommend what more can be done. You'll recall the testimony before this committee in multiple hearings, and also the discussions, the debates on the Senate floor and also in the media. The abortion-inducing drugs, the abortion pill regimen, historically required multiple in-person doctor visits, required prescription by a physician, and the drugs had to be administered in the doctor's office. Now, even when all those conditions are met, it still resulted in the death of the little unborn baby. But in those cases, there were protections for the moms. Under current law, with changes made by multiple federal administrations, there are little to no protections. And so basically we see Big Pharma and others taking advantage of women in Texas, harming moms, harming babies, and need to be held accountable. That's what House Bill 7 was about, and that's what our charge is about, to see how that implementation is going and what else we can be doing going forward. Again, we recognize that there is a little unborn baby whose life needs to be protected, and there's a mom who needs to be loved and respected and protected, and we can do both. That's always our goal, to protect both of them, to love both of them, and so that's what our next panel will be about. And so Chair calls John Seago. We'll have two panels on this invited testimony, then we'll open up public testimony for all of the charges we've had today. So Dr. John Seago, Ashley Leonards, Chelsea Yeoman. And then we'll have one more panel after this. Y'all just have a seat wherever you like. Thank you. Dr. Seago, introduce yourself, give us your testimony.
Great. Thank you, Chairman Hughes, Members of the committee, thank you all for the invitation. My name is Dr. John Sego. I serve as the president for Texas Right to Life. Texas Right to Life is proud to partner with you senators